Okay, thank you. And then we have somebody approaching the bench or the podium. All right, good morning, sir. Can you tell me your name, please?
Luis Hernandez.
Your Honor, I'm sorry, just to make sure.
BRC 2.
BRC2, okay, thank you.
Thank you. All right, good morning. Are you there, did you connect in, Mr. Interpreter?
Yes, Your Honor.
Okay, all right, good morning. Can you tell me your name, please?
Luis Ángel Hernández Zamudio.
Luis Ángel Hernández Zamudio.
All right, so you're hearing case number 2017 CF 4521AO, and you are arrested pursuant to a warrant for a violation of probation, and the judge in the case did set your bond at none. Does he have, well, we'll appoint the public defender to represent you in the case. This is a 2018 warrant. So, Mr. Matos, you may want to email somebody, see if they can get a bond motion filed for him. He does have an immigration detainer. So I do have to advise you of the immigration detainer, Mr. Hernandez. And so you're being held at no bond, and then you also have the detainer. So you'll have to have that detainer lifted, and the public defender's office will file a bond motion. Either way, you'll see Judge Whitehead in a couple days for your arraignment. Okay? If you have any questions, you can call the public defender's office. They're going to give you a piece of paper with their phone number on it, okay?
Okay. Yo quería preguntarle que yo vengo de prisión, hice casi 2 años y quería ver si me podía correr el cargo concurrente.
So I just wanted to let you know that I just came from prison and served 2 years, so I wanted to see if charges could be run concurrently.
Well, you'll see Judge Whitehead in a couple days, and you can discuss that with Judge Whitehead. You may be able to resolve the case that day. But I can't do anything for you today, Mr. Hernandez, okay? So call the public defender, and then you'll also speak with Judge Whitehead in a couple days for that arraignment, all right?
All right.
Okay, thank you. Good luck, sir. All right, good morning, sir. Can you tell me your name, please?
Kelvin O. Hernández Vázquez.
Kelvin O. Hernandez Vasquez.
All right, Mr. Hernandez Vasquez, you're here in 2016 MM 3436AO, and this is a failure to appear capias for an arraignment on April 26, 2016. Or have you been in the Department of Corrections since then, or? No, since 2018 it looks like.
Estuve en county jail y después me mandaron para la prisión.
I was in county jail first, and then I was sent to prison.
Okay. How much longer do you have on your sentence?
La sentencia mía de prisión termina el jueves, este jueves, en 2 días.
Well, my prison sentence ends in 2 days.
2 days.
This Thursday.
Okay, yeah. Ms. Fusco, did you have an offer to resolve this? It's a petty theft, and he's just been in DOC since 2018.
I'm sorry, he wasn't on my move-up list. I'm trying to find him.
It's a misdemeanor pleable. It's 2016 MM 3436. So it looks like
I don't have the full set of records for him, Your Honor, so I wouldn't be able to make an offer today.
So it was a notice to appear. and he has 2 days in, and it was a notice to appear for a theft from J.C. Penney on March 26, 2016. There was a hat valued at $30. And the amount, I guess there was some other item and a shirt at $25. So the total recovered item, it says it was recovered, was $55. The state doesn't have an offer. Mr. Hernandez, if you wanted to resolve your case today, the state has already filed an information, so there would be no reason not to resolve the case today. And you were charged with petty theft with a prior theft conviction. So that's a misdemeanor of the first degree. And as I stated, it was alleged to have occurred at J.C. Penney on March 26, 2016. And it looks like the items were recovered. And so, did you want to resolve your case today, Mr. Vasquez? Or Hernandez Vasquez?
Sí.
Yes.
Yes, okay. So I want to explain to you, as you may understand already, that petty theft or any theft is an enhanceable offense. So, for instance, you're charged with petty theft with a prior theft conviction, meaning you already have a prior theft conviction. So now you'll assumably have two. The next time if you commit another theft, it could be charged as a felony. Do you understand that?
Okay. Sí, sí.
Yes.
Okay. And do you still want to go forward with any plea knowing that?
Una pregunta. Por ser un caso menor y yo tener 29 meses adentro, ¿me darían tiempo servido por eso?
Well, since it's a misdemeanor, and since I've already been in for some time, would I get time served?
Well, so you've been in for 2 days, only on this case. Nothing that you did in the Department of Corrections or anything before that. So you have credit for 2 days. I would adjudicate you guilty and give you the credit for the 2 days that you've served. I just need to make sure that you understand that if you get another theft, it could be charged as a felony.
Okay. Sí.
Yes.
Okay. And did we have a plea form for him over there that he might have been
Yes.
able to read? Okay. Did you read that plea form, Mr. Hernandez Vasquez? No, they're not, I mean, they're not even talking with him, so no way. Thank you.
Okay, ¿cuál sería?
Okay, did you understand everything on the plea form?
I didn't get time, no tengo tiempo
He
para
said
leerla
2 days
todo.
or 2 days credit.
Solamente me dio
Well-
un par de segundos.
Well, I haven't had time to read it all. I mean,
Okay,
I've just been
well,
only
why don't
given a
you-
couple of seconds.
Why don't you read it? I'll give you the time to read it.
Ok, la pregunta mía a ella es ¿cuál sería la sentencia para el caso ese?
Okay, but my question for you is, what would the sentence be in this case?
I told you that I would give you the credit for the time that you served, which was 2 days.
Ok, so eso sería tiempo servido.
So then we're talking about time served.
That is correct, yes.
Ok. So,
Why don't you read the plea form?
Ok. Sí. Dile que sí, que yo acepto eso.
They don't have it in Spanish?
He
You don't
has-
have a Spanish plea form over there?
He has one, but it's not printed directly from the JA or whoever prints them out. Because we don't print them
All
out
right,
anymore.
I'll take that offer.
Okay.
Next time.
Somebody needs to let us know so that we can get the plea forms to you, you know, so, because we can print one out.
He was added on, they may have one for him back there,
Okay.
however, we don't have one right now.
Is that a Spanish plea form that he
That's in
has?
Spanish that he
Yes,
has
Your Honor.
now. It's just not printed out, from
This one.
the clerk's office.
It's printed out from the
Okay.
clerk's office, Your
It's
Honor.
printed out
It is?
from,
Yes.
yes, it just don't have his type name and everything.
Oh, okay, well, that can easily be put in.
Okay, all
Okay,
right.
yeah. I just need to know that he can read the plea form
Yes,
itself.
he
Okay,
has something that he can read. That is
Okay.
a legal plea form.
okay.
Sí, señor.
All right. Were you able to read the plea form?
Sí, señor.
Yes, ma'am.
Okay, did you understand everything on the plea form?
Yes, ma'am. Sí, sí, señora, sí, señora.
Yes, ma'am.
Okay. And are you on probation anywhere? I know you're in Department of Corrections custody, but are you on probation?
No, no, señor. No, señor. No, señora.
No, ma'am.
All right. Do you understand that if you're not a U.S. citizen, the plea will subject you to deportation?
Sí, señora.
Yes, ma'am.
All right, I do find a factual basis based on the notice to appear in the court file. I'll adjudicate you guilty, sentence you to 2 days with credit for 2 days' time served. Order that you pay your court costs by July 14th, 2021. That gives you a year. If you'd like to appeal the judgment and sentence of the court, you must do so in writing within 30 days. If you cannot afford an attorney, one would be appointed for you, sir. Good luck, okay?
Sí, gracias. Hey, puedes decirle que tengo que esperar al jueves a que mi sentencia termine de la prisión para poder salir.
So, do I have to wait? I have to wait until Thursday for when my
Yeah,
prison
until
sentence ends
you're-
in order to get out?
Yeah, your sentence with DOC will have to be complete, but this case is over, so you will not be held on this case any longer, okay?
Ok, gracias.
Thank you.
Okay. What,
Felony domestic, Joshua, last name Alberdes. Second felony. And I'm calling.
what is it? ALBERD, Alberdeston
Yes.
Felicia, okay. We have one more Spanish interpreter case that was just added. Mr. Interpreter,
Yes, Your Honor.
okay. Well, it's a couple cases, but it's the same defendant. So he has 3 case numbers. I'll make sure to place them all on the record. All right, good morning, sir. Can you tell me your name, please?
Joshua Emanuel Alberdeston Pellicia. Joshua Emanuel Alberdeston Pellicia.
Joshua Manuel Alberdeston Beisier.
All right, sir, you're here in case number 2020 CF 8207AO. And in that case, you were arrested pursuant to a warrant in which probable cause was previously found for domestic battery by strangulation, tampering with a witness to hinder communication to law enforcement, and criminal mischief. And I am going to appoint the Public Defender's Office to represent you in that case. Do we have any witnesses present for the case? No? Okay. All right, sir, I am going to order that you have no contact directly or indirectly with the victim in that case. I'll have you sign the no contact order. Do we have one in Spanish for him over there?
It's coming over.
Okay, okay, it's coming over, okay. So we're gonna address that, I'll go back over that with him. I'm also ordering that you're not to return back to where the offense is alleged to have occurred. No weapons or firearms or any ammunition. Your bond on count 1 is $2,500. Count 2, I'm reducing to $150, and count 3 will be $100. You also have 2013 CF 7284AO, and that was a violation of probation warrant. And the bond in that case is set at none. I am going to appoint the public defender to represent you in that case as well. And you'll see Judge Whitehead in a couple days for your arraignment in that case. In the meantime, the Public Defender's Office can file any motions to set bond for you, but you will see Judge Whitehead in a couple days. Then the last case is 2013 CF 7284AO. It looks like it's the same case as the second case, but it's a failure to appear, so there's no bond in that case as well. So the bond will stay as none, as it's duplicative regardless. But you will see Judge Whitehead on that case, as I stated before.
On his first case, the 2020 CF 8207, were you doing the maintain separate residence?
I don't think that they have, I mean, we can add that, but he doesn't live there, so it's just no return to the scene.
And no weapons
And no weapons or firearms or any ammunition, no contact directly or indirectly with the victim. And will order maintain a separate residence as well. He does not live there. And it looks like you have an out-of-county hold for Polk County as well. I don't know what that's about. So, just says an open case out of Polk County. So, sir, do you have that no contact order in front of you in Spanish?
Yes.
Okay, did you understand everything on that form?
Yes.
Okay. If you have any questions about anything, you can contact the public defender's office, but you'll see Judge Whitehead on the violation of probation case in a couple days, okay, sir?
Muchas gracias.
All
Okay,
right. Thank you. And, Mr. Interpreter, we don't have a lot of people out in the gallery, but just in an abundance of caution, if you could just make an announcement, if anybody needs the interpreter, please raise their hand.
Yes, sir.
Thank you.
Este anuncio va dirigido a las personas en el auditorio. Si es que usted va a declarar y necesita un intérprete en español, levante la mano, por favor.
I don't see anybody raising their hands. So, thank you so much.
Yes, you're welcome.
Have
Your
a
Honor.
great
Thank you.
day. Okay,
You
thank
too.
you.
Small? Okay.
All right.
Michael Chalmers is medical, Your Honor.
Okay, I think this was reset from yesterday, based on, I guess Judge Cameron did not have the affidavit to the issue the warrant, so he didn't have any facts to support any conditions of release, despite the fact that probable cause had previously been found. Is that?
I did forward one report that I was able to get to your email.
I got the report already from OCSO, but thank you.
Oh, okay.
Yeah, we were able to get the report, or from OPD, I should say. So I have read that. Did he appoint? Yeah, the PD was appointed yesterday. So we're gonna address Mr. Chalmers' case. Looks like he's being held at no bond on the other case from yesterday. Is that correct?
Here.
He's only set for this one because Judge Cameron did not have the affidavit. Okay. All right, I have read the affidavit. The PD was previously appointed. It's 2020 CF 8426AO. He was charged by warrant with attempted burglary of an occupied dwelling and stalking. I believe it's the same victim in both cases. And so I am ordering no contact directly or indirectly with the victim, not to return to the victim's residence, no weapons or firearms or any ammunition. If he has any weapons or firearms, he's to surrender them to law enforcement within 6 hours of his release. And also no alcohol or drugs without a valid prescription. The bond on count 1 will be set at $5,000. Count 2 will be set at $1,000.
And Judge, are you waiving his opinion?
Yes. All right. Good morning, sir. Can you tell me your name, please?
Christopher Allen Heitzman.
All right, Mr. Heitzman, you're here in a couple of cases. 2020 CF 840780. You're charged with burglary of a conveyance and petty theft. And I do find probable cause, and I'll appoint the public defender in that case. 2020 CF 840680. It's a burglary of a conveyance and a petty theft. And I do find probable cause for those offenses, and I'll appoint the public defender. 2020 CF 841080. It's a burglary of a dwelling and a petty theft. And I find probable cause, and I'll appoint the public defender. 2020 CF 840280. It's 2 counts of attempted burglary of a conveyance and loitering or prowling, and I find probable cause, and I'll appoint the public defender. So in all of the cases, no contact with any victims or witnesses, no return to where the offenses are alleged to have occurred, and no drugs or alcohol without a valid prescription. The bonds will stay on 8407 at $3,500 and $100. On 8406 at $3,500 and $100, on 8410, $5,000 and $150, and 2020 CF 840280 at $1,000, $150, and $100. You're also out on release. That's a notice to appear. So I'm not taking any action on that based on the fact that he has not been seen by a judge, nor is he on any conditions of release in that case. Legally, I can't take any action.
Ma'am?
He has an arraignment set in that case coming up. Was that today?
That's today at 1
Okay. So, we could probably just do that arraignment.
Is it felony?
It's
a misdemeanor.
No, it's a misdemeanor. I mean, he's here, and we might as well do the arraignment to avoid. Is it 4590? So I'll let whoever, do we know who has arraignments in 4D today? Do we know?
Okay, so he's not starting a division yet, so we'll do it, so you want to do it like.
Yeah,
in jail?
I'll do the arraignment today, and I will let the judge know that he's not failing to appear, that he's in jail, and that I did the arraignment.
Okay, so we'll set him for TPC day?
Yeah,
Okay.
but let me do the arraignment. So, Mr. Heitzman, you're set for an arraignment today downtown, but because you're here, you're not gonna be downtown. So I'm gonna do the arraignment today, and then we'll give you a date, okay? And I'll appoint the public defender for you in this case as well, so you have representation.
Okay.
So it looks like you received a notice to appear on June 17th, 2020, and you were charged by a notice to appear with petty theft.
Yes, ma'am.
And so that was on June 13th, 2020. I don't know if the state will have an offer today.
No, Your Honor.
Okay, so there's not going to be an offer today, Mr. Heitzman, but I'm going to appoint the PD. We're going to enter a plea of not guilty for you, okay?
Okay.
And then we will give you a date, okay?
Okay. I
Okay.
got a question for you, ma'am.
Yes.
On my other accounts, is there any way possible that I can be released on ROR? Because I've got a terminally ill girlfriend at home with 3 kids, and I really need.
So, not today, Mr. Heitzman, but you do have the public defender. So you have a piece of paper in front of you. It has their phone number on it. You're gonna need to call them if you can't make the bonds. And they will file a motion to reduce the bonds, or in the alternative, release you on your own recognizance, okay?
Okay.
Judge, I have to give him dates.
And we're gonna give you some dates, okay, for the misdemeanor petty theft.
Division 85, pretrial conference, August 10th at 9 o'clock, courtroom 4A.
We don't happen to know who's in 4A today. Or D today at 1?
Judge Allen.
Alan? Okay, I'm gonna let her know.
And just let her know we gave
We,
him.
yeah, is there, do you know who I know the clerks are not in the courtrooms, right?
You can email.
Open, okay. Okay, all right. All right, I'm gonna let them know that you didn't fail to appear and that we gave you dates, okay?
Okay,
All right, good luck, sir.
thank you.
All right, solving problems. All right,
Tony Stanley is mental health, Your Honor.
okay. Looks like this is a failure to appear. Yesterday was a behavior issue, so now, mental health. So, does he have the PD?
That one was not appointed yesterday, he just reset.
No, it's a failure to appear. So I'm just wondering if he previously had the PD. I think he does because I'm looking at the court minutes. Yeah, and Mr. Spencer did file, Dan Spencer did file a motion to quash the KPS and set aside the bond. Doesn't look like that was actually heard because it was filed the 2nd of July. I don't know, that was just never put on the docket. So, Mr. Matos, did you want to waive his appearance? He has no bond at this time.
Yes, Your Honor.
Okay, so it's 2019 CF 653180, Tony America Stanley. He failed to appear for a status hearing on June 29, 2020. The judge did revoke the release and set the bond at none. And he does have the public defender. It does look like Mr. Spencer's been filing motions in the case. So, Mr. Matos, you may want to let Mr. Spencer know that he's in jail so that he can get that in front of Judge Roche immediately. There looks like there's competency issues. Okay. All right, good morning, ma'am. Can you tell me your name, please?
Marlene Adair.
All right, Miss Adair, you're here in 2020 CF 8460AO, and you were arrested for aggravated battery with a deadly weapon, domestic violence. I do find probable cause. I'll appoint the public defender. We do have a witness present. Can you raise your right hand to be sworn in?
I'm sorry, I can't hear you.
Can you raise your right hand to be
I'm
sworn
working
in?
on it.
All right, sir, can you, do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Ma'am, hold on, I'm taking some testimony, okay? Can't talk over each other, okay? All right, you can put your hand down now, sir. And you'll have to talk directly into the microphone, it's really hard to hear. Can you state your name and then spell your last name for me, please?
Ricky Adair, Adair.
All right, Mr. Adair, how do you know Marlene Adair?
Tomorrow's our 25th wedding anniversary.
Okay. And you live together?
Oh, yes, ma'am.
Okay. And are you afraid of Miss Adair?
No, ma'am.
Do you want to have contact with her through the pending
Oh,
of this case?
absolutely. I love her to death.
Do you think that drugs or alcohol had any involvement in what may have happened?
I was drinking yesterday. We got out of the pool and I started to make dinner, and now we're here. My wife needs serious medical attention is the main factor here. I've been begging her sister for years to help me get her to a doctor.
When you say medical, do you mean physical or mental?
I believe it's mental. there's no other explanation for this. We've been together almost 30 years and nothing like this. She's in severe need of medical help.
Okay. Well, I can't get her that help. You can talk to the state attorney's office and her attorney about that. So what we're gonna do today is, and you're telling me that you're not afraid of her, is that
Oh, no,
correct?
ma'am. I want her home with me.
Okay, okay. Miss Fusco, do you have any other questions for Mr. Adair?
Nothing further, Your Honor.
And Mr. Matos, any questions?
Nothing further, Your Honor.
Okay. All right. So, Mr. Adair, I'm going to allow you and your wife to have non-hostile, non-violent contact. Okay?
Okay.
So, Ms. Adair, do you understand that non-hostile contact and non-violent contact means you can't get in his face, you can't be disrespectful, you can't pull out any weapons, you can't hit him, punch him, scratch him, bite him. If you raise your voice or get angry, that's violating the non-hostile violent order, okay? Do you understand everything that I've just explained to you?
Yes.
Okay. So if things get heated and you get upset, you walk away.
Got it.
Okay?
Yes.
Take a breather, all right? Okay. So, I'm also ordering that you're not to possess any weapons, any firearms, or any ammunition. I am going to place you on pretrial release, so you'll be released today. You'll have to report by phone.
Okay.
And you do not want to miss any court dates if you have any upcoming court dates, okay?
Okay.
The state attorney's office should reach out to you, Mr. Adair, so you'll need to.
I can't hear you.
I said the state attorney's office will reach out to you about the case, so you'll need to discuss
Okay.
any things that
So
you
you're
want
going
to
to
see
let her come home
happen.
today?
Huh?
Is she getting to come home today?
She is. They're going to, process her through pretrial release and then release her. They have your phone number? They were able to contact you?
Yes.
Okay. So, if you can remember this phone number, 407-836-3400.
It's in my phone.
Perfect. So you can call them and they'll let you know when she's ready to get picked up, okay?
All righty.
Okay. All right, thank you.
Thank you.
All right, good morning. Tell me your name, please.
Good morning, ma'am. My name is Derek Reynolds.
All right, Mr. Reynolds, you're here in a couple cases. I've got 2020 CF 8189AO, and you were arrested pursuant to a warrant for aggravated stalking domestic violence. And probable cause was previously found based on the warrant. I'm going to appoint the public defender to represent you in that case. There's also 2020 MM 577AW. And that's also a warrant. Probable cause was found for violation of an injunction, stalking. And I'm going to appoint the public defender's office to represent you. It looks like the final injunction was entered yesterday
Yes, ma'am.
with Judge Ashton, and then this offense is alleged to have occurred after that. So, what I'm going to do we have any witnesses present for Mr. Reynolds? Nope. Okay. So, Mr. Reynolds, you have an injunction in place, and you're going to have to abide by that. But
Ye-
right now, I'm also going to have you sign the no contact order.
Yes, ma'am.
So it's no contact directly or indirectly with the victim or anyone in the victim's family.
Yes, ma'am.
Do you understand everything on that form?
Yes, ma'am. I completely understand. I just want a chance to
Okay.
get back to my job. I don't want to lose
Okay,
my
you're-
job.
Okay, you're not to return back to the victim's residence?
Yes, ma'am.
And no weapons or firearms or any ammunition, no drugs or alcohol without a valid prescription. And you're to surrender any firearms or any weapons within 6 hours of any release from the Orange County Jail.
Yes, ma'am.
All of these conditions are in both cases. And then there's also an injunction that you're going to have to abide by.
Yes,
And
ma'am.
if we could put this in the court minutes as well, it's 2020-DR-004787-0. And then it looks like you also have an out-of-county hold out of Broward County and Fort Lauderdale.
Yes, ma'am. That,
And that is set at no bond, and they are extraditing, so.
ma'am, that's a non-extraditable bond. I had missed court date on that bond when I was arrested.
I don't, I'm not a judge in Broward
Yes,
or Fort Lauderdale. Do we know, is there no bond on that?
It's non-extraditable, yes, ma'am. I missed court date for that because I was arrested.
Mr. Reynolds, I need you to be quiet for a second.
Yes,
okay?
ma'am.
Yeah. So you have no bond in that case, okay?
Yes, ma'am.
So you'll have to bond out of these cases, and then if I give you a bonds, in order to get brought back to Broward and Fort Lauderdale. So, based on my review of the cases, I've read the affidavits in both cases. And so I am going to find that there are no conditions of release which can reasonably assure the safety of the victim or community or the integrity of the judicial process based on the facts as alleged in the affidavit for arrest warrant in 2020 CF 8189AO, and then the injunction that was entered yesterday, and then now the violation of an injunction the same day that the injunction was entered into. And so I'm going to find that the no bond is appropriate.
Ma'am,
And I'm going to hold him at no bond on both cases.
ma'am, I just got that injunction yesterday. I didn't violate it.
I don't want you, Mr. Reynolds, you're being recorded, so everything that you say will and can be used against you.
Yes,
So
ma'am.
today is not the day to place any defenses on the record.
Yes, ma'am, I
So that
understand.
box should be checked. Okay. All right, so you do have the public defender, Mr. Reynolds, excuse me. They're going to have to file bond motions for you, but based on my findings today, you'll be held at no bond on these cases.
Ma'am, how long will I be held with no bond? I don't want to lose my
Until
job.
you get a bond. Either way, you have no bond in the other case from Broward County, okay?
Ma'am, that bond is non-extraditable, ma'am. I had missed court date because I was arrested for that bond.
Okay, well, they're saying it is extraditable, and if you have questions about that, you can contact the public defender's office, okay?
Okay.
Thank you, Mr. Reynolds.
So I don't have no bond, ma'am?
Same conditions on both cases. All right, good morning. Tell me your name, please.
Precious Santiago.
All right, Ms. Santiago, you're here in 2020 CF 7227AO. You're arrested pursuant to a warrant in which probable cause was found for aggravated assault with a deadly weapon, domestic violence, 2 counts of that. And I am going to appoint the public defender's office to represent you. Do we have any witnesses present for Ms. Santiago? We do not. Ms. Santiago, I am going to order that you have no contact with either victim directly or indirectly. I'll have you sign the no contact order, please. That could be changed into writing at a later date by the judge, okay? So your attorneys will have to file a motion. You're also to maintain a separate residence. Do you have any items at the residence?
No.
Okay.
I got just my own apartment just now for me and my kids. So now I don't live there anymore, and
Okay.
yeah.
So I'm also going to order that you're not to return to that location. And that, like I said, that can all be changed in writing by a judge at a later date if the victims are, or the judge orders that, okay?
My
So
mom
no weapons,
my kid.
no
but,
wep-
okay. I'll just get like a
You'll have to,
babysitter.
if you have legal questions about anything related to the no contact, you're gonna have to contact the public defender. I can't give you legal advice, okay?
Okay.
You can't go over there. I'm not ordering that your child cannot, so, okay?
All right.
You're not to possess any weapons or firearms or any ammunition. She does not qualify for pretrial release.
Well, we wouldn't qualify her because it was a warrant, but you can qualify.
You can qualify her, you think? Or you want me to qualify her?
Yeah,
Okay.
we don't usually qualify warrant,
Right, we were starting to do that before COVID, and then it kind of stopped, so.
but she can qualify.
Okay, so I'm thinking that you may qualify for pretrial release, so what I'll do is I'll set the bond on each count at 1,000 or PTR.
Do you know what that is? I'm sorry.
So pretrial release is it's a form of release which you'll have to check in, and I think it's via phone right now. So you'll have to check in with the pretrial release officer, and they'll make sure that you know of any court dates and that you don't get arrested for anything. If you do, then you could, your release could be revoked regardless of whether you're out on bond, but you won't have to post a bond, okay?
So basically, when I get out or something, I have to go to a pretrial release officer.
Well, they'll go through everything. If you qualify, they'll go through everything with you, and they'll tell you exactly what you need to do, okay?
Okay.
If you don't want to do pretrial release, you'll have to post the bond.
So I'm kind of like more understanding.
Okay. So what don't you understand?
So basically, like if I get out, like I'm trying to like get where you're
Okay.
coming
So
from.
you've been charged with 2 offenses.
Okay.
Aggravated assault with a domestic violence, okay? I'm ordering you into pretrial release if you qualify. I don't know, they haven't interviewed you yet, so
Okay.
they may find that you qualify, they may find that you don't qualify. If you don't qualify, you'll have to post the bond. If you don't want to do pretrial release and you want to post the bond, you can post the bond. If you want to do pretrial release, they'll explain everything to you, and you'll be released without having to pay a bond.
Okay.
Okay?
Yes, ma'am.
All right, thank you.
So I do have a bond. Or
All right, please tell me your name.
My name is Derringer Treadwell.
All right, Mr. Treadwell, you're here in 2020 CF 8421AO. You're arrested for aggravated battery on a pregnant person. I do find probable cause, and I'll appoint the public defender. Do we have any witnesses here for Mr. Treadwell? No, I see no one. Mr. Treadwell, I am ordering that you have no contact directly or indirectly with the victim or any witnesses in the case. I'll have you sign the no contact order, please. And did you understand everything on the no contact order?
Yes, ma'am.
All right, you're also to maintain a separate residence if you need to return to the residence to get any personal belongings. You may do so one time with law enforcement. You're not to possess weapons or firearms or any ammunition. I am going to release you on pretrial release. Make sure you comply with their requirements as well as my orders.
Yes, ma'am. Thank you, Your Honor.
All right, good morning. Tell me your name, please.
Brianna Moss.
Okay, and then, all right. Ms. Moss, you're here in 2020 MM51018O. It's a domestic violence battery. I do find probable cause, and I'll appoint the public defender. I don't believe we have any witnesses for Ms. Moss, so I am going to order that you have no contact directly or indirectly with the victim. I'll have you sign the no contact order. Did you understand everything on that order?
Yes, ma'am.
Okay. And you're to maintain a separate residence. If you need to return back with law enforcement to get any personal belongings, you can go one time with law enforcement. No drugs or alcohol without a valid prescription, no weapons, no firearms, and no ammunition. And She does not, she was not interviewed? She qualifies? Okay, do I need to do a bond or PTR?
Yeah, do a bond or.
Okay, so what I'll do, Ms. Moss, I think you're gonna qualify for pretrial release. I'm gonna do pretrial release if she qualifies, or a $500 bond. Did you understand everything that I told you?
Kind of. I don't really know what pre-child release or the
Okay,
bond.
they'll explain that to you. You won't have to post a bond. If you qualify through pretrial release, you'll have to phone in, contact with an individual who works for pretrial release. But it's a phone in, but you will not have to post a bond if you go through pretrial release, okay?
Okay, all right.
And I want to add one more, I'm sorry, hold on, Ms. Moss. Looks like DCF was contacted. They may have an investigation, I don't know. If they do, you must comply with that investigation, so we'll put that in the court minutes as well. All right, good luck, ma'am.
Okay.
Good morning. Can you tell me your name, please?
Maria Rios.
All right, Ms. Rios, you're here in 2020 MM 5097AO. You're arrested for domestic violence battery. I do find probable cause for that offense, and I'll appoint the public defender. Do we have any witnesses for Ms. Rios? I don't see. Is there anybody out there? No? Okay. Sometimes I can't see if people are back there. All right, so Ms. Rios, I am going to order that you have no contact directly or indirectly with the alleged victim in the case. I'll have you sign the no contact order. Did you understand everything on the no contact order?
Yes, ma'am.
Okay. So I'm also ordering that you're to maintain a separate residence. Are you all living together?
No, ma'am.
Or you're not?
No.
Okay. And so the Avlee, that street, is that where you're staying or is that where he's staying?
That's my home address, ma'am.
Okay, and so he's staying somewhere else?
Staying in Melbourne.
Okay, and I do have a note on the pretrial release sheet showing that. So I'm only ordering that you maintain separate residence. So if for some reason he is at the residence, you can't be there, okay? But he's indicated to pretrial release that he's going to Melbourne. Okay.
Yes, ma'am.
All right, so you can go there. If for some reason, I'm just going to put it in abundance of caution in case he is at the residence, that if you need to go back, you can go with law enforcement, okay? But that's just in an abundance of caution if he's there. You're not to possess weapons or firearms or any ammunition. And I am going to release you to pretrial release. Make sure you comply with their requirements, okay? And mine.
Yes, ma'am.
All right, good luck.
Thank you.
All right, please tell me your name.
Melvin Roll, Jr.
I'm sorry, can you say that again?
Melvin Roll, Jr.
Okay, thank you, Mr. Roll. You're here in 20 MM 5106AO, and you were arrested for a violation of pretrial release condition on a domestic violence case.
Yes, ma'am.
And I do find probable cause for that offense. And I will appoint the public defender's office to represent you in the case.
Okay.
And do we have any witnesses present? No. Okay. So, Mr. Roll, I am going to have you sign the no contact order. There's already a no contact order in place.
Okay.
In the case that you're out on release on, I'm going to
Yes.
have you sign it again.
Okay. Can I say something, please?
I don't want you to say anything about the facts of your case.
Oh,
You may
yeah.
have a defense, and that's great.
Yeah.
But today is not the day to talk about that. Everything that you're saying can be used against you, Mr. Roll. So I know
Okay.
you want to say your side,
Okay.
but today is not the day to do that until you get to speak
Understandable.
with your attorney. So they're going to give you a piece of paper there. You call that number, you tell them everything that you want to tell me right now, but
Okay.
I don't think that you should tell me anything, okay?
Okay.
Okay, so did you understand everything on the no contact order?
Yes. Now I do.
Okay. You're not to return back to that residence. You're not to possess weapons or firearms or any ammunition.
Yeah.
Your bond is set at $1,500. I am going to revoke the release in 2020 MM 1171AO and set that bond at none at this time. Does he have the public defender? I'm not showing anything on the form here. Okay. So the PD was previously appointed in your case. They're going to have to file a motion to set bond for you.
So I have no bond?
Well, you have a bond in the new case. You do not have a bond in the old case. So you call that phone number, they'll tell you the best thing for you to do, and they will file a bond motion for you.
I'm out on
All right,
bond.
Mr. Rawl, good luck, sir. All right, good morning. Can you tell me your name?
My name is Jeremy Johnson, Jeremy Dwight Johnson now.
Do we know what happened to James Ross?
East Hospital, Your Honor.
Hospital?
Yes, Your Honor.
Okay, we'll reset within 24 hours of release from the hospital. And there's no victim present today to take testimony. All right, Mr. Johnson,
Yes, ma'am.
you're here in 2020 CT 4341, driving while license revoked as a subsequent offender. And I do find probable cause, and I'll appoint the public defender in 2020 MM 5100AO to resisting an officer without violence. And I find probable cause, and I'll appoint the public defender in 20 CT 4341, no driving without a valid driver's license. The bond will stay at 500. In the other case, the bond will stay at 500, no conditions in that case.
Can I say
You're out
something?
on
Can
release.
I say something ma'am, before you?
Okay. Mr. Johnson, I don't know what you want to say, so
It's not-
hold
it's
on.
not-
Let me
it's
just
not-
give,
It's not
Okay.
pertaining to the case.
okay, people say that all the time, and then they start talking about the facts. So I'm just going to give you my advice, which is everything that you say can and probably will be used against you. You're being recorded, so anything, I just want to make sure that you understand I'm trying to protect you.
I understand, ma'am.
Okay, so what do you want to tell me, and knowing that anything that you say could be used against you?
Yeah, it's not about anything against my case. I just wanted to say that my mom, she's in the hospital fighting for her life. And I'm the only one that she put me down as the one that can determine what goes on with her. And I just want you to give me a chance to get out and make sure she's all right.
What hospital is she at?
She's at the Sanford Hospital, ma'am.
Okay, what's going on with her?
She had caught the coronavirus. She on life support. Her kidneys
Sorry to
failed.
hear that.
And she's like
I'm sorry to hear that.
going through dialysis.
All right, Mr. Johnson, my inclination is here, you're out on bond on 2 cases, and one of which is fleeing and attempting to elude and driving without a valid driver's license. Now you're gonna have 4 cases, okay?
I'm okay.
I'm just letting you know that if you come back and you have 4 cases out on release and you pick up another one, I don't know if it's just for an open container violation. Chances are your release is gonna be revoked. You got me?
Yes, ma'am.
Okay. So you go to the hospital and you go home and you don't drive. You got me?
Yes, ma'am. I'm not going to drive, ma'am.
Okay. So no driving without a valid driver's license. I'm not taking any action on the out on release case. Does he have the PD in both of those cases?
I have a lawyer on the case that the fleeing, but I don't have one on the previous.
4053 and 4069, he does not have that.
Okay, so I'm going to appoint the public defender in 2020 CF 4069 AO. So now you have an attorney on both cases,
Yes,
all
ma'am.
right? Just remember what I told you.
Yes, ma'am. I'm gonna remember.
And I'm going to add no drugs or alcohol as well without a valid prescription. So no driving, no drugs, no alcohol. I hope your mother gets better.
Thank you, ma'am.
Good luck.
morning.
All right, tell me your name.
Jordan Marr.
All right, Mr. Marr, you're here in 2020 CT 557 and 2020 CT 558, and you were arrested for driving under the influence and then a driving while license revoked as a subsequent offender. And I do find probable cause for those offenses, and I will appoint the public defender to represent you. So no drugs or alcohol without a valid prescription. I'm gonna stay the bond at 500 and 100. It looks like you have an out on release case. It was a pretrial diversion reject. I guess you got rejected from pretrial diversion way back when, 2013. Then there was a capias issued, and then that was unexecuted because based on the race, I guess it was incorrect. So there is a capias outstanding, I think, and it has a $500 bond, but I don't know if he'll be arrested on it. Nobody ever responded to the clerk's correspondence to the judge in that case when I looked it up. So I'm not taking any action on it. Mr. Marr, let's see, I just want to make sure that he doesn't get served with the capias before he gets released. So I'm just showing that back in 2013, on July 15th, the clerk's office sent a letter to Judge Craner saying that he ordered a capias on June 3rd, 2013. They issued the capias on June 6th, and then they received the capias back as unexecuted with the explanation of the incorrect race. So all of the documents they have in the court file is showing that the individual was white, and it appears as though Mr. Marr is African American. So I think the race was incorrect. I don't know if they're gonna withdraw that capias or if they would execute it with a wrong race. Okay, it's 2012 MM325 AA. But that's the last thing that happened in that case. I don't know. All I'm showing is that there was a capias returned unexecuted because of the wrong race. It was a status hearing that he failed to appear for when he was rejected from pretrial diversion. So I just don't want him to get arrested. I don't want them to serve him with a capias. It says Adam McGinnis. It's a possession of cannabis. My guess is that they wouldn't even be prosecuting it anymore, but I just don't want you to bond out and then they arrest you on it,
Understood.
So chances are the case is going to get dismissed anyway. Okay. Well, as long as there's no active warrant, looks like, Mr. Marr, I would talk to the public defender about this case, okay?
Okay.
You don't have an attorney on it. I'm going to appoint them on it so that they can look into it and then make sure that at some point you don't get arrested on it just randomly because they arrest you. So I'm going to appoint the PD in 2012 MM325AA. Mr. Matos, you may want to make a note that there's an unexecuted capias and it's so that somebody in your office can look into it for him. Okay?
Yes, ma'am.
All right, that's about all I can do for you, Mr. Marr, on that one. So hopefully they don't arrest you on it, okay? All right, good luck.
Thank you.
Yeah. trial, diversion, rejection, and then a status hearing that he failed to appear for, and then it looks like.
Okay, we'll find out.
It may very well be that they don't ever execute it and it just sits there and languishes forever. Yeah. And then let just Judge McGinnis know, I guess, too. All right, good morning. Can you tell me your name?
Kevin Strong.
Can you hear me?
Yes, Kevin Strong.
All right, Mr. Strong, you're here in 2020 MM 3162. It's an arraignment, and the Public Defender's Office was previously appointed in your case. And you were charged by information with petty theft with a prior theft conviction and providing false identification to law enforcement. Those are both misdemeanors of the first degree alleged to have occurred on or about the 30th day of April 2020. Mr. Strong, are you on probation?
With Seminole County, yes.
Okay, all right. And have you talked to any attorney about this case yet?
Not about the Orange County case, no.
Okay, so you nobody's come and talked to you through Polycom or anything about this case from the public defender?
I didn't know that files were, or they were filing charges on me through this case until this morning. As far as I knew, it had not been filed on.
When were you placed on probation in Seminole?
Last September.
Okay, so this offense was alleged to have occurred in May, all right? So today, we're not gonna resolve your case today because I don't wanna mess up anything for you in the Seminole case. I don't know what's going on with your any violation of probation. So, Mr. Matos, did you wanna enter a plea of not guilty for Mr. Strong?
Yes, Your Honor.
Okay, so we're gonna enter a plea of not guilty. We're gonna give you a date.
All right.
Do we have a phone? Can he call? Do we have a piece of paper for the public defender so that he can call them? Because they may be able to get something worked out.
Yes, Your Honor.
He's got 76 days in on this case.
Yes, ma'am.
Yeah. So I just don't want to mess with your probation, okay?
All right.
So if somebody could give him a piece of paper over there with the PD's number on it, that would be fantastic. And you can call them and let them know the state filed the information. And if you want to try to resolve it, they may be able to get with Seminole and figure out what's going on with your probation, okay?
All right, thank you.
Give him the pretrial dates.
Yeah, we're going to give you a date.
All right, Division 80, pretrial conference, August 11th at 9:30 in 9C.
All right, good luck, Mr. Strong.
Thank you.
All right, good morning. Tell me your name, please.
Good morning to you too, ma'am. Joshua De Leon.
Okay. All right, Mr. DeLeon, we've got information for you of the Volusia case that you got arrested on, the out-of-county, and it's Volusia 2020, I think 100069. I don't know what CFDL means, but that's attached to the case number. And so, Judge Carter here had contacted Judge Perkins, excuse me. Perkins is the judge in Volusia, and he is requesting that the bond remain at $10,000. So the PD was previously appointed on your case. The next step for you now is to have the public defender file a bond motion, and that would be with Judge Marquez in the Circuit Felony Division here in Orlando. So they can still hear a bond motion for you, okay? But we can't change the bond without that bond motion being heard, okay?
Yes, ma'am. Yes, ma'am. I
So
understand.
call the public defender and get with them about filing a bond motion for you, okay?
Is there anything about resolving the case?
I can't resolve any felonies out of another county, and I don't even know what you're charged with. So it very well may be that you can resolve it, but you'll have to get with the public defender. We are doing out-of-county pleas, but not today, okay?
Okay, thank you, ma'am.
All right, good luck. All right, please tell me your name.
Alberto Rodriguez.
Mr. Rodriguez?
Ma'am.
Is that correct? Alberto Rodriguez?
Yes, ma'am.
Okay. This looks like it was reset. Was this a reset from the 12th?
His case was reset. That's the in-jail arraignment judge.
Okay, so it's an in-jail
It was
arraignment?
reset from yesterday. The public defender's office was supposed to go talk to him about a plea. So the judge asked that we reset it for today.
Okay. What? Who was here on the 12th? Was that Sunday?
It was yesterday.
Okay, because it says reset from the 12th, but today's the 14th, so the 12th was on Sunday, I believe.
Sorry, Judge, that was yesterday.
Okay.
I'm here right now.
Okay, so, Mr. Matos, were you here yesterday? What happened yesterday?
I wasn't here in the afternoon, Your Honor.
This would have been in the morning as an arraignment, correct?
Ms. Bush, Ms. Bush gave me some notes that it is enhanceable and there's some JNSs that are pending. But if he wanted to resolve the case, she offered adjudication of guilt, 60 days Orange County Jail, credit for time served, no return to the scene, no contact with the witnesses, restitution of $317.93, abide by the trespass warning, court cost.
Are you on probation, Mr. Rodriguez?
No, ma'am.
And so, but I understand it's enhanceable, Ms. Fusco, but your state filed, the state filed on it already. So your offer is, how much credit for time? He has no credit for time served? Because he's not being held on this case? Okay. Mr. Matos, I don't know if you want to talk to him about taking a 60-day offer where he has no credit for time served. Are you being held on something else?
Actually, looking at it again, she has
she's saying-
160 days.
160 days?
She was gonna give, the state attorney yesterday was gonna give him 160 days with credit for zero. The PD was supposed to go and talk to him because, he was confused.
Well, I would be
about the
confused
time
too,
served.
yeah.
And then the judge, because he was so confused, reset him for today because he wasn't understanding the whole, why he didn't get time served part. But I'm not sure if the PD's office went and spoke to him.
It wasn't the PD that was present, it was their supervisor, Erin. She was the one that was here yesterday when that case was called.
Your Honor, I just got a message from my boss, and she says that he's been in there for 90 days.
Not on this.
Not on this.
But it has not been on this, okay.
Well, see, what happened was, is that there was a felony warrant, okay? And that was in 2020 CF 4487. He was never arrested on the warrant. And the state ended up filing as a misdemeanor. So the warrant was returned unserved on 4/13/2020. It was not executed. Do we know what he's in for?
Right now, his charges are trafficking and controlled substance, trafficking in heroin, possession of controlled substance.
Okay. Do we know why it was never served? The warrant? I'm just showing one page and it's stamped return unexecuted, but I don't know why. Because otherwise, he would have had all that credit for time served, but for the fact that he was never arrested on it. So, I think, Mr. Rodriguez, your attorneys are gonna have to get with the state attorney's office, figure out, is that warrant still pending? I mean, can he be arrested on the warrant?
It was transferred to a misdemeanor and they did it as a summons. And the summons has been served.
Okay, but okay, I get it
So
now.
it's served.
Oh, yeah, the summons is served, but he's not getting any time on anything,
Yes.
because it's not an arrest,
Are
it's
you
just,
gonna remand him today, Judge?
does he have, what's his bond in the felony?
30,000 and 150.
Okay. Mr. Rodriguez, have you attempted to bond out on the felony yet?
No, ma'am.
When were you arrested on that?
March 23rd this year.
Okay, so you've been in for quite some time on that.
Yes, ma'am.
I know this is a difficult question because you're not an attorney. Do you want me, if you're not planning on bonding out on that case, do you want me to remand you on this case, the one that's in front of me, the misdemeanor, so you start getting time? Because if you're sitting in jail, you have this case, but you're not getting time on it. So, Mr. Matos, do you want me to remand him so that he starts getting some time?
Mr. Rodriguez, what's going on is that you are serving time in jail, but you're not serving it specifically for this case. The state's attorney wants to offer you 90 days. The question is
No,
whether...
I think the offer is 160 days.
160 days. Whether if you want, we can remand the case and start you getting credit for the days that you're actually in jail if you're not bonding out.
I know.
Can you repeat that again?
So although you've been in jail, you were not arrested for this case that we're speaking on right now.
What case?
And the fact that you're not arrested for this case, that means that the days that you've spent in jail do not count towards the sentencing of this case. Your Honor, can we just reset this for tomorrow?
No, I'm not going to keep resetting it. So, I mean, I can either enter a plea of not guilty for him, and you all can figure it out and ask the judge to remand him if you want, but he's not getting time on it, so he's just going to be sitting in jail on the other case.
The question to you is, Mr. Do you want the judge to remand you today so they can start counting those days, or would you rather plead not guilty and let your attorney downtown that knows your case figure this out?
Look, I got a private lawyer. I'd rather my lawyer do whatever he got to do.
Okay, I don't believe you have an attorney on the case.
I got a private lawyer. I don't got a...
So the PD was appointed yesterday on this case. I don't show that you have who's your private attorney on?
Miguel Gonzalez.
Okay, he's not representing you on this case?
Is this
Maybe the felony?
This is a
The felony?
Yeah, for the
Sorry?
felony. Yeah, for the felony.
Okay, but he's not, the PD is representing you on this case.
Okay.
I'm not taking any action today. If you want to hire this other attorney and they want to file any appropriate motions, I'm going to enter a plea of not guilty for you, and you call the public defender and explain to them that you're not in jail on this case, okay?
Yes, ma'am.
I have dates for him because
And we'll give you some dates.
it's in Division 80,
Pretrial conference, August 11th at 9:30 a.m. in 9C.
these names out.
We're just going to see how that goes. Oh, yeah. We'll see how that works. All right, good afternoon, sir. Can you tell me your name, please?
Thomas James Burke.
Thomas Burke?
Yes, ma'am.
Okay. All right, Mr. Burke, you are here in 2020 MM 5102AO. It's a petty theft. And I do find probable cause for that offense. Ms. Fusco, did you have an offer to resolve the case today? I don't see any prior theft convictions. I looked, but.
I think he does have prior,
okay.
Your Honor. Yeah, I think there are prior cases, and
Yeah,
it's
there are.
enhanceable.
Okay. All right, so there's no offer today, Mr. Burke, for your case. It's an enhanceable offense, so I am going to order that you're not to return back to the Academy Sports at 6640 Eagle Watch Drive. No contact with any victim, any witness, or any co-defendant. No drugs or alcohol without a valid prescription. And the bond will stay at $250. You're out on release on 2 cases, 2020 CF 131AO and 2020 CF 7402 AO. I am going to revoke the bonds in those cases and set them at none at this time. And it looks like you do have the public defender in those cases or attorneys. And so they're going to have to file a bond motion for you in those cases. Okay?
All right, ma'am.
All right, good luck, sir. All right, good afternoon. Tell me your name, please.
Raymond Calderon.
All right, Mr. Calderon, you're here in 2020 MM 594AW, and you were arrested for trespass on property after warning. And I do find probable cause, and I'll appoint the public defender to represent you. Well, let me see. Before I do that, Ms. Fusco, did you have an offer?
Yes, Your Honor. Adjudication of guilt, 2 days with credit time served of 2 days. Court costs, no return to the scene of the trespass at the mobile gas station at 5206 Silver Star Road, and abide by trespass warning.
All right, Mr. Calderon, if you want to resolve your case today, I don't know if you heard the state, but it's a credit for time served offer. You got to abide by the trespass, can't go back there.
Yes,
You want to
ma'am.
do that?
Yes, ma'am, absolutely.
Okay, okay, I'm not gonna appoint the public defender, and then I think the last case that I called, I initially did not appoint the PD, because I thought maybe there would be an offer, but just wanna make sure that the PD was appointed.
Yes.
Awesome, okay. All right, so Mr. Calderon, did you read the plea form before you came into court?
Yes, ma'am.
Did you understand everything on the plea form?
Yes, ma'am.
All right, you understand all those rights that you're giving up by entering the plea?
Yes, ma'am.
Are you on probation anywhere?
No, ma'am.
Okay. You understand that if you're not a U.S. citizen, the plea will subject you to deportation?
Yes, ma'am.
Okay. I do find a factual basis to accept your plea based on the affidavit in the court file. I'll adjudicate you guilty, sentence you to 2 days with credit for 2 days' time served. Abide by the trespass warning. Don't go back to that mobile gas station. And no contact with victims or witnesses at that location. I'll order you pay your court costs by July 14th, 2021. If you'd like to appeal the judgment and sentence of the court, you must do so in writing within 30 days. If you cannot afford an attorney, one would be appointed for you. And I'm not taking any action on the other case that he has, 2020 CF 6232. Don't know what's going on with that case. Make sure you keep in touch with your attorney, okay?
Yes,
Don't
ma'am.
miss any court dates, all right?
Yes, ma'am.
All right, good luck, sir. All right, good afternoon. Tell me your name, please.
Ronald Dean Guffey.
All right, Mr. Guffey, you're here in 2020 MM 5095AO. It's a petty theft, and I do find probable cause. Ms. Fusco, did you have an offer?
It looks like there's a Florida conviction and an out-of-state one.
What is it?
You're charged with petty theft,
Yes, ma'am.
Mr. Guffey. Okay. So
Like-
you're not making an offer today?
No, Your Honor, it's enhanceable.
So, Mr. Guffey, you have prior convictions out of state, looks like maybe one in state. So the state's not gonna we're not gonna be able to resolve your case today. So you cannot return back to the Circle K at 6942 Sand Lake Road. No contact with any victim or witness at that location. Abide by any trespass warning. I'm gonna stay the bond at the $250. I'm not taking any action on your out on release case. Looks like you have a court date coming up on the 23rd.
Yes,
Are you
ma'am.
aware of that?
Yes,
Okay.
ma'am.
Does he have the PD in that case?
Yes,
You
Ma'am,
do?
I-
Okay.
Ma'am, I'm not even from here, and I was fixing to take off as soon as I get this resolved on the 23rd.
Okay,
I was
well,
getting
you
ready to leave
can,
here.
you can go wherever you wanna go. You just have to show up to court. So,
Right.
I don't know how you how you do both, but that's what you're gonna, you can't miss any court dates, okay?
Right. Ma'am, why is it that we can't resolve this today?
Well, I explained that, which is because it's an enhanceable offense and you have prior convictions. So the state may charge it as a felon, as a first-degree misdemeanor, as a petty theft 1 prior, or with a petty theft 2 priors, which means that would be a felony. So based on what information they can get from any other location about any prior conviction. So because it's an enhanceable offense and they're indicating that to me today, I cannot resolve the case for you, okay? Okay, so the bond will stay set. I'm not taking any action on the trespass. Just make sure you don't miss any court, Mr. Guffey, okay? All right, good luck. All right, good afternoon. Tell me your name.
Sam Proclumba.
Okay, sir, you're here in 2020 MM 5098AO. It's a possession of drug paraphernalia. I do find probable cause. Is there an offer?
Yes, Your Honor, adjudication of guilt, 4 days with credit time served, court cost.
And he has credit for 2?
Yes, Your Honor.
All right, so do you want to do that, Mr. Proclumba?
Yeah, it's fine.
I think that would get you out tomorrow, correct?
Yeah,
I'm
got it.
calculating that correctly? It's 4 days with credit for 2.
tomorrow.
So tomorrow. So that would get you out tomorrow, okay?
Okay.
Do you want to do that, or you want me to impose a bond?
No, that's fine.
Okay. All right, so, and then we're gonna resolve that, and then you've got looks like a DR writ. So you were arrested on a writ in 2005 DR 16898. And so the judge in that case is gonna release you without posting any money. And you're gonna get some paperwork about when you'll need to appear. And I believe it's going to be by phone. It's a telephonic hearing. If you fail to appear for the telephonic hearing, meaning you don't call in when you're supposed to call in,
Right.
that will count as a failure to appear, and you can get arrested and be held at no bond, okay? Do you understand that?
Okay, so with
Okay.
so with the writ, am I still going to court, or is that being resolved?
Yeah,
already?
well, you're gonna get all of this information when you get released, okay? And it's gonna be a telephonic hearing.
Okay.
You must call in. If you miss the telephonic hearing and you don't appear, okay,
Right.
telephonically, then you can get arrested on the warrant again, okay?
All right, so
All right.
I'm being released in what, 2 days?
You'll be released tomorrow on the drug paraphernalia. You'll be released on the writ today. That will no longer be a hold on you,
Really?
okay? So you'll get out tomorrow. Just make sure you appear by phone on the other case, okay?
Okay.
So did you read that plea form before you came into court?
Yes, ma'am.
Did you understand everything on the plea form?
Yes, ma'am.
You understand all the rights that you're giving up by entering the plea?
Yes, ma'am.
And are you on probation anywhere?
No, ma'am.
Okay. You understand that if you're not a U.S. citizen, the plea will subject you to deportation?
Yes.
Okay. I do find a factual basis to accept your plea based on the affidavit in the court file. I'll adjudicate you guilty, sentence you to 4 days with credit for 2 days, time served. Order you pay your court costs by July 14th, 2021. And if you'd like to appeal the judgment and sentence of the court, you must do so in writing within 30 days. If you cannot afford an attorney, one would be appointed for you, sir. Okay?
Thank you very
So
much.
good luck.
Thank you.
And I signed all the, I missed them right now. I signed. Probably missed them. All right, good afternoon. Tell me your name.
Michael Smith.
All right, Mr. Smith, you're here in 2020 MM 5099. You were arrested for criminal mischief, and I do find probable cause for that offense. And did you have an offer, Ms. Fusco? It's water.
It is, but I haven't been able to contact the victim.
I understand that, but I mean, I can reserve for restitution. And
Okay.
you can
I
get the
would
restitution.
defer to the court since I haven't been able to contact them.
Okay.
It was an accident and knocked the wood over.
All right, Mr. Smith, what I'm gonna do is, I do find the probable cause. I'm gonna appoint the public defender's office to represent you. You can't go back to the Circle K at 6942 West Sand Lake Road. Abide by any trespass warning, no contact with any victims or witnesses at that location. You know you gotta show up to court if I release you, right?
Yes.
Okay, how are you gonna get to court?
I'm get the court. Getting ride.
You get a ride,
Yes.
okay. All right, and where are you living?
I'm living.
You staying anywhere?
Yes, I'm staying in the house.
Where are you staying at? Do you remember the address?
Yes, 35th Street.
What is it?
35th Street. It's on my paperwork right here.
Okay, well, I have that you don't have a residence, so
Okay.
I'm just trying to make sure that you don't miss court, because if you miss court, you'll get a warrant for your arrest,
Okay.
and
I'm-
we don't want that to happen.
I'll make court. Yes.
Okay, if you don't know your address, that's fine, but I'm gonna order and I'm gonna put it in the court minutes that you get in touch with the public defender's office within 24 hours of your release.
Yes.
You're gonna get a court date when you get out of jail.
Yes.
Do we know when that court date will be, or?
Do you stand alone?
Yeah, no, I'm gonna RORM. We're gonna give you a court date when you get out of jail, so you need to make sure you do not miss that court date, okay?
Yes.
And get in touch with the PD within 24 hours of you getting released, okay?
Yes.
August 12th at 1
SPD.
p.m.
Okay, so your court date's gonna be August 12th at 1 p.m.,
Mm-hmm.
all right?
Yes.
Okay, good luck, sir.
All right. Thank you.
All right, good afternoon, tell me your name, please.
My name is Marcus Lee Cassida II, Your Honor.
Okay. All right, you're here in 2020 CF 8350AO. You're arrested pursuant to a capias. The state did file an information charging you with possession of heroin. A court did find probable cause. And I'm going to appoint the public defender's office to represent you. No drugs or alcohol without a valid prescription. I am going to stay the bond at the $1,500. Looks like you've got some other cases going on and then an out-of-county hold for Seminole.
Yes, ma'am.
So I don't know what else is going on here in Orange, but you'll have a $1,500 bond here and the PD was appointed, okay?
Yes, ma'am. Your Honor, may I ask what date this warrant's stemming from, originating
So
from?
the incident is alleged to have occurred on August 17th, 2019.
And I've been incarcerated since February 12th on these numerous new charges. I just was wondering how they all of a sudden just popped up with a warrant for this
So
yesterday.
what happened is that somehow drugs were obtained and sent to FDLE, and FDLE tested them, and then they sent it to the state, and the state filed an information, and that's why you're here.
All right, yes, ma'am. I was just under no disrespect. I was just under, and I know you're a busy lady.
It's fine.
I'm not trying to take up no more.
It's confusing.
Yeah, I'm not trying to take up no more of your time. I'm glad that you explained
It's
it, but I thought
fine.
that they only had 180 days to charge me with,
If you haven't been arrested, then they have, now you've just been arrested on the capias. So now speedy trial starts,
all right.
okay?
Yes,
But I
ma'am.
think speedy trial is still suspended. I don't know, pursuant to the court, but
Oh, I didn't know they could suspend.
get in touch with the public defender, okay?
Yes, ma'am. Have a great
Okay.
day. God bless you.
After the next case, the sign interpreter is ready. She's in your office.
Oh, okay. Okay. All right, good afternoon. Tell me your name.
Jordan Desashore.
Do we know what happened to Ludi Delise?
Bonded, Your Honor.
Bonded, okay, we'll take no action. All right, Mr. Desashore?
Yes, ma'am.
Okay. All right, you are here in 2020 CF 8433AO. It's attempted burglary of a conveyance, and I do find probable cause, and I'll appoint the public defender. And in that case, no return back to where the offense is alleged to have occurred, no contact with any victim, witness, or co-defendant. The bond will stay at 1,000, and in 2020 MM 5093 AO, it's a resisting an officer without violence. And I do find probable cause, and I'll appoint the public defender. And the bond, no conditions of release on that, just the bond will stay at the $500. All right?
Your Honor, may
Yes.
I ask one question?
Sure.
Will I be able, because I have an out of county hold, I don't know if you can see,
Okay.
I don't know if you can see it for Polk County. And I was just wondering if I'll be able to bond out on these charges and be extradited so I can take care of my VOP.
So is he being held on a Polk County
It's a no-
VOP?
No bond.
No bond, okay. So right now, they're not transporting people. It's a little confusing. So even if you bonded out on these new charges.
Yes, ma'am.
Okay, you probably would not be transported to Polk County to resolve your VOP. But we are able to resolve out-of-county cases in Orange County because they're not transporting. Has he been seen by a judge on that
That may be
Polk
the
County
best.
VOP? Hold on, did you see a judge?
No, ma'am, but that may be the best case for me to handle it in Orange County.
Right, but I need to make sure that you have an attorney. Do we know if he's been seen by a judge for that?
I haven't.
So he's not been arrested on it?
Well, it's a VOP.
Huh?
It's a VOP. I don't have any more information besides them telling us to let them know when he's completed our charges here in Orange County, and they'll pick him up.
Right, but they're not transporting.
That's the last message that was sent. So,
Okay. All right, well, you have the PD in this case, okay?
Yes, ma'am.
So I think call them and let them know that you have this out-of-county warrant.
Yes, ma'am.
They'll tell you whether or not you should bond out if you can on this. The pretrial release is telling me that the communication with Polk County was that they're gonna come and get you, but they're not transporting people, so I don't know if they're making exceptions for VOPs. I don't know. And I can't appoint the PD in the other case for you because I don't have it in front of me.
Yes, ma'am.
So your best bet is to call the public defender's number and ask for some legal advice about that case, okay?
About the VOP?
Yeah.
Would it be best, that's what I was just asking, would it be best if
Yeah.
I just bonded out all my charges over here?
I can't tell you that, what
Okay.
would be best for you, because I can't give you legal advice and I don't know about what's going on in Polk County. Okay.
So if I bonded out here and then you guys couldn't transport me, what would be the next step?
I don't know. That's a
Okay.
good question.
Okay.
once he posts bond here, we'll contact Polk
Okay.
County and let him know.
So once, Mr.
Yes, ma'am.
Just sure, okay, once you bond out here, Corrections is advising me that they will then contact Polk County and see what they're going to do.
Yes, ma'am.
Okay, so it's
Okay.
really,
Thank
but I
you.
would call the PD and ask them for legal advice, okay?
Yes, ma'am.
You got me? Okay.
All right, thank you so much.
All right, thank you, good luck. Okay, now, what do I hit?
We're gonna add the plus button, like we're calling the interpreters.
Okay.
And add the interpreters in.
Okay.
And then from my understanding, they're supposed to hit the video button there.
But it's not the Spanish interpreter?
No, but she's there in their office.
Okay. And then is this Mr. Holiday? Do we know?
He's coming, Your Honor.
Okay, I'm calling the interpreter now.
Hello, Cisco Unity Connection Messaging System. From a touch-tone telephone, you may dial an extension at any time. For a directory of extensions, press 4. Otherwise, please hold for an operator.
How do I disconnect? Because it says.
Sorry, the operator is not available. Record your message at the tone. When you are finished, hang up or press pound for more options.
I may get disconnected from you all because.
Okay, we had to hang up.
All right, we're back. Hold
We'll try
on.
to add you in again now. She said try it one more time. She tried to pick up, but it wouldn't pick up.
Story of
I
my
have her
life.
on the phone.
Story of my life.
Hopefully it works. If it does not, call AV. Yes, it's ringing now. You want me to call AV or you?
It's just gonna pick up the.
Are you-
I can't breathe.
Okay. Okay, so try to call you again.
Is it the interpreter? Because
Okay,
that's
thank you.
Spanish interpreter.
I know, but she's there in their office. She's there. So she said try to call one more time. She thinks it's her station. If she can't pick up from that station, then we'll have to hang up and call again, and she'll have her at her station. But she said she's able to. So one more time.
Hello, Cisco Unity Connection Messaging System. From a touch-tone telephone, you may dial an extension at any time. For a directory of
All right, we're gonna have to wait on Mr. Holliday because we can't get the interpreter just yet, so we're gonna figure it out, okay? We may have to do it I mean, she has a hearing at 1.
Yeah, at 1 o'clock she
So-
has an injunction.
So what are they doing?
She said give her a few minutes and call her again, and she'll have her at her station.
All right, good afternoon. Tell me your name.
Solomon, do you?
All right, sir, you're here in 2020 CF 8365AO. You were arrested pursuant to a warrant in which probable cause was found for 2 counts of sexual battery on a victim less than 12 years of age. And I will appoint the Public Defender's Office to represent you. Both counts are capital offenses. Ms. Fusco, does the state wish to be heard as to bond?
The state defers to the court in the matter of bond, Your Honor.
I'm sorry, I can't hear you.
The state defers to the court in the matter of bond.
Okay, so you're not asking the court to make a finding?
We're asking the court to make a finding based on the affidavits.
Okay. So you're asking me to make a finding and then to use my discretion?
Yes, Your Honor.
I'm confused. Okay. Mr. Matos?
Your Honor, the PD's office also leaves it to the court's discretion.
Okay. So based on my review of the affidavit presented to me, I do not find proof evident presumption great based on what's in the affidavit. And so I am entitled to a bond. So first off, sir, do we have a no contact order over there? This is a family member. So it's technically a domestic type case, and I would like him to sign a no contact order if we have one over there, or if we can get one printed. Okay. So, sir, I'm going to order that you have no contact directly or indirectly with the victim, any victim, or the victim's family. I know that they're in relation to you, so you cannot have any contact with them at all. Do you understand that? That means
Yes.
directly or indirectly. So no phone calls, no emails, no leaving anyone notes, no mail, no communicating through a third person. Do you understand?
Yes, ma'am. Yes, ma'am.
Okay. You're not to go back to their residence either, or anywhere where they're living. Do you understand?
Yes, ma'am.
So that's not returning to the scene of where the offense is alleged to have occurred. No weapons or firearms or any ammunition, no alcohol consumption or any drugs without a valid prescription. Okay, you understand that?
Yes, ma'am.
Okay. Also, you're not to have any unsupervised contact with any minor child under the age of 18.
Okay.
Okay, your bond on count 1 is 25,000. Your bond on count 2 is 25,000. Are there any other conditions of release, Ms. Fusco?
That's all, Your Honor.
Do you have a passport, Mr. Liu?
Yes.
Okay, so I'm gonna need you to have that surrendered to the clerk's office within 12 hours of any release from the Orange County Jail, okay? So
Okay.
you can surrender that to the clerk's office downtown.
Okay.
If you have any questions about any of that, you can contact the public defender's office and they can give you legal advice, okay?
Okay. So what's next?
All right, thank you. Okay, we're gonna try Mr. Holliday again. I think somebody answered. Hello?
Hello, can you hear me?
I can.
Oh, good. It's the interpreter. Can you see me?
I cannot. Can courtroom two see the interpreter?
We can see her, Your Honor.
Okay.
Oh, good. Perfect.
Yay, okay. Have you been sworn in today?
No, Judge.
Is this Julie?
Yes, it is.
Okay, can you just announce yourself and,
Yeah.
you said you have not been sworn in?
I have not.
Okay. Can I have you raise your right hand to be sworn in? Do you swear to translate from English to English Sign and from English Sign to then English to the best of your ability?
I do. Julie Balassa, nationally certified interpreter.
Okay. And then I believe the individual who needs your services is Daniel Holliday. Sir, can you please tell me your name?
Yes, my name is Daniel. That's my first name. And my last name is, oh, wait, I can't remember how to spell it. Hold on a minute. It's H-A, no, wait, I don't remember how to spell it. L-L-A-D-A-Y.
Okay.
Halliday.
Mr. Holliday, you were arrested in case number 2020 MM 328AA.
I'm not going to bother anybody anymore.
Okay, Mr. Holliday, I need you to not speak right now. And you need to listen. Anything that you say can be used against you. So it's in your best interest not to say anything until you speak with your attorney about the case. All right, so you were arrested for a violation.
Okay, no problem. No more. I won't bother anybody anymore. No
Okay.
more.
You were arrested for a violation of pretrial release condition on a domestic violence case. And I do find probable cause.
Excuse me, Judge.
Yes.
Judge, I'm sorry to interrupt, but the picture just went super blurry, and
Oh,
I can
yeah.
barely see Mr. Halliday.
We just see the same thing. I don't know. I've never had that happen before. Do you want us to try to call you back?
Okay.
I'm calling AV.
Okay, we're gonna call AV. Just stay on the line, all right?
Okay. Okay.
I don't. Yeah, I can't see him either. So.
Oh, good. Better.
Oh, it's back. Okay, we got it.
Okay.
It's keeps
Yeah.
going kind of in and out, but all right. So
Yeah, she's on there, but it's
okay. All right. I do find probable cause for the offense, and I will appoint the public defender's office to represent you in your case. I am going to order that you have no contact directly or indirectly with the victim. I'll have you sign the no contact order. Also, you're not to have contact with both Ronald Holliday and Mary Holliday, so they're both the listed victims, okay? No contact with them at all. Do you understand? Okay, Madam Interpreter, I don't want to interrupt him from talking, but I don't want him to talk about the facts of anything, so I just need to make sure he understands no contact with, I think it's his mom and dad.
I think we lost the volume on the interpreter, Your Honor.
Oh, we lost her?
Can you not? Hello? Hello?
Hello?
Now we can
Hello? Oh, okay.
Yeah.
There's a foot pedal I'm not used to. Sorry, not
That's
used to
okay.
the foot pedal.
Okay, I saw that he was signing a lot, so my guess is that he was talking, a lot. I don't want him to talk about the facts. I just want to make sure he understands that he can't have contact with Ronald and Mary Holiday.
I'm not going to bother them. I'm not going to bother them anymore. No, I'm not going to bother them anymore. Not at the house, at their own house, at
Okay.
my own apartment. I understand it. I'm not going to bother them anymore. I'm not going to bother people anymore. I'm just
Okay.
going to be on my own.
Okay, Mr. Holiday, so you understand no contact directly or indirectly. You're not to return to their residence, so not to return to the scene of where the offense is alleged to have occurred. No weapons or firearms or any ammunition.
Okay, but I want to tell you, the church is better. The church, CHURCH, the church is better.
Okay, so you're not to possess any.
I would change my life. I'm going to change my life. I'm going to quit. I'm going to quit. I'm going to quit smoking and drugs.
Mr. Holiday, I need you to be quiet. Okay, I need you to be quiet and listen. All right? So no weapons or firearms or any ammunition, no alcohol or drugs without a valid prescription. I am setting the bond in this matter at $1,500. I did see that just yesterday, Judge Young.
Oh, wait. Again. What is my bond again?
Your bond is $1,500. I did see yesterday that Judge
Oh my
Young.
God, 1,500? Oh my God.
Okay, well, you're gonna have to talk to a bondsman or your attorneys about it. Just yesterday, Judge Young ordered him incompetent to proceed, placed him on conditional release, and then this incident occurred just thereafter. So I am going to revoke the release in 2019 CF 4519AO, and I am going to contact Judge Young, advise him
Wait.
that Mr. Holiday. No, we're not waiting. You wait. Hold on one second. So I am going to contact Judge Young, and I am going to let him know that I revoked the release, and he will get Mr. Holiday back on the docket as soon as possible. The PD, Mr. Matos, if you might want to I don't know if Mr. Spencer is handling the case or not, but.
No problem.
But somebody at the PD's office who's handling the case should know.
I'm going to be quiet. Less.
So part of the conditional release was that he was not to return back there and he was not to have contact with either one of them. So I am going to revoke that today. He does have Fabian Jaffe, I think is the name of the PD. I'm not sure. But.
Please, I understand. I understand clearly.
Well, Mr. Holiday, I'm going to need to make sure that Judge Young knows that you understand that. So you'll see Judge Young in a couple days. I will make sure that he knows what's going on with the case. Yes.
Okay, no problem. No, I understand. It's clear. I'm sorry. I'm not going to bother anybody anymore. I'm sorry. 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 No more trouble. No more problems.
Okay.
Okay, thank you. Thank you.
All right. And he's signing the no contact order. All right, Mr. Holliday, your attorneys will get in touch with you, and Judge Young, I will speak with Judge Young, okay? All right, thank you, sir. Thank you, Madam Interpreter. Glad that we were able to connect.
All right, thank you, Judge.
All right, thank you so much.
Take
Have
care.
a good day. All right.
You too, bye-bye.
And then is she disconnecting? I can't hang up because oh, okay, because then it disconnects them. All right. Good afternoon. Tell me your name.
How you doing, Judge? My name is Jamal Morris.
Okay, Mr. Morris, you're here in 2020 CF 845980. You were arrested for attempted robbery with a firearm. Looks like they changed the bond from 2,500 to 0. I'm not sure why. It's an F2.
I thought it was a PBL, Your Honor.
Well, so a robbery with a firearm is a PBL. And then if you go to 777.04, that's the attempt. And then that brings it down to an F2 as an attempt. Unless you're reclassifying it again with the same offense that he's charged with. So a robbery with a firearm is a PBL, but when you have an attempt, you go to 777.04. And then if it's, I believe, a capital or a life felony, the attempt becomes an F2.
Your Honor, I see that they scanned in a bond change, and it's supposed to be 2,500. They hasn't updated it yet, so I'll change it to 2,500.
Well, I'm gonna decide the bond.
Okay.
Yeah, I'm just saying I didn't know why
Yeah.
it came in at no bond
They just scanned it in, but
when
they
it's
didn't.
an F2. Yeah.
Okay.
So, Ms. Fusco, are you showing something different under 777.04?
I didn't bring my,
So I'll read the statute into the record.
It's the same thing. It's none. So she just printed out this. It's saying attempted robbery at 2,500.
That's the form we did to update it to none, right, Judge?
Huh?
Yeah,
The-
you got
Can I
that
see the
form.
form and see if that's what the clerk said? Because they gave us a different form.
No, I mean, it still says
Yeah,
none.
they set it at 0.
They did?
Yes.
Right,
Okay.
but it's an F2. So. But Ms. Fusco thinks it's a PBL, so I'm trying to give her the opportunity to argue. I don't know why it's not pulling up the statute.
The statute would be 775.083, Your Honor.
No, when you do an attempt, it's 777.04. So you need to go to 777.04, and then that talks about attempts, okay? Because it changes it from the main offense to an attempt. Don't know why it's not letting me pull it up. I just had it in my office. So, pull it up here. I feel like we go through this every time. So 777.04, attempt, solicitation, and conspiracy. Subsection 4B, if the offense attempted, solicited, or conspired to is a capital felony, which this is not. Subsection C, it's a life felony or a felony of the first degree, the offense of criminal attempt, criminal solicitation, or criminal conspiracy is a felony of the second degree. Okay, we all on the same page? So it is a second degree felony. All right, so Mr. Morris, I am going to order that you're not to return back to the 7-Eleven at 1823 South Orange Avenue. You're not to have any contact with any listed victim or witness at that location, and no weapons or firearms or any ammunition. If you own any weapons or any firearms, you must surrender them within 6 hours of your release from the Orange County Jail. Ms. Fusco, did you wish to be heard as to bond? And he has, does he have 3 other robbery with a, I'm showing 1 robbery with a deadly weapon, a robbery with a firearm, and another robbery with a firearm. He's already been seen on those?
No, he hasn't. He has attempted the 2 robberies with a firearm and a robbery with deadly weapon. He hasn't been seen on those.
He hasn't been seen on those. It's listed on the face 2019 CF 15097. And then there's 2019 15102.
Yes, he has. He was seen on November
Okay, just want to make sure.
2019.
Because he has those cases pending, so I just wanted to make sure. Ms. Fusco, did you wish to be, want to be
Just
heard? as
ask you to
bond?
revoke the bonds in the prior cases, Your Honor, and consider his history in setting the bond in the current case.
Okay, I didn't hear the first thing that you said.
To revoke the bonds in the pending cases?
I don't have anything to revoke. I don't have any bond revocation forms or anything of that nature. My guess is that maybe this offense is alleged to have occurred in August of 2019. So my guess is that those offenses would not be revocable based on the dates. So I will look them up, but that's probably why they don't have a bond revocation for me. So 15019 CF 15097.
Yes, because he's been here since August 31st of 2019 for these 3 charges.
August 31st.
2019.
Okay, yeah, I mean, so he wasn't seen by a judge. That's why they don't have the bond revocation forms. So he would have to have violated those, and it would have to be offense after that date.
Then I would just ask the court to consider his history when setting the bond today, for today's case.
So you want me to stay the bond at 0?
I just asked the court to consider his history when setting the bond on today's case.
Okay, I thought you said stay the bond. Okay. All right. So I am going to set the bond in the amount of $15,000. Mr. Morris, I did appoint the public defender, so you'll need to get in touch with them, okay?
Yes, ma'am. Thank you, Judge.
All right, have a good day. All right, please tell me your name.
Jennifer Amena.
All right, Ms. Neff, you're here in 2020 CF 8463AO. You were arrested for possession of cocaine, possession of drug paraphernalia. I do find probable cause, and I'll appoint the public defender. No drugs or alcohol without a valid prescription. I am going to stay the bond at $1,100. All right, thank you.
All right.
All right, please tell me your name.
Nicole O'Neill.
All right, Ms. O'Neill, you're here in 2020 CF 845780. You were arrested for possession of heroin and possession of drug paraphernalia. As you find probable cause, and I'll appoint the public defender. No drugs or alcohol without a valid prescription. I am staying the bond at 1,100. I'm not revoking any release. In the 2020 MM 3390AO, make sure you don't miss any court dates in that case, okay?
Ma'am, what about the trespassing that I'm not on bond? I said that you were gonna deal with that too.
I just said that I was not revoking the release.
I don't know what that means.
I'm not taking any action on it. You will not be held on that case. Don't miss court.
I can bond out?
Yes.
Thank you, ma'am. Take this?
Good afternoon. Tell me your name.
Abraham Petros, Your Honor.
All right, Mr. Petros, you're here in 2020 CF 8462AO. You're arrested for possession of cocaine, possession of methamphetamine, possession of a controlled substance, possession of drug paraphernalia, and possession of fentanyl. I do find probable cause for those offenses, and I will appoint the public defender. No drugs or alcohol without a valid prescription. And the bond stays at 1,000, 150, 150, 100, 150. 2020 CT 4343AO. It's a driving while license suspended. And I do find probable cause, and I'll appoint the public defender. You may not drive without a valid driver's license. And the bond will stay at 500. I'm not taking any action on the other case. Mr. Petros, you've got 3 cases now, okay? If you come back on another case, I can almost guarantee you're probably gonna get your release revoked on your cases, okay?
All right, ma'am.
So, you have a court date coming up in October for the one that you're out on release on. Make sure you keep in touch with the public defender and you don't miss court, okay?
Yes,
Don't get
Your Honor.
arrested for anything.
Thank you, Your Honor.
All right, good afternoon. Tell me your name.
Sam Porter.
All right, Mr. Porter, you're here in 2020 CF 8419. AO, you were arrested for a burglary with an assault or battery and criminal mischief and petty theft. And I do find probable cause for those offenses, and I will appoint the public defender. Count 1 is a punishable by life felony. And Ms. Fusco, does the state wish to be heard as to bond?
Yes, the state asked the court to consider all the facts in the affidavit. The defendant reached past the doorway of the victim's home and pushed him, and then he kicked the door in and took items belonging to the victim. Photos were taken of the damaged door, and the defendant admitted to being at the scene and had injuries related to the encounter. The state asked the court to find proof, evidence, presumption grade and hold him at no bond.
Mr. Matos?
Your Honor, the public defender's office, based on the facts, does not make an argument and wants to leave it at the court's discretion.
Okay. All right. So, Mr. Porter, I do find proof, evident, presumption great, but based on my review of the facts as alleged in the affidavit, I'm going to use my discretion. I am going to give you a bond, okay? First, before I get to that, you're not to have any contact with the victim or any witnesses in the case. Do you understand?
Yes.
Okay. Don't violate that condition. You can get your bond revoked, okay?
Yes, ma'am.
You're not to return back to that residence
Okay.
at 617 West Swoop Avenue. Don't go back there, okay?
Yes, ma'am.
No drugs or alcohol without a valid prescription, and no weapons or firearms or any ammunition. Your bond on the burglary is $15,000. It's 100 on count 2 and 100 on count 3. All right, get in touch with the public defender. If you cannot make that bond, they'll be able to file a motion to reduce the bond for you, okay?
Yes, ma'am.
All right, good afternoon. Tell me your name.
Matthew Ross, ma'am.
All right, Mr. Ross, you're here in 2020 CF 8464AO. You're arrested for abuse of an elderly or disabled adult. And I do find probable cause, and I will appoint the public defender. First, I do have to advise you that you have reporting requirements, so if you stay at the jail for any reason, you need to report any change of address. Are you aware of all of that, that you need to comply with that?
Yes, ma'am.
Okay. You're not to return back to the 7-Eleven at 901 South Orange Blossom Trail. No contact with the victim in the case. I know that it's alleged in the affidavit that you're roommates.
Yes,
So
ma'am.
I'm gonna order that you maintain a separate residence. So if the victim is at the residence, you can't be at the residence. If they're not at the residence, you can live at the residence, okay?
Understood.
So I'll give you an opportunity to go back with law enforcement, should you need to go back and get any personal belongings. But you gotta be with law enforcement. Don't go to the house and then call law enforcement. Call them ahead of time, all right?
Understood, ma'am.
No weapons or firearms or ammunition. I don't remember if I said that or not. And the bond will stay at $1,000.
Yes, ma'am.
All right, is there any questions that you had about that?
No, ma'am.
Okay, good luck. All right, good afternoon. Tell me your name.
Jordan Turner.
All right, Mr. Turner, you're here in 2020 CF 8452AO, and that is driving while license revoked as a, looks like a third subsequent offense, and there's probable cause for that, and I'll appoint the public defender to represent you in that case. No driving without a valid driver's license, and that bond will stay at $2,500. For 2020 CF 8453AO, it's an attempted robbery with a firearm. I have no facts to support that. Okay. Yeah, it'd be nice that I get this ahead of time. Okay. Did you give one to Mr. Matos?
I did the tab one with the affidavit and the second part of the garage.
Okay. I mean, it could be emailed. That would be great, because now it's going to take me, I don't know how long to read 20 pages.
The actual affidavit is shorter.
I'm sorry?
The actual affidavit is shorter.
Well, you just handed me a whole stack of paper, so is there something specifically that you want me to read? You only want me to take into consideration?
Yes, Your Honor, I'm sorry. The tab part that has 2 pages is the affidavit, and his Gerard is on the second staple section.
Well, I have a victim statement that's tabbed, and then I have an affidavit. Okay, I've read the affidavits provided by the state, and I do find probable cause for the attempted robbery with a firearm. And I'll appoint the public defender's office to represent Mr. Turner, and this is in F2, same as the last case that we discussed because it's an attempt. Ms. Fusco, did you still have an argument as to any bond?
Defer the court, Your Honor.
Okay, I did set the bond in the Willis at the 2,500. Mr. Turner, you're not to have any contact with the victim or any witnesses in the case or any possible co-defendants. Do you understand?
Yes, I understand. The co-defendant is my wife, my baby mother. I stay with her.
What
Jacinta
is her-
Cruz?
Ms. Cruz?
Yes,
Okay.
ma'am.
Okay, you can have contact with Ms. Cruz, but anybody else named in the affidavit, you cannot have contact with them, okay?
Understood.
Okay. No weapons or firearms or any ammunition. You're not to return back to where the offense is alleged to have occurred. No drugs or alcohol without a valid prescription. If you have any weapons or any firearms, you'll need to surrender them within 6 hours of your release to the local law enforcement agency. And he has another attempted robbery with a firearm?
Yes,
Was he
ma'am.
seen- Were you already seen by a judge on that one?
No, ma'am. I never made it to first appearance. They gave me a bond of, I think, 20,000, and then when I went to bond out, they gave me these 2 new charges.
Yes, you seen a judge on July the 10th. You seen Carter.
What's the?
For the case number 2020 CF 008320.
Yeah. All right, I am gonna also set that bond in the amount of $20,000. So you have a $2,500 bond on the driving while license suspended, and then a $20,000 bond on the attempted robbery with a firearm. So you'll need to contact the public defender's office. If you can't make those bonds, they'll be able to file any motions on your behalf, okay?
Yes, ma'am. Can I ask you one question, please? Excuse me, Judge.
Yes.
The house that it happened at, that's also my house.
Okay, hold on. Can I have that paperwork back? I'm sorry. The affidavit? No, the other, the affidavit. What is your address?
4712 Leacock Court, Orlando, Florida 32817.
Okay, so we'll strike that. You can go back to the residence. I don't believe the victim lives there, correct?
Yes, ma'am, she doesn't.
So again, no contact with any victims or witnesses or co-defendants unless it's Ms. Cruz, okay?
Okay, thank you.
Okay, thank you. All right, please tell me your name.
Michael White.
All right, Mr. White, you're here in 2020 CF 83 or 8434 AO. It's an attempted burglary of a conveyance, and I do find probable cause. I'll appoint the public defender to represent you in that case. You may not return back to where the offense is alleged to have occurred, so you're not to go back to the Las Palmas Vista subdivision. No contact with any victim, witness, or co-defendant. That bond will stay at the 1,000. And you've got a resisting an officer without violence in 2020 MM 4094AO, and I do find probable cause, and I'll appoint the PD. It's a $500 bond, no other conditions. And I'm not gonna take any action on the DUI that you've got. You have a court date coming up in August. He has an out-of-county hold for Polk. Looks like you have bonds for a Polk County warrant, okay?
Okay.
Sorry? It's really, I can't hear you. I'm sorry.
Did you address all three cases? I didn't hear, he's currently on a DUI.
I don't.
He's out on bond on a DUI, and he's.
I don't have a DUI. I have I said,
The
I have an out.
attempted burglary and a resisting is what you have?
Yeah. The DUI is what he's out on release for.
And he's currently here on a DUI.
That's the same one that's out on release. It's the same case number. 2020 CT 2114. It's the same
Okay, the
case
judge-
number?
I mean, the bondsman just endorsed it. He came off of it.
Oh, okay, well, it's not in front of me. Okay. So it'll probably come back tomorrow, maybe, I don't know. If I had the paperwork in front of me, I just don't think the clerks can do anything with it if we don't have the paperwork, right? Okay, yeah, so it'll have to get reset. So, Mr. White, it looks like the bondsman came off your bond on the DUI, but I don't have that information in front of me, and I have to wait until the clerk is able to reset that in order to address it, so you may be back here tomorrow. Okay?
Okay.
I can't do anything with it until it's put on the docket and the clerks have it, and the paperwork's generated and all of that, okay?
Okay.
Okay, I'm sorry. All right. Please tell me your name, sir.
Clinton Benjamin Reno Jr.
All right, Mr. Reno, you're here in 2019 CF 468AO. It's a violation of probation warrant, and the judge in your case did set your bond at none. And so I'm going to appoint the public defender to represent you, and you'll see Judge Whitehead in a couple days for your arraignment. Okay?
Yes, ma'am. The reason why I'm here is because I wasn't able to pay my probation fees.
Well, the allegations in the violation of probation are
Or
that you failed to...
the $1,020
Also
that I
that
have
you
to pay. I
Okay.
haven't been able to do that yet.
Do you want to listen to me, or you want to talk over me?
Oh, I'm sorry, ma'am. I do apologize.
Okay. So the second condition is that you failed to attend and successfully complete Batter's intervention program. That's the second
Yeah, I
violation.
haven't signed up for it yet. I haven't had the
Well,
money.
then, I know, but that's why they violated you. So it's not just money. It has to do with the conditions that were imposed, and you did not complete that,
Oh,
okay?
I do
So
understand
you'll
that,
see Judge
ma'am.
Whitehead in a couple days, okay?
Yes, ma'am. Thank you.
All right, please tell me your name.
Felix Roman.
All right, Mr. Roman, you're here in 15 CF 65, and it's a violation of probation on view, and I do find probable cause for that offense based on the new arrest in 2020 MM 5103AO for possession of cannabis less than 20 grams. And I find probable cause, and I'm gonna appoint the public defender in that case. So I am gonna ROR on the cannabis, no drugs or alcohol without a valid prescription. Unfortunately, you're on probation, and part of your probation and being in drug court is probably not to possess or consume any alcohol or drugs. So you're gonna see Judge Whitehead in a couple days for any arraignment. You can address this with Judge Whitehead, as it's a drug court case. but the bond will stay set at none at this time, and you'll probably see him in just a couple days, okay?
Okay,
Or the PD can also file any motions to set bond for you on the VOP.
okay, I also have a question. The driver of the vehicle admitted that it was his, and when I got pulled out the vehicle,
Mr.
Sir,
Rowland?
I don't want you to talk about the facts of the case. That's not what today is about, okay? So you're gonna need to talk to your attorney about that and/or Judge Whitehead, if it gets to that point when you see Judge Whitehead. But right now, it's not a good idea to talk on the record because you're being recorded, so everything can be used against you,
I understand that. Okay.
okay? All right, thank you.
Your Honor, next on the list is White Medical.
All right, and this is an on-view violation of probation.
Excuse me,
29
Your Honor, he's here.
Oh, okay.
Excuse me.
All right, tell me your name.
Daquan White.
All right, Mr. White, you're here 2019 CF 16768AO. It's an on-view violation of probation based on the new law, arrest of attempted first-degree murder with a firearm. And so I do find probable cause for that violation of probation. I'm gonna appoint the public defender to represent you. Your bond will stay set at none at this time. You'll see Judge Whitehead in a couple days for an arraignment, okay?
Yes, ma'am.
All right, good luck, sir. All right, good afternoon. Tell me your name.
Zachary Brown.
Okay, do we know what happened to Ayala?
He's medical, Your Honor.
Myrna?
Ayala? Yes, she's medical.
All right, so this is a Pinellas County case. And so I'll appoint the public defender. Mr. Matos, do you want to waive? She has a bond,
Yes, Your Honor.
and I'm not going to take action on the other case. So she has a bond of 2013. So if she can bond out, she can bond out. If not, Judge Carter will contact Pinellas County. But the PD was appointed, not taking any action on the out on release case. Do we know if she has an attorney in that case?
Oh, on the.
On the out on bond?
Yes, she does.
She does? Okay.
And he's waiving her appearance.
Yeah, the PD waived. All right, and you said Zachary Brown?
That is correct.
Okay, Mr. Brown, you're here on a Seminole County warrant. It looks like the judge set your bond at $1,500.
Yep.
Is it a $1,500 bond?
Yes, ma'am.
Yes? Okay.
Yes.
So it's a $1,500 bond. I'm gonna appoint the public defender here. If you're able to bond out, you can, there's nothing else holding him, correct?
No, Your Honor.
Okay, so if you're able to bond out, you can bond out. If not, one of the judges here will contact Seminole County and see if they can get that reduced, but you have a bond, so it may not get reduced any much, more than
I can
it
afford that.
already is. Okay?
Yep.
Okay, thank you. All right, good afternoon. Tell me your name, please.
My name is Cherie Malcolmus.
All right, Ms. Malcolmus, you're here on a Polk County warrant. And it looks like the judge in Polk County set your bond at none on all the counts. And I'm gonna appoint the public defender here to represent you. And Judge Carter is a judge here. She will contact Polk County and see if they can get you a bond, and you'll come back on our docket in a couple of days. If the answer is no to that, or that you do get a bond and you can't afford that bond, the PD's office can then file a bond motion here in Orange County for you, okay?
Okay, that would be great because I was taken from treatment. Like I was in rehab when they pulled me for this. I've been there for almost 3 months. So
Okay.
how would I've
So-
written the judge and
so-
everything asking for a bond or something.
So
So
Judge Carter here will contact the judge in Polk County. We should have an answer in a couple days, and we'll
Okay.
bring you back here. And then we'll tell you what they say in Polk County, okay?
Okay. All right.
All
Thank
right.
you.
Thank you. All right, please tell me your name.
Nicholas Wagner.
All right, Mr. Wagner, you're here on a Volusia County case, and you do have a $5,000 bond. I'm gonna appoint the public defender here. If you're not able to bond out, then Judge Carter over here will contact Volusia County and see if they will reduce that bond. If they say no, then the PD here can file a motion here in Orange County for a bond hearing, okay?
Okay, yeah, I'm indigent. I don't have any funds for a bond.
Okay, so we'll see what Volusia County will do once Judge Carter contacts them, but we cannot change the bond without their permission to do that, okay?
Understood.
Okay, thank you.
Thank you. Have a good day.
You too. All right, anything else? All right, hearing nothing, then.
All right, so I'm just going to go down the list they've given me. The first I have is Stephen Courier, who represents Mr. Courier.
Good morning, Your Honor. Donald Carbone on behalf of Mr. Courier.
And what is Mr. Courier set for this morning?
Set to plea this morning, Your Honor.
Okay. And it looks like we have paperwork here. Let's go ahead and swear Mr. Courier in.
Raise your right hand. Do you solemnly swear or affirm the testimony you're about to enter into this case will be the truth, the whole truth, and nothing but the truth, so help you God?
All right, good morning, sir. You can put your hand down. Tell me your name and your date of birth.
Stephen Courier, January 15, 1989.
Mr. Courier, as you stand here this morning, you're currently charged in count 1 with burglary of a conveyance, a third-degree felony, punishable up to 5 years in prison. Count 2 is petty theft, a misdemeanor of the second degree, punishable up to 60 days in the county jail. Do you understand the 2 crimes you're charged with, sir?
Yes.
You understand the maximum possible punishment?
Yes.
Your public defender, Mr. Carbone, is standing here in the courtroom. Mr. Carbone, how does Mr. Courier want to resolve this case?
At this time, Mr. Courier would like to enter no contest to the charge of burglary of a conveyance. The negotiated agreement, burglary of a conveyance as well as petty theft, negotiated agreement is adjudication of guilt, 8 months in Osceola County Jail with credit for 195 days. Full cost.
All right. State, is this your agreement?
Maria Morales on behalf of the state, it is, Your Honor.
Mr. Courier, is this how you want to resolve your case?
It is.
As you stand here today, are you under the influence of any drugs, alcohol, or other medication?
No, sir.
Have you ever been treated for a mental illness, emotional disturbance? Are you suffering from such at this time?
No, sir.
Do you read and understand the English language?
Yes.
Your attorney has given me a document called a plea form. It's a 4-page document. It's got your name on it, your case number on it, the charges you're pleading to, the resolution, all your rights. I'm holding it up. I don't expect you to read it from here, but do you see what I'm holding up?
Yes, sir.
Did you go over this form?
Yes, I did.
Did your attorney explain to you all the rights you have and the rights you're giving up by entering this plea today?
Yes.
Did he answer any questions you had about your rights?
Yes.
Did you initial each paragraph indicating you understood what was explained in that paragraph?
I did.
And did you sign on the last page?
Yes, sir.
You understand you're entering a plea today, which means there will not be a trial in your case, and I will sentence you this morning.
I understand.
Has anyone forced, threatened, or coerced you to enter this plea?
No, sir.
Other than what's been discussed here in open court, has anyone made any other promises to you about the sentence you'd receive in this case?
No, sir.
Are you satisfied with the work Mr. Carbone's done in handling your case?
I have.
Do you understand, sir, if you were not a citizen of the United States, entry of this plea would result in your deportation?
I do.
State factual basis for counts 1 and 2.
Yes, Your Honor. On January 2nd of 2020, law enforcement responded to the Osceola Regional Medical Center regarding to a burglary in the parking lot. A witness advised that the defendant was going around checking door handles in the parking lot and gave a description of the defendant who was found inside the victim's vehicle, pretended to the witness that the vehicle belonged to him. When confronted about the situation, the defendant proceeded to hand the witness items that he had taken from the vehicle. and then fled the area. The victim later identified the items as his, and then the witness later identified the defendant as the perpetrator. Post-Moran, the defendant said he was sorry and that he was just trying to take care of his family after he got released from the hospital. All these events occurred in Osceola County, Florida.
Mr. Carbone, any objection to that factual basis for purposes of this plea?
No, Your Honor.
All right, sir, I'm going to accept your plea. I find you're alert, intelligent. Your plea is freely and voluntarily entered. You understand the nature of the charges against you, and you're represented by competent counsel with whom you say you're satisfied. I also find a factual basis for the acceptance of the plea. Mr. Carbone, is there any legal reason why sentence should not now be imposed?
No, Your Honor.
All right, sir, the court having accepted your plea, I will sentence you as follows. On each count, I'll adjudicate you guilty. On count 1, I will sentence you to 8 months. That's 240 days in the Osceola County Jail with credit for the 195 days time served you already have. On count 2, I'll adjudicate you guilty. Since it's a second degree misdemeanor, I'll sentence you to 60 days in the Osceola County Jail with credit for 60 days time served. I'll order on each count that you pay whatever statutorily required fines, fees, and costs are associated with that charge. Madam Clerk, what would those be?
$418 court costs, a $100 cost of prosecution, and a $100 public defender lien for a total of $618.
Sir, other than this case, is there anything that's going to hold you in custody longer than the service of this sentence?
No, sir.
All right. I'll give you 90 days from your date of release to get out, find a place to live, find a job, and start making payments to the clerk of the court. I'll order within 90 days of your release from custody, you contact the clerk of the court, set up a payment plan, and begin making payments at a minimum rate of $30 a month towards your costs till your costs are paid in full. Anything else, Mr. Carbone?
No, Your Honor.
Anything else, Ms. Morales?
No, Your Honor.
Anything else, Madam Clerk? That's the judgment and sentence. The court defendant is remanded to custody of the Osceola County Jail to serve the balance of the sentence. Good luck to you, sir. All right, next I have Willie Dowdell. All right, what are we doing with this case today?
It's an arraignment this morning, Your Honor, and based on the office of the state, I imagine that we'd be entering a denial on his behalf this morning.
Okay, let's go ahead and swear Mr. Dowdell in.
Raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to enter into this case will be the truth, the whole truth, and nothing but the truth, so help you God?
All right, good morning, sir. Tell me your name and your date of birth.
Willie Dowdell, 11/28/1960.
Sir, you're previously placed on probation for the offense of burglary of a dwelling, I believe burglary of a conveyance, and possession of burglary tools. It's now been alleged that you have violated your probation in this matter. The Office of the Public Defender was previously appointed to represent you. And again, Mr. Johnson, you want to enter denial at this time?
Yes, Your Honor.
I'll enter a denial as to the allegation of violation at this point in time. I'm going to set you for a violation of probation status hearing. Tabitha, can you tell me what August 13th is looking like? I want to set you for a violation of, well, Mr. Johnson, let me ask you. I was going to give him August 13th. I also have September 10th available, given that he's classified as a violent felony offender of special concern. I think September 10th might be a more reasonable date to give you more time to work on a potential resolution or potential defenses to the violation.
Yes, Your Honor, I believe that's true. And if we can work something out, we can also get him.
All right, so I'm going to set you for a violation of probation status hearing on September 10th, 2020, and your lawyer will be in contact with you, all right?
Yeah, Your Honor, can I ask what that violation consists of?
I don't have time to go over the entire affidavit.
I never was told what the violation was.
I believe it was a failure to report and a violation of curfew were alleged.
Yeah, it looks like a failure to report to the probation office, and they're also alleging that you were in violation of curfew. Your attorney will be able to talk to you more about that, okay?
Yes, sir.
All right. Tabitha, can you go ahead and tell me what September 10th is also looking like? So I can... 9. And so this one would make 10. Perfect. Great. All right, next I have Philip Hayward Harrison.
Yes, Your Honor. Don Carbone.
What do we have him docketed for?
It's going to be a plea, Your Honor. But I'd just like to give the court a heads up. It's going to be a global with 19 CF 3665. That case is not open in our system for some reason.
Okay.
I don't have a signed VOP form for that. If the court is inclined to reset this, we can do that. Or what I can do is go through the plea colloquy and I can mail it to the defendant and he mails it back and the clerk will have it closed out by either Friday or next week.
Do you have an executed plea form on the new law?
Yes, Your Honor.
Yes. So what I would anticipate doing is, if the clerk can print me the affidavit of violation. Okay.
He let me know. He gave me a heads up.
Under the circumstances, if I'm adjudicated him guilty of a new law violation, then I think that effectively,
Right.
I don't know how long a colloquy I need to have on a VOP under those circumstances.
Okay.
So we can proceed. Let's go ahead and swear him in.
Do you solemnly swear or affirm the testimony you're about to enter into this case will be the truth, the whole truth, and nothing but the truth, so help you God?
All right, good morning, sir. Tell me your name and your date of birth.
Good morning. Philip Hayward Harrison, 12/15/86.
All right, Mr. Harrison, you have two matters before the court today. The first is case number 20 CF 1162. In that case, in count 1, you're charged with petty theft, having 2 prior theft convictions, a third-degree felony, punishment to 5 years in prison. Count 2 is resisting an officer without violence, a first-degree misdemeanor. Count 3 is resisting merchandise recovery, a first-degree misdemeanor. Count 4 is trespass in an occupied structure, a first-degree misdemeanor. Count 5 is battery, a first-degree misdemeanor. And count 6 is possession of drug paraphernalia, a first-degree misdemeanor. Each of those first-degree misdemeanors is punishable to a year in the county jail. Do you understand the new charges and the maximum possible punishment?
Yes, sir.
Now, at the time of this new offense, you were on probation in case number 19 CF 3665 for the offense of grand theft in the third degree of a motor vehicle, grand theft in the third degree. Do you understand? And now this is alleged to have violated your probation, this new offense. Do you understand that?
Yes.
Mr. Carbone, how does he want to resolve these two cases?
At this time, Mr. Hayward Harrison would like to enter a no contest plea to a new law violation of 20 CF 1162 on an admission of guilt and a VOP of 19 CF 3665. The negotiated agreement is adjudication of guilt, 180 days in the Osceola County Jail with credit for 110. It would follow by 36 months of supervised probation. You must complete the inpatient program, which is Bridge, 100 hours community service, random urinalyses and court costs, no return to the Walmart, as well as satisfy the underlying conditions of the probation of $2,000 restitution to the victim, $6,249.67 to the insurance company, as well as remain no contact with the victim. This state of Florida has no objection to early terminate after this done, and like I said, is concurrent with VOP 19 CF 3665.
Is he going to receive a new term of probation on the VOP as well?
No, that probation is revoked and terminated, Your Honor.
Is he stipulating that the unresolved conditions from his violation can now be added as conditions in his new case?
Yes, Your Honor.
Okay. And state you're comfortable with that resolution?
No, he would need to be on probation still for the underlying, that way, just because of the restitution, because of the amounts. I think the record would be clear if everything just kind of follows through. If anything, on the new law, I'm okay with him just doing the jail on that one instead.
Okay. So, Mr. Carbone, are you comfortable with me making sure the defendant understands that he's going to be on supervision in both cases?
Yes, Your Honor.
All right. So, Mr. Hayward Harrison, have you heard your attorney describe the resolution?
Yes.
And because you still have unpaid restitution and other conditions on your underlying VOP case, the state's asking that I place you back on probation on that case as well as probation on your new case. Do you understand that?
Yes.
And have you decided that this is the best way for you to resolve both your new case and your violation of probation?
Yes.
As you stand here today, are you under the influence of any drugs, alcohol, or other medication?
No.
Have you ever been treated for a mental illness, emotional disturbance? Are you suffering from such at this time?
No.
Do you read and understand the English language?
Yes.
In your new case, your attorney has given me a document called a plea form. It has the case number on it, it has the charges you're pleading to, it has the resolution, and it has all of your rights. I'm going to go ahead and hold it up. It's a 2-page document printed front and back. I don't expect you to read it from here, but are you familiar with that document?
Yes.
Did you go over that document with Mr. Carbone?
Yes, sir.
Did he explain to you all the rights you have and the rights you're giving up by entering this plea today?
Yes, sir.
Did he answer any questions you had about your rights?
Yes, sir.
Did you then go through this form initially in each paragraph indicating you understood what was explained in the paragraph?
Yes, sir.
Did you sign on the last page?
Yes.
Do you understand by entering this plea, you're not going to have a trial in your new case, and I'm going to sentence you this morning?
Yes, sir.
Now, you also understand that you were on probation when this new offense took place. Do you understand that?
Yes, sir.
Do you understand by me finding you guilty and sentencing you on this new case, I would be required to find you in violation of probation?
Yes, sir.
Do you understand by entering this plea today, you're not going to have a violation of probation hearing on the allegations in the affidavit of violation?
Yes, sir.
And again, have you decided it's in your best interest to take this plea to resolve both your new case and your violation of probation?
Yes, sir.
Has anyone forced, threatened, or coerced you to enter this plea and this admission?
No, sir.
Other than what's been discussed here in the courtroom, has anyone made any other promise to you about the sentence you'd receive in either of these cases?
No, sir.
Are you satisfied with the work Mr. Carbone's done in handling these two cases?
Yes, sir.
Looks like he got you a good outcome, sir.
Yes.
Do you understand, sir, if you were not a citizen of the United States, entry of this plea would result in your deportation?
Yes, sir.
Ms. Morales, can I have a factual basis for the new case? I also need a score sheet, and then we'll proceed forward.
Score sheet's coming up, and then the factual basis for the new law violation, which would be 2020 CF 1162. On March 27th of 2020, loss prevention officers at Walmart observed the defendant conceal a total of about $186.72 of merchandise and exit the store without paying. Once the defendant passed the last point of sale, the loss prevention officers identified themselves and tried to escort the defendant to the security office. The defendant became combative and kicked the loss prevention officer Nieves in the shin and punched her in the face. He struck loss prevention officer Cortez in the forearm and was able to free himself. Loss prevention advised that the defendant had previously been trespassed on July 4th of 2019 under a false name he had given them at the time. Law enforcement observed the defendant running from the store and ordered him to the ground. At first he resisted, but eventually he did comply, and then physically struggled with the officers to avoid being handcuffed. All these events occurred in Osceola County, Florida. And I have the global score sheet. I'm just getting it signed.
All right. Mr. Carbone, any objection to the factual basis as to the new law violation?
For purposes of the plea, Your Honor.
And do you concede that that factual basis in this determination of guilt constitutes a basis for the court to find the defendant willfully violated his probation and sentence him on that case as well?
Yes, Your Honor.
All right, sir, I'm going to accept your pleas. I find you're alert and intelligent. Your pleas are freely and voluntarily entered. You understand the nature of the charges against you, and you're represented by competent counsel with whom you say you're satisfied. I also find a factual basis for the acceptance of the plea on the new law violation and a factual basis to believe you willfully violated your probation. Is there any legal reason why a sentence should not now be imposed, Mr. Carbone?
No, Your Honor.
All right, sir, starting with your new law offense as to count 1, I'm going to adjudicate you guilty. I'm going to sentence you to 180 days in the Osceola County Jail. That's 6 months. I'm going to give you credit for 110 days time served. That'll be followed by 36 months of supervised probation. I'll order that you report to Department of Corrections probation within 2 working days of your release from custody on this case. While you're on probation, I will order that you perform 100 hours of alternative community service at a minimum rate of 8 hours a month. I'll order that you pay, is it restitution to Walmart on the new case?
No.
Okay.
It was on the On the VOP case, it's 19 CF 3665. It was 2,000 to one party and
All right. I'm just going to make that a condition of the new probation on the VOP. I'll order that you not return to the Walmart where this offense took place. Any other conditions on the new law offense as far as to the probationary sentence?
Yes, Your Honor.
What else?
Oh, that's what I meant by the restitution, so.
Okay, all right. On counts 2, 3, 4, 5, and 6, on each of those counts, I'll adjudicate you guilty. On each of those counts, I'll sentence you to 180 days in the Osceola County Jail. On each count, I'll give you credit for 110 days time served. The sentences on counts 2 through 6 are concurrent with the sentence on count 1. All of the sentences in this case are concurrent with the VOP sentence I'm about to announce on your other case. State, have I omitted anything on the new law case?
may I approach with the global score sheet?
You may. I am going to order on the new law case that you pay any statutorily required fines, fees, and costs associated with that case. As to your violation of probation in 19 CF 3665, on count 1, I'll adjudicate you guilty. I'll revoke and terminate your probation. Do we have a time served on him?
Well, it was 111 days, but he wasn't technically picked up on this one. The 111 days was the last sentence.
Okay.
So it would add 110 days if we were to count the arrest on this one. It would be 221 total, or 110 he wasn't technically arrested on this one.
I don't think there's going to be a meaningful difference on his release date if I give him 111 days on the VOP. He's still going to, the new law case is still the thing that's going to hold him the longest.
And the 111 was what he was sentenced, the prior sentence.
All right.
So
I'm going to give him credit for the 111 days he's actually already served on the VOP.
Okay.
He only got 110 days on the new case, so the new case is going to keep him theoretically 1 day longer than the VOP, regardless of what I do on that.
Thank you.
All right, so as to your violation of probation on each of those counts, I will adjudicate you guilty. I will sentence you to 111 days in the Osceola County Jail with credit for, or actually 180 days in the Osceola County Jail with credit for 111 days time served. I'll revoke and terminate your original term of probation. I'll impose a new term of probation of 36 months of supervised probation. I'll order that you report to Department of Corrections probation within 2 days of your release from custody. Your terms and conditions of probation will be comply with all original terms and conditions that were previously announced, specifically that you pay the remaining restitution to both the victim and the insurance company, that you have no contact with the victim on that case. Any other conditions, Ms. Morales, on the new term of probation on the VOP case?
There.
All right. I'll also order that you pay any statutorily required fines, fees, and costs on this violation of probation, and whatever unpaid balance is left on the underlying case as far as the unpaid restitution balance, unpaid restitution balance, unpaid court costs. So, Madam Clerk, and this sentence is concurrent with the sentence that I just announced in case number 20 CF 1162. Madam Clerk, can you announce the cost by case number, including unpaid balances from the VOP?
I just have a question, because on the VOP, there was a $2,000 restitution, but I noticed another restitution amount mentioned $6,249.67. That wasn't ordered on the VOP. Is that something being ordered on the new law now?
That was, okay. It should have been part of the VOP, because the $2,000 is what goes towards the deductible, and then the 6,000 whatever amount, it's the actual payout from the insurance company. So then you don't have the information of the insurance company?
There's no restitution order on the VOP case. There's just the $2,000 to the victim.
Okay.
And there was no order for the $6,000.
Okay, I'll get that printed out. The notes I have on this are from back in April, so I thought that it had already
All right.
been included.
So, Mr. Carbone, is your client going to object to the court now entering the $6,249.67 payable to the insurance company?
Your Honor, I'm not sure. That's not something I realized and contemplated.
Okay, so, do you have any objection if I explain the situation to him and then offer him the opportunity to consult with you before making the decision?
No objection.
All right, so, Mr. Hayward Harrison, here's the situation. The state attorney's office is indicating that on top of the $2,000 to the victim for their deductible, that the insurance company is claiming $6,249.67 payable to them for their out-of-pocket to reimburse for the damages that took place based on your criminal conduct. The clerk's indicating that that was never originally ordered. I'm not going to force you to accept that today. If you want to talk to Mr. Carbone about the pros and cons of that, here's the one thing I want to caution you about. This was part of the deal the state negotiated. I'm not going to impose the rest of the deal if you indicate that you want to think about the $6,249. I'll simply reset you for next Tuesday so you can talk to Mr. Carbone and see if you're comfortable agreeing to that restitution amount. Or if you're comfortable just proceeding forward and having me ordering it and not talking to Mr. Carbone about it more, then I'll proceed forward and sentence you. So it's really your decision, and it doesn't matter to me which decision you make. It's a lot of money just to agree to, but by the same token, if you want to get this over with and not spend any more time on it.
Yeah, let's get it over with.
Mr. Carbone, do you think I need to have any further colloquy with your client on that point?
No, Your Honor, if he understands that he will now owe,
It's an extra
money.
$6,249 that you previously hadn't been ordered to pay. You understand I'll order you to pay that?
Yeah.
You understand that if you try to early terminate probation, one of the first things that I or any other judge will look at is, has all that restitution been paid off? Do you understand that?
Yeah, well, I'll speak to Mr. Carbone about it then.
Okay, all right. So here's what we'll do. I will reset this to next Tuesday. I'll set aside the plea that I just went through. If you come back next Tuesday and you're fine, then I will just proceed to sentencing. So actually, technically, I'm not setting aside the plea. I'm going to defer sentencing to next Tuesday. If you decide next Tuesday that you're ready to go forward and take the $6,249, then I'll proceed to sentencing. If you tell me that you're not comfortable with that, then I'll set aside your plea on next Tuesday, and we'll put you back where you were before, okay?
Okay.
All right, Mr. Carbone, any objection to me handling it that way?
No, Your Honor, thank you.
All right, Madam Clerk, is that clear? I'm going to defer sentencing on the issue of restitution until next Tuesday. All right. Next, I have, I have Jamil Porter. Okay, what's Mr. Porter here for today?
It's here for an arraignment this morning, Your Honor.
Okay, let's go ahead and swear him in.
Raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to enter into this case will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Okay. Sir, tell me your name and your date of birth.
Jeremiah Porter, 10/20/1995.
Mr. Porter, looks like you're charged with one crime in the case. That's the crime of grand theft, third degree of a motor vehicle. That is a third degree felony, punishable to 5 years in prison. The Office of the Public Defender has been appointed to represent you. Mr. Johnson, what plea do you want to enter at this time?
Being not guilty this morning, Your Honor.
Who's the state on this case?
On behalf of the state.
Ms. Olvera, what would be the normal speedy trial calculation, ignoring the fact that it's currently told?
One moment, Your Honor.
Just for Mr. Porter's sake, there was no offer conveyed this morning as far as
Okay.
not guilty.
The date would end April 22nd, 2020.
April 22nd, 2019? 2020. All right. Do you know why I'm just seeing him for arraignment at this point, Ms. Olvera?
That's the case habeas at one point,
Okay.
beginning of January, or end of January.
All right.
For a fact, he was held in Polk County, so we can wait.
All right, well, I don't have to make a formal decision on speedy trial today. We can address that at the appropriate time, but let's do this. I'll go ahead and set this for pretrial conference on October 7th, 2020. And a trial period starting October 19th, 2020. If the case is going to resolve before then, just bring him in and we'll take his plea.
Yes, Your Honor.
All right. That's the order of the court in regards to Mr. Porter. Next, I have Jose Ramos. Who represents Mr. Ramos?
He
Says-
hasn't been assigned in this case yet.
Okay, let's go ahead and swear him in.
Raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to enter into this case will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, good morning, sir. Tell me your name and your date of birth.
Jose Ramos, September 18, 1975.
Sir, it looks like you were placed on probation previously for the offense of possession of a controlled substance. It's now been alleged you violated your probation specifically in regards to a grand theft charge. The Office of the Public Defender has been appointed to represent you, but your case has not yet been assigned to a particular public defender. Will one of the public defenders tell me how you want to proceed at this moment? Hold on a second, sir.
I represent him on the new law. So,
Okay.
I know that we should enter denial.
All right. So, Mr. Ramos, today is arraignment. The purpose is to simply tell you the nature of this charge, to make sure you've got an attorney. You do have the public defender's office. Ms. Rosas, who has your new case, is most likely going to be assigned your violation as well. My advice would be talk to her. If you talk about the case right now, the prosecutors are listening. This is being recorded. You might make it difficult or impossible to defend yourself later on. Does that make sense?
Yes, Your Honor.
Ms. Rosas, do you happen to know when his new law case is docketed?
I could look it up.
Okay.
It hasn't been filed.
Okay. So here's what we'll do. That's not been filed yet, so I'll go ahead and enter a denial at this point. I'll set a violation of probation status hearing on September 10th. And if the new case gets filed and it gets put on a pretrial docket and it's not going to resolve, then we'll just move the VOP to ride along with the new case. All right, that takes care of Mr. Ramos's case at this point in time. Next, I have Dexter Roberson.
Rose Rosas on behalf of Mr. Roberson.
What do we have Mr. Roberson for today? All right, is it ready to go?
Oh, yes, Your Honor.
Okay.
It didn't print. So can you try to print it out again? It's an Oxford Dean. Oh, okay. Let me go print it.
All right, let's go ahead and swear. So you don't have to put your hand up, or you can just do it the best you can. Perfect. The way you did it before is perfect.
Do you solemnly swear or affirm the testimony you're about to enter into this case will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, good morning, sir. Tell me your name and your date of birth.
Dexter Roberson, April 12, 1979.
Mr. Roberson, you have two cases before the court, starting with case number 19 CF 3493. In that case, you're charged with 5 crimes. Count 1 is felony battery. causing great bodily harm, permanent disability, or permanent disfigurement. Count 2 is resisting officer with violence. Count 3 is battery on a law enforcement officer. Count 4 is battery on a law enforcement officer. Count 5, those first 4, each third-degree felonies, each punishable up to 5 years in prison. Count 5 is a violation of pretrial release condition, a first-degree misdemeanor, punishable up to a year in the county jail. Do you understand those 5 crimes, the maximum possible punishment you're facing?
Yes.
Then you have another case, 20 CF 1609. On that case, you're charged with the crime of battery on a law enforcement officer, a third-degree felony, punishable up to 5 years in prison. Do you understand the charge in that case and the maximum possible punishment?
Yes.
Your public defender, Ms. Rosas, is standing here in the courtroom. Ms. Rosas, how does he want to resolve these 2 cases?
As to 19 CF 3493, Mr. Roberson will enter a plea of no contest. The agreed upon sentence is an adjudication of guilt, 28.05 months DOC, and court costs, and that's to run concurrent to his other case, 20 CF 1609, where he'll also enter a plea of no contest, and the agreed upon sentence in that case is an adjudication of guilt, 18 months DOC, court costs concurrent to 19 CF 3493. And those 2 cases, they also are going to run consecutive to 19 MM 3101, which is a case that he already pled to a few months ago.
All right, and I assume he received some kind of county jail sentence on the MM case?
It's actually probation. It's a probation offer.
Okay.
Well, hold on. We're about to make things very complicated. If I announce a DOC sentence consecutive to a misdemeanor probation sentence, then theoretically they need to let him out, go do his probation, then they need to bring him back afterwards and commit him to DOC. Legally, that would be the structure of the sentence. My concern is that would be very difficult to explain to the jail. And I'm not sure, well, I'll start with that. It would be very difficult to explain to the jail because they're going to say, we've got a DOC hold on him. We don't want to release him. So I'm fine with the proposed sentence on these 2 cases. I'm just worried that we're about to create a very confusing situation and have subsequent hearings when somebody in the system says, we can't really do this. So
I'm okay with just leaving that part out because that's why I haven't even included it on the plea form. Originally, that was something that the state wanted to add in. So I know he's gonna have to do probation anyway when he gets out of DOC, so I don't think we don't need to include that in the plea form for this.
So what ASA Gonzalez is clarifying is that the probation would then have to follow his DOC sentence. So I don't know that saying that these cases are consecutive to the, I guess essentially he wouldn't, we're trying to get it so that he wouldn't start his probation until after the fact.
Okay.
I mean, it's gonna be automatically told anyway, so.
My assumption is that probation would toll his probationary sentence while he's in custody. But Ms. Gonzalez might want to get back in front of the misdemeanor judge and make sure that that's clear, but that'll be an issue in that case. All right, so Mr. Roberson, have you been listening to this conversation?
Yes, sir.
All right. Do you understand that my intent this morning is to sentence you to the Department of Corrections?
Yes, sir.
You should assume that you're going to go to the Department of Corrections, and you should assume that unless you hear otherwise, your misdemeanor probation is not going to start until you get released from probation, and you'll still have to do that. Do you understand all that?
Yes, sir.
Okay. Understanding that, do you still want to go forward and resolve the case the way Ms. Rosas just explained it to me?
So you're saying I got to do probation after the DOC?
That is my understanding of what's going to, that's what you should assume. If the judge in the misdemeanor case orders otherwise or probation says otherwise, that's a different issue. But what I want you to understand is if I sentence you,
yes, sir,
and you get out of DOC and you don't report to probation, very likely a violation would be filed and you'd probably be picked up, and then you could argue whatever you want about that. But I just want you to understand that this sentence is going to take effect, and you should not assume anything other than the fact that you're going to have to do that misdemeanor probation after this DOC sentence is served.
Okay, sir, I don't mind doing the probation. My problem was I was trying to finish everything, because when I get done with DOC, I'm leaving the state. I'm not gonna be here in Florida.
Sir, all I can.
I was trying to finish everything while I was here.
Okay. Sir, all I want to explain to you, I don't want a situation where you get to DOC and they tell you, oh, by the way, here's your date of release, and by the way, here's your order to report to the probation department, and now you're writing me a letter saying, I thought I was done, I thought my DOC time was it, now they're saying I have to report. I want to avoid any confusion. So if you're not comfortable resolving the case this morning because of this issue with the probation sentence, I understand that. I'll reset your case. I'll let your lawyer talk to you more. If you decide that you don't want to take the deal, that's fine. Then we'll put you back on a trial docket. If you decide.
I'm just ready to get this over with.
Well, Ms. Rosas, are you comfortable going forward based on what I've explained so far?
Well, Your Honor, the state was saying that we can delete the part that says consecutive to 19 MM 3101, but also I do feel comfortable proceeding in this case. We've talked about the offer, and we've talked about the fact that he pled to probation already, so he knows he has to do the probation anyway. So
Okay. I just want to avoid any confusion about his decision to enter the plea today. So, sir, I understand you want to get it over with. I was going to give you more time to talk to your lawyer, so do you understand? I'm going to sentence you to DOC today. Yes, I'm not doing anything about the probation that you already received on 19MM3101. That's going to be between you and that judge and probation when you get released from DOC. You understand that?
Yes, sir.
Have you decided it's in your best interest to go forward with this plea today and resolve these two cases that I do have?
Yes, sir. Yes, sir.
As you stand here today, are you under the influence of any drugs, alcohol, or other medication?
No, sir.
Have you ever been treated for a mental illness, emotional disturbance? Are you suffering from such at this time?
No.
Okay. Do you read and understand the English language?
Yes.
Your attorney in each case has given me a document called a plea form. Each one has your name on it. Each one has the appropriate case number on it. Each one has all your rights and the resolution for that case. There are two of them. I'm holding them up. Did you go over these forms?
Yes. Yes. Yes.
Did Ms. Rosas explain to you all the rights you have and the rights you're giving up by entering these two pleas?
Yes.
Did she answer any questions to you about the sentence you'd receive in either case?
Yes.
Did you then initial each paragraph indicating you understood what it explained?
Yes.
Did you sign the back of each plea form?
Yes.
Do you understand in each case you're entering a plea, which means there won't be a trial in your case, and I will sentence you this morning?
Yes.
Has anyone forced, threatened, or coerced you to enter this plea today?
No, sir.
Other than what we've discussed here in open court, has anyone made any other promise to you about the sentences in these two cases or how it would affect the probation sentence you already received in your misdemeanor case?
Yes. No, sir.
Are you satisfied with the work Ms. Rosas has done in handling these cases?
Yes.
Do you understand, sir, if you are not a citizen of the United States, entry of these pleas would result in your deportation?
Yes.
Has any state factual basis for each of these two cases?
Yes, Your Honor. As to 2019 CF 3493, on or about October 2nd of 2019, the defendant and his live-in girlfriend were at their residence. The defendant had been drinking and became verbally abusive towards her. The defendant continued to yell at Ms. Mills and became angry, combative, and began throwing items around the house. Ms. Mills walked into her bedroom to avoid the defendant and proceeded to get ready for work. The defendant became enraged and came into the bedroom and pushed her. The defendant hit her in the face multiple times and pushed her over the dresser. Ms. Mills continuously asked the defendant to stop, but he wouldn't. Ms. Mills tried to pull away and scream for help, but the defendant then pushed her into the bathroom mirror, creating 2 large lacerations on her forehead. The defendant immediately stopped and began to apologize for hurting her. Ms. Mills then ran into the neighbor's house for help. She ultimately received stitches for her injuries. Further into the investigation, law enforcement discovered that there was an active no contact order in case number 2019 MM 3101, and they had advised the defendant not to have contact whatsoever with Ms. Mills, not to return to the home, and not to consume any alcohol-controlled substances. The defendant was arrested and taken to the Osceola County Jail. Law enforcement moved the defendant's cuff to the front so that he could write a statement. When the defendant asked if Ms. Mills was being charged with anything, at which point he became irate and said, this is BS. The defendant then lifted the interview table 2 feet off the ground and dropped it. 2 other officers came in to assist with the defendant, who was combative. The defendant was ordered to sit, but he refused. He was taken to the floor. He ended up hitting one of the deputies with his shoulder and backed another deputy into the wall. The defendant also tried to headbutt another one of the law enforcement officers. He kicked one of the deputies that he had pushed, and he became increasingly violent, kicking and pulling away and cursing at them. A hobble was ultimately placed on the defendant's leg. Outside the Sally Port, the defendant was trashing and kicking his body. He was then taken to the ground, sprayed with OC spray, where he finally complied and taken to jail. Once at the jail, he became violent again, spitting at everybody, and he was placed on a restraining chair and spit mask. All law enforcement officers were wearing their spruce green sheriff's office uniform. The incident was captured on surveillance video and occurred in Osceola County, Florida. As to case number 2020 CF1609, on or about January 3rd of 2020, Corrections Officer Richardson and Corrections Officer Hughes conducted cell checks. The defendant became hostile. He continually refused to follow the commands and was yelling profanities at the COs. The defendant ultimately yelled that he was tired of CO's shit and that he was gonna mess him up. The defendant ran into the cell door and purposely struck CO Richardson. The CO was able to gain control of the cell door and secure the defendant. At that time, the CO was wearing his Osceola County Corrections uniform, and all these incidents occurred in Osceola County, Florida.
Any objection to either factual basis for purposes of this plea, Ms. Rosas?
No objection.
All right, Mr. Roberson, I'm going to accept each of your pleas. I find you're alert and intelligent. Your pleas are freely and voluntarily entered. You understand the nature of the charges against you, and you're represented by competent counsel with whom you say you're satisfied. I also find a factual basis for each of the pleas. Is there any legal reason why sentence should not now be imposed, Ms. Rosas?
No, Your Honor.
And just to avoid confusion, Ms. Rosas, I'm going to return the 20 CF 1609 plea form. If you can strike through the consecutive to the misdemeanor case and have both you and Ms. Morales initial that alteration. All right, sir, I'm going to start with 19 CF 3493 on counts 1, 2, 3, and 4. I'll adjudicate you guilty. On each count, I'll sentence you to 28.05 months in the Department of Corrections. On each of those counts, I'll give you credit for 287 days time served in the Osceola County Jail. On count 5, I'll adjudicate you guilty of the first-degree misdemeanor. I'll sentence you to 287 days in the Osceola County Jail with credit for 287 days time served. The sentences on counts 1, 2, 3, 4, 5 are concurrent with each other and concurrent with the sentence that I'm about to sentence you to in 20 CF 1609. In 20 CF 1609, I'll adjudicate you guilty. I will sentence you to 18 months in the Department of Corrections with credit for 42 days time served. The sentence in this case will be concurrent to the sentence I just announced in 19 CF 3493. State, both of these sentences appear to be a departure sentence based on the Criminal Punishment Code score sheet. Anything that you want to put on the record in regards to the decision to negotiate a departure?
Yes, Your Honor. A couple things. I guess the first one being the 28.05 months, 28 months DOC in 2019 CF 3493 is actually the bottom of the guideline if that case was to plead by itself. If not 20 CF 1609 was to plead by itself, the 18 months is actually higher than what he would score. Additionally, defense did provide some form of mitigation, and we thought that the resolution ultimately was an appropriate one.
Okay.
The final thing I do want to put on the record, not necessarily for the downward departure, is that the victim She is aware of the plea and did not want to be present.
All right. Mr. Roberson, in each of your two cases, I will order you pay all statutorily required fines, fees, and costs. Madam Clerk, can you announce those costs by case number?
In case number 2019 CF 3493, there's $418 court costs, a $100 cost of prosecution, $100 public defender lien, and a $201 battery surcharge for a total of $819. And 20 CF 1609 is $418 court cost, a $100 cost of prosecution, $100 public defender lien, and a $201 battery surcharge for a total of $819 in that case as well. The total of both cases together is $1,638.
I'll order that the cost on these two cases be consolidated into a single payment. Mr. Roberson, I'm going to order within 9 months of your release from the Department of Corrections that you contact the clerk of the court here in Osceola County, set up a payment plan, and begin making payments at a minimum rate of $30 a month towards your costs till your costs are paid in full. Do you understand? Okay. That is the judgment and sentence of the court in these two cases. Defendants remanded to the Department of Corrections to serve his sentence.
Your Honor, have the plea form for 19 CF 3493. Just need to cross out the same part that we did on the other plea form.
I actually wasn't sure that it was on. It was, I'm sorry. All right, and then the last defendant in this group that I'm showing is Bahram Habibzadagan, I believe.
On behalf of Mr. Kiabi.
Okay. Thank you. Mr. Schmier, why are we addressing his case this morning?
This is a competency status hearing. Mr. Hababizian, I can't pronounce his name, I'm sorry, Kiabi, came back from State Hospital. I disputed the State Hospital record or report. I candidly think that he still is incompetent. So Dr. Szyczki was assigned to see him. We have made now 3 attempts to try to talk to Mr. Kiabi. The first time the cameras were being utilized by somebody else, so we couldn't go through the evaluation. Second time, the COs refused to transport the gentleman to the Polycom. They said he was too unstable to be left alone, so we're doing an in-person visit. The secretary is out yesterday and today, so I don't know what date's been scheduled. I looked on my calendar, I did not see it, but the bottom line is the jail wants this evaluation to be done in person because of Mr. Kiavi's alleged instability.
Okay.
I explained that to Ms. Hall already.
So I assume you're asking me to reset a status hearing?
Yes.
How long out do you think it needs to be set in order to facilitate an in-person evaluation?
Hard for me to say. I'm flexible as far as going into the jail. I don't have the doctor's schedule. Hopefully within no more than 4 weeks.
Who's the state on this case? Okay. Ms. Olvera, any thoughts about where I set a new status hearing? You're gonna have to speak up, Ms. Olvera.
Just like council said, 3 to 4 weeks.
All right. Let's go ahead and schedule this. Tabitha, can you tell me what I've got set on August 17th at this point?
You don't have anything to say?
Can you tell me what August 10th is looking like?
There's trials. All the trials are set on that day. Aside from that, it looks like you only have
two other things, a competency status and a status.
All right, I'll reset the defendant for a status hearing on August 10th at 9 a.m. Mr. Schmier, if the evaluation's not been done by then, what I would expect to hear at least on August 10th is this is the day it's scheduled.
Thank you.
And then we could pick a more efficacious next status date. All right, defendant will remain in the Osceola County Jail pending his evaluation and further order of the court. All right, so corrections, that's the end of my first group. Do y'all have anybody from the first group I've not talked to?
That's it.
How long do you think it's going to take to reload with the second group?
If you give me about 10 minutes, sir, I'll try to get them up here.
Okay, so I'm going to go off record and we'll come back in about 10 minutes.
I have one case from the second group. I don't need the person to be here. It's up to you. It's a VOP arraignment. I would not have had this on the docket if I'd known
Okay.
to sign this case.
Tell me who that is.
On page 1, it's Lena Krugman, CF 19-787.
Okay. Are you waiving her arraignment?
Yes, and I'll enter a denial of a violation of probation on her behalf.
Okay.
She has 2 pending cases, one of them which just got transferred to me from Division 301. Those cases are set for the September 2nd pretrial. And the one case is pretty serious. It's a drug trafficking case, so.
Okay. So if I set her status hearing for September 10th, should that give you enough time to get some sense of which direction all these cases are going?
Yes.
All right, Ms. Krugman, I'll enter denial. I'll set her for status hearing on September 10th.
9 a.m.?
Sure.
Thank you.
Anything else this morning, Mr. Schmier?
No, thank you.
All right, so Mr. Seibel,
Yes.
I appreciate your extended stay in the courtroom this morning. I apologize.
Oh, no worries, Your Honor, but I am going to be leaving. I have a hearing that was supposed to be telephonic and before Judge Karsten, but I might as well mosey on over there.
Okay.
And I'm bouncing between some after Judge.
All right, Ms. Cobb, where do we stand in regards to Mr. Loshaw's case, or cases?
I think these cases got reset today to, I guess, show the court Dr. Owen's report. It's in the court file.
Who's the state handling Mr. Loshaw's cases?
Miriam Rouse, on behalf of the state.
Any objection to me relying on Dr. Osis's report?
No objection, Your Honor.
And Ms. Cobb, I assume you don't have an objection to me relying on it? All right. Do you know if it's populated in all of his case numbers?
I believe so.
Okay.
It is.
Okay, thank you, Toby. Okay. And while I'm pulling this up, Ms. Cobb, what are you going to ask me to do at the end of my review of the report? Okay.
just, yeah, if there was any like this, mostly drugs. Yeah, so like something like this. Like this one. Credit card thing, yeah, if there's something like that.
All right, in each of Mr. Loshaw's cases, based on my review of Dr. Osis's report and my prior review of the state hospital's report, I find that the defendant is currently competent to proceed. Ms. Cobb, any thoughts on which pretrial docket I place this on at this point in time?
The next one is the 29th of this month. So I was thinking September.
Well, I can tell you that the September numbers are the highest numbers you've ever seen for a pretrial. So I don't particularly want to add any more there at this point. I suspect once the lawyers actually sit down and look at what they have to say grace over, they're not going to want anything more on September pretrial either.
Yes, sir.
So I was contemplating Wednesday, October 7th.
Yes, sir.
All right, so in each of Mr. Loshaw's cases, I do find that he's competent to proceed, and I will set each of his cases pretrial conference on October 7th. The trial period currently scheduled to begin October 19th. Mr. Loshaw will remain in the Osceola County Jail pending disposition of his cases. All right. Next, Ms. Cobb.
Judge Wooten, that's all I have. May I be excused?
You may. Have a wonderful day. Okay. Mr. Seibel,
Yes, Your Honor.
tell me who you represent.
I represent Ms. Destiny Griffin in 17 CF 740. Judge, we're here for an admission to her violation of probation.
All right, can I have Destiny Griffin? Go ahead and swear her in.
Raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to enter into this case will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Good morning, ma'am. Tell me your name and your date of birth.
Good morning. My name is Destiny Griffin. My birthday is August 26, 1995.
You can put your hand down, Ms. Griffin. Ma'am, you previously were placed on probation in this case for the offense of burglary of a conveyance and grand theft in the third degree. It's now been alleged that you violated your probation. Do you understand the underlying charges and the allegations of violation in this matter?
Yes.
In the courtroom is your attorney, Mr. Seibel. Mr. Seibel, how does she want to resolve this violation?
Judge, at this time, Ms. Griffin will be entering a best interest admission to the violations of probation. The agreed upon disposition with the state is a revoke and termination of her probation, 150 days in the Osceola County Jail with all credit time served. There is a $300 cost of extradition, and then any remaining court cost balances are still outstanding.
State, is this your agreement?
Yes, Your Honor.
All right. And Ms. Griffin, is this how you want to resolve your violation of probation?
Yes.
As you stand here today, are you under the influence of any drugs, alcohol, or other medication?
No.
Have you ever been treated for a mental illness, emotional disturbance, or are you suffering from such at this time?
No.
Do you read and understand the English language?
Yes.
Mr. Seibel, do you have an admission form for me?
I have them. They don't have her signature on them, Judge. So
Okay. Did she go over them with you?
I have discussed them. I did not read them specifically, but I have discussed all of her rights, hearing rights, all those things that she will be giving up. We have discussed the maximums. We have discussed possible defenses. We've discussed the offers. I have no problems moving forward today.
All right, Ms. Griffin, is that correct that you have discussed with your attorney, Mr. Seibel, all the rights you have when you're alleged to have violated your probation?
Yes.
Including your right to have a hearing and require that there be evidence that establishes by the preponderance of evidence that you violated your probation?
Yes.
And having discussed all of your rights with Mr. Seibel, have you decided the best thing to do is to admit that you violated your probation with the understanding that I will sentence you this morning?
Yes.
Has anyone forced, threatened, or coerced you to make this admission?
No.
Other than what's been discussed here in open court, has anyone made any other promises to you about the sentence you would receive?
No.
Are you satisfied with the work Mr. Seibel's done in handling your case?
Yes.
Looks like he's done a good job for you, ma'am. Do you understand, ma'am, if you were not a citizen of the United States, entry of this admission would result in your deportation?
Yes.
Mr. Seibel, do you concede that the affidavit of violation sets out a factual basis for the court to find your client willfully violated your probation?
Yes, Your Honor.
Ma'am, I'm going to accept your admission. I find you alert and intelligent. Your admission is freely and voluntarily entered. You understand the nature of the charges against you, and you're represented by competent counsel with whom you say you're satisfied. I also find a factual basis to believe you willfully violated probation based on the affidavit filed in this case. Is there any legal reason why the court should not now impose sentence, Mr. Seibel?
No, Your Honor.
All right, ma'am, the court having accepted your admission, I'll adjudicate you guilty. I'll revoke and terminate your probation. I'll sentence you to 150, that's 150 days in the Osceola County Jail. I'll give you credit for 138 days time served in the Osceola County Jail. I'll also order that you pay all statutorily required fines, fees, and costs for this violation. I'll order that you pay the $300 in extradition costs payable to the Osceola County Sheriff's Office. And I'll order that you pay any unpaid balance you had from your original case. Madam Clerk, what are those costs?
There's a $100 cost of prosecution, an outstanding balance of $594.92. That, along with the cost of extradition ordered, is $994.92.
Ma'am, if I give you 90 days from your date of release, any reason you can't pay $75 a month towards your cost?
No, I can pay that.
All right. I'll order within 90 days of your release from custody that you contact the clerk of the court, set up your payment plan, and begin making payments at a minimum rate of $75 a month towards your costs until your costs are paid in full. State, do you have a criminal punishment code score sheet and an extradition order?
If I may.
Or an extradition cost order?
If I may approach, Your Honor.
All right. All right, that's the judgment and sentence of the court in regards to Ms. Griffin. She's remanded to custody of the Osceola County Jail to serve whatever balance she has left on her sentence.
Judge, thank you. And if Ms. Griffin, I will be following up with your family. Please just stay in contact with me, okay?
Okay, thank you, Your Honor.
You're welcome. Have a good day, ma'am.
You too.
Judge, thank you very much. That's all I have. If I may be excused.
Have a wonderful day.
You too. It's great to see everybody. And, hopefully we can do this more often.
Well, sure. State, I got a duplicate extradition cost order. Y'all can have that back.
If I may approach, Judge.
You may. Okay. Who's next? Okay.
CF 2224, Tina Louise Darden. VOP arraignment.
Let's have Tina Darden come up. Let's go ahead and swear her in.
Do you solemnly swear or affirm the testimony you're about to enter into this case will be the truth, the whole truth, and nothing but the truth, so help you God?
Good morning, ma'am. Tell me your name and your date of birth.
Good morning. Tina Darden, September 19th, 1966.
Ms. Darden, you previously were placed on probation for the offense of possession of drug paraphernalia. It's now been alleged that you have violated your probation. Mr. Carbone, your public defender, is here in the courtroom. Mr. Carbone, how does she want to proceed in regards to this allegation of violation?
Your Honor, I just have one clarification. I did get an offer this morning, but Ms. Morales, is that from the VOP arrest? Is the 90 days from the VOP arrest?
From the VOP,
Okay. Your Honor, we'd like to enter a denial at this time.
All right. Ms. Darden, I'm going to enter denial on your behalf at this point in time. I will set you for a violation of probation status hearing on August 13th at 9 a.m. If your case is going to resolve before then, Mr. Carbone will docket it and we'll get in and resolve it ahead of time. All right?
Yes, sir.
Okay, have a good day.
Thank you.
You're welcome.
May I be excused?
You may. Have a good day, Mr. Carbone. All right, next.
I'll go next, Your Honor.
All right.
I just have one plea with Harrison.
Let's have Stephen Harrison come up. Good morning, sir. Let's swear him in.
Raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to enter into this case will be the truth, the whole truth, and nothing but the truth, so help you God?
All right, good morning, sir. Tell me your name and your date of birth.
My name is Stephen Harrison, 6/17/89, June 17, 1989.
All right, Mr. Harrison, as you stand here, you have one matter before the court. It is 19 CF 07. It's a case where you previously were placed on probation. Looks like for attempted burglary of a dwelling, armed trespass, and resisting an officer with violence, and battery on a law enforcement officer. It's now been alleged that you have violated your probation in this matter. Ms. Rosas, your public defender, is here in the courtroom. Question for the attorneys before we proceed further. I don't see that DOC tagged this as a violent felony offender of special concern. State, what's your position as to whether any of these four offenses qualify him for that designation?
Maria Morales covering for Asa Gonzalez. I didn't see anything that was mentioned. I'm trying to get everything open now. I haven't gotten a chance to.
Ms. Rosas, what's your position as to whether any four of these offenses qualify him as a violent felony offender of special concern?
Well, Your Honor, as I read the statute, I do believe that attempted burglary of this type would be one of those charges, but
That was my recollection, but I didn't want to immediately make that assumption. I also believe that battery on a law enforcement officer would probably be considered a qualifying offense. It's a felony offense, it's violent in nature, so.
And he
All
does
right.
have a prior.
So, Ms. Morales, are you covering this for Ms. Gonzalez?
I am, Your Honor.
So did she give you any insight as to what positions she was taking on the, that issue?
Not specifically, but she did indicate that this is a stipulated downward departure, and that the victim has been spoken to. So I would believe that any concerns that would be raised based on that have been addressed, that the resolution would be.
Ms. Rosas, go ahead and tell me what the proposed resolution is.
it would be 12 months Osceola County Jail from the date of Yoki arrest, which was February 1st, 2020, and to reinstate him on probation with all the same terms.
Ms. Morales, do you want to reach out to Ms. Gonzalez and find out what her position would be on whether the defendant currently poses a danger to the community and whether she would want to offer evidence on that point?
I will, Your Honor, but I believe we don't have any evidence to offer, but I'll double check.
Is it correct that the sole allegation of violation is testing positive for using cocaine, or are there other allegations?
Yes, Your Honor.
Mr. Harrison, just so you understand, because of the original charges that you pled to, whenever you are alleged to have violated your probation, you're classified as a violent felony offender of special concern, and the law requires me to make certain findings at the time that I find you in violation. I'm not necessarily suggesting that I'm not going along with the resolution, but I think the law requires me to find out what the state's position is, whether they're going to argue that you're a violent felony offender of special concern. It also requires me to look at the underlying case and the allegations of violation and make an independent determination on that. So it's not anything particular to you. It's just the way the law is written. I have to do these things. That's why this is taking longer than you may have assumed. Let me make this suggestion. Can we pass and take care of some other things while we wait to see what Ms. Gonzalez's position is going to be? All right, Ms. Harrison, why don't you grab a seat, and I'll recall you in a few minutes when I know what the assigned prosecutor wants to tell me on these points. All right, Mr. Johnson?
Yes, Your Honor. I have two remaining clients.
Okay.
First one was where Valerie Dixon, 19 CF 2287. This is set for plea status this morning.
Okay. Is Ms. Dixon present? This was a reset from last week, correct?
Yes, Your Honor.
Okay.
This is a case where Ms. Dixon was found competent to proceed after returning from state hospital. She has a credit time served offer that we've been trying to convey. I was able to speak with her this morning for the first time over the phone. And the state and I were speaking about trying to have this where we could resolve this morning.
Okay.
Was potentially pleading to the charge 2, possession of drug paraphernalia, which is a misdemeanor offense. And yeah, and it'd be an adjudication of guilt with credit time served. I discussed that with Ms. Dixon. She would like to take that plea.
Okay.
Just we don't have a plea form, so what I did do is I went through the rights that she would have at a trial, basically the gist of a plea form.
Okay. And it would be a misdemeanor time served plea?
Yes, Your Honor.
I'm showing her with 325 days time served.
That's all right.
Let's go ahead and swear Ms. Dixon in.
Raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to enter into this case will be the truth, the whole truth, and nothing but the truth, so help you God?
All right, good morning, ma'am. Tell me your name and your date of birth.
Valerie Dixon, 4/13/1980.
Ms. Dixon, you have one case with 2 charges. Charge 1 is possession of cocaine, a 3rd-degree felony, punishable by up to 5 years in prison. Count 2 is possession of drug paraphernalia, a 1st-degree misdemeanor, punishable by up to 1 year in the county jail. Do you understand those charges?
Yeah.
Do you understand the maximum possible punishment you could receive?
Yes.
The state attorney's office is willing to resolve your case by having you plead count 2, the possession of paraphernalia. They would dismiss or drop count 1. And the agreement is I would sentence you to the 325 days you already have in the Osceola County Jail, which means you would get out of jail today. Has that been explained to you?
Yes.
And have you decided this is the best way for you to resolve your case?
Yes.
And your attorney, Mr. Johnson, is standing here in the courtroom. He indicated that he had a conversation with you where he explained to you all the rights you have and the rights you give up when you enter a plea. Did you have that conversation with him?
Yes.
And do you feel like he explained everything to your satisfaction?
Yes.
Did you have any questions about your rights that he could not answer?
No.
And have you decided the best way for you to resolve this case is to take the time served plea on count 2, understanding that count 1 will be dismissed or dropped?
Yes.
Do you understand that means we're not going to have a trial in your case and the public defender is not going to do any more work on your case? Do you understand that?
Yes.
Has anyone forced, threatened, or coerced you to enter this plea?
No.
Other than what's been discussed here in open court, has anyone made any other promise to you about the sentence you'd receive?
No.
Are you satisfied with the work Mr. Johnson's done in handling your case?
Yes.
Do you understand, ma'am, if you were not a citizen of the United States, entry of this plea would result in your deportation?
Yes.
State factual basis for count 2.
Yes, Your Honor. On June 21st of 2019, law enforcement was patrolling the area when they saw a defendant who they recognized from previous encounters and ran her name through the system, verified that she had a warrant. When the warrant was executed, the defendant dropped a pipe on the ground. That pipe field tested positive for cocaine, which FDLE confirmed. It was just residue, though, on the smoking device, which is why we're just going forward on the paraphernalia.
Mr. Johnson, any objection to that factual basis as to count 2?
No, Your Honor.
All right, ma'am, I'm going to accept your plea. I find you alert and intelligent. Your plea is freely and voluntarily entered. You understand the nature of the charges against you, and you're represented by competent counsel with whom you say you're satisfied. I also find a factual basis for the acceptance of the plea. Is there any legal reason why the court cannot impose sentence on count 2?
No, Your Honor.
All right, Ms. Dixon, the court having accepted your plea as to count 2, I'll adjudicate you guilty. I'll sentence you to 325 days in the Osceola County Jail with credit for the 325 days time served. I'll order that you be released from the Osceola County Jail on this case only today. I'm going to order that you pay all statutorily required fines, fees, and costs. Madam Clerk, can you announce those for the misdemeanor plea on count 2?
$273 court cost, a $50 public defender lien, and a $15 drug paraphernalia surcharge for a total of $338.
Ms. Dixon, let me ask you this. When was the last time you had a job?
I never had a job.
And do you receive, when you're not in jail, do you receive any type of disability or other assistance from either the federal or state government?
Yes.
What do you receive?
Disability.
All right.
Yeah.
How much, does that come directly to you or does it go to somebody who is your?
Directly to me.
All right. And what do they give you each month?
It was, I can't remember how much, I think it was about $748.
Okay. Here's what I'm going to do, ma'am. Based on your testimony, I'm going to order that your cost be reduced to a civil judgment. I'm not going to put you on a payment plan, all right?
Okay.
All right. State, do you have an announcement on count 1?
Yes, Your Honor. As to count 1, state announces an oral process, and I'll follow up with any files.
Mr. Johnson, anything else in Ms. Dixon's case?
No, Your Honor, just thank you.
All right. Madam Clerk, anything else? All right. That's the judgment and sentence. Ms. Dixon can be released on this case only. Good luck to you, ma'am.
Thank you.
You're welcome. All right. And Mr. Johnson, you had one more, is that correct?
Yes, Your Honor. I have a motion to set bond in Jose Humberto Perez's cases, but he's going to require the assistance of a Spanish interpreter. I don't know.
Okay.
I'm ready on Mr. Harrison.
Okay.
Let's do this. Let's recall Mr. Harrison. All right, Mr. Harrison, the state attorney in the courtroom is going to update me on what the state attorney who is assigned to your case is indicating. So go ahead, Ms. Morales.
Your Honor, so I did confirm that state would not be presenting any evidence or further argument beyond the score sheet that I believe Your Honor already has. She did reiterate that the concerns about him being a danger have been addressed in the proposed resolution. So.
And I believe you previously indicated that the victim on the underlying charge has been consulted and is in agreement with this resolution?
Yes, Your Honor, and there is a victim impact statement that I have been requested to read on the record.
Well, let's do this before I go all the way through the colloquy. Why don't you read that victim impact statement to me to see what impact it's going to have on my comfort level with this resolution. So go ahead.
Yes, Your Honor. This is from Ms. Catherine Duran. This letter is for the judge. I'm writing this today because I would like to say something regarding this. It's been years that I've lived in fear. I've lived through so much pain physically and mentally, even years after my divorce with this man. I am a single mother that does not have help, and my daughter is suffering more and more because of her father being so selfish. She will be 8 years old, and she is also mentally destroyed because she doesn't have a sane father to look up to. I just want you to please have this man get mental help professionally with his anger and drug problem. If he doesn't end up getting fixed while you have him, we will go through this crazy attacks, and he will not give my daughter a normal father-daughter relationship. If it could be saved, please help us look into his record with me. This is not normal. And this cannot keep happening to me and my baby girl. Thank you.
Ms. Rosas, here's what I'm struggling with at this point. The defendant, starting when he's a juvenile, has a string of battery offenses, violations of probation, moving into life as an adult, an aggravated assault with a deadly weapon, battery on juvenile detention facility staff, then a burglary of dwelling in 2010, a DV assault in 2015, violation of PTR conditions on a domestic violence case, violation of domestic violence injunction, and then the attempted burglary of a dwelling, armed trespass, and battery on a law enforcement officer that were the underlying charges in this case. So that paints a pretty negative picture of your client based on the factors that I'm supposed to consider in determining whether I find that he poses a danger to the community at this point in time. Here's my suggestion. I think I'd be more comfortable if Ms. Gonzalez was present in person rather than have Ms. Morales attempt to discuss or argue on her behalf why this is an appropriate resolution and why I should not be concerned about the danger to the community. So my inclination is to allow y'all to reset this.
We just have a moment. I think Ms. Gonzalez might have been considering being in the office for part of the day today. If she happens to be here, if the judge is okay, maybe addressing it after the other one.
I will, it just depends. I've got another matter after Mr. Johnson's plea. I mean, I'm not going to tell him to haul Mr. Harrison back at this point. If we can take care of it this morning, we can take care of it. I just want to be very candid with the attorneys that the statute, if I make that determination, suggests that I should consider sentencing up to the maximum.
Right.
There's no requirement that I do that, but by the same token, it's difficult for me to see giving him less than the law requires if I find that he's a danger to the community. So, but I am not going to deny you an opportunity to make an argument on that, Ms. Rosas. I would be more comfortable Ms. Gonzalez is available. So, Mr. Harrison, grab a seat. We'll see if the assigned prosecutor can get to the courtroom and allay my concerns about the proposed resolution, and we'll go from there. Otherwise, I will reset your case so the assigned prosecutor can be present and the lawyers can argue to me why I should go along with the resolution, all right? So for right now, just grab a seat. All right. So, Mr. Johnson, we're going to do the bond hearing on Mr. Lopez, if I have an interpreter.
Yes, sir.
Let me see if I've got an interpreter. Good morning, this is Judge Wooten. Can the interpreters hear me? Can the interpreter hear the court? Let me try again.
Good morning, Your Honor. This is Alan Figueroa, Assistant Vice Master Interpreter.
Good morning, Mr. Figueroa. This is Judge Wooten down in Osceola County. I'm going to be conducting a bond hearing. The defendant is going to be at the Osceola County Jail. His attorney is here in the courtroom. The defendant has 6 cases on the docket, one of which is 2018 CF 2860. Do you need the other 5 case numbers?
I could, Your Honor. Yes, please.
18 CF 3262, 18 CF 4501, 19 CF 638, 19 CF 1821, and 19 CF 2160.
Thank you.
All right, let me see if they can, corrections, can you get Mr. Perez up to the microphone?
Yes, sir, Your Honor.
All right, he is at the microphone, Mr. Figueroa. Let's go ahead and swear him in.
Levante la mano derecha, señor, por favor.
Do you solemnly swear or affirm the testimony you're about to enter into this case will be the truth, the whole truth, and nothing but the truth, so help you God?
Jura, promete que el testimonio que...
Good morning. Go ahead, Mr. Figueroa.
Good morning, good morning. Good morning, Judge.
So, Mr. Figueroa, will you please interpret the following for me?
Sure thing, Your Honor.
So, Mr. Perez, we're using the Spanish interpreter.
Señor Pérez, estamos usando el intérprete de español.
Even if you think you understand what I'm saying in English,
Aunque usted crea que entiende lo que yo digo en inglés,
I want you to wait for the interpreter to interpret to Spanish.
quiero que espera que el intérprete lo interprete al español.
I want you to give your answer in Spanish and then wait for the interpreter to interpret back to English.
Quiero que dé su respuesta en español y que espera que el intérprete entonces interprete su respuesta al inglés.
That way, I'm sure you fully understand what's being said.
De esa manera yo estoy seguro de que usted entiende lo que yo digo.
And I fully understand the answers you're giving. Does this make sense?
Y que yo entiendo las respuestas que usted da. ¿Le parece bien?
Sí, sí.
Yes.
Standing in the courtroom is Mr. Perez's attorney, Mr. Johnson from the Public Defender's Office.
Aquí presente en la sala está el señor Johnson, defensor público del señor Pérez.
Mr. Johnson, tell me what your client is asking me to do today in these 6 cases.
Señor Johnson, dígame lo que su cliente desea pedir hoy en día en estos 6 casos.
Yes, Your Honor. In Mr. Perez's 6 cases that are set on the docket this morning, he's wishing to have a bond set. In these cases, he's currently held on a 0 bond and is asking for a total bond of $2,000. If I could elicit testimony from my client.
Sí, señoría. Mi cliente en este momento desea pedir que se le emita fianza de estos 6 casos. En este momento él no tiene ninguna fianza y desea pedir que se le emita una fianza para un total de $2,000.
You may proceed and question your client.
Adelante con el testimonio de su defendido.
Good morning, Mr. Perez. I'm going to ask you a few questions for your bond motion today, okay?
Buenos días, señor Pérez. Le voy a hacer una serie de preguntas con respecto a el pedimento de fianza. ¿Bien? Okay.
Okay. Are you a resident of Osceola County, Florida?
¿Es usted residente en el condado de Osceola de la Florida?
Eso es correcto.
That's correct.
And how long have you lived here?
¿Hace cuánto que ha vivido aquí? 20 years.
Okay. And at this time, on these 6 cases that we have this morning, do you currently have a bond on those cases?
En estos 6 casos por los que nos encontramos aquí esta mañana, ¿usted tiene alguna fianza en alguno de estos 6?
Me parece que en el último caso.
I believe in the last case.
In that case, we're not having the bond motion on this morning.
En ese caso no tenemos una audiencia para fijar fianza esta mañana.
Okay.
I'm sorry, I didn't understand.
It's okay, I'll move on.
No hay problema, seguiré adelante.
Prior to your confinement in the Osceola County Jail, were you working?
Antes de ser encarcelado en la cárcel de Osceola, ¿usted estaba trabajando?
Sí,
Yes.
What were you doing?
¿A qué se dedicaba?
demolition.
Demolition.
Demolition? Okay. And at this time, do you have any physical conditions that you need medical attention for?
¿Sufre usted de alguna condición física en estos momentos por la que necesite cuidado médico?
Sí, correcto.
Yes, I do.
What is that?
¿Cuál?
Tengo unos dedos en la mano, 2 dedos que tengo que operarme, porque no me cierran ni el derecho normal, pero eso no me pide trabajar, pero tengo que recibir una
I'm sorry to interrupt, Your Honor. I'm just going to request for the defendant to approach the mic. I can barely hear him. Señor, si se puede acercar bien al micrófono y hable en voz más alta para poder escucharle, por favor.
Ok, yes, tengo 2 dedos de mi mano que necesitan cirugía. La persona que quiere trabajar, pero necesito una cirugía porque me da mucho dolor y también necesito tomar medicación.
Okay. Yes, I have 2 fingers on my hand that require surgery, and I require the surgery because of the pain that it causes in my hand, and I need my medication.
And when we're talking about medication, are you talking about mental health medication?
Y cuando hablamos de medicamentos, ¿se refiere a medicamentos para su salud mental?
Correcto, sí.
Correct, yes.
Are you currently receiving any medication for any mental health conditions at the Osceola County Jail?
¿Está recibiendo usted algún medicamento para su condición de salud mental en la cárcel?
No, aquí no me proveen de nada.
No, I'm not being provided with anything.
Okay. Prior to being in the Osceola County Jail, were you going to Park Place for any mental health conditions?
Y antes de ser encarcelado en la cárcel de Osceola, ¿usted acudía a Park Place para terapia por su salud mental?
Sí, eso es correcto, con la señora Penny y la doctora, una doctora que se llama Ann Rosa.
Yes, correct, with Miss Penny and the doctor. I'm sorry, the interpreter couldn't catch the doctor's name.
Okay. Would that be Penny Dickerson at the Park Place Behavioral Center?
¿Sería Penny Dickerson en el programa de Park Place?
Sí, estaba en Park Place.
Yes. Yes.
Okay. If you were to be released on bond in these cases, where would you end up living?
Si usted quedaría en libertad bajo fianza en estos casos, ¿dónde estaría viviendo?
Con mi hermana en el apartamento de ella, que siempre yo he vivido ahí.
With my sister at her apartment where I've always lived.
Okay. And is that apartment at 2435 Academy Circle East, apartment 203, Kissimmee, Florida?
Y ese es el 2435 Academy Circle East, apartamento 203 en Kissimmee, Florida.
Eso es correctamente.
That's correct.
Okay. Do you currently have a passport?
¿Tiene pasaporte en este momento?
No, no tengo pasaporte.
No, I don't.
No lo necesito, soy ciudadano americano.
I don't need it. I'm a U.S. citizen.
Nací en Estados Unidos.
I was born in the U.S.
Okay. And let's talk about your family. Do you have any family that lives in Kissimmee, Florida?
Y vamos a hablar de su familia. ¿Tiene algún familiar que vive en Kissimmee?
Sí, correcto. Tengo toda mi familia aquí. Tengo mis 4 hijos, mi esposa, mis 2 hermanas, mis tíos y mis nietos, 5 nietos.
Yes, I have my 4 kids, my wife, my 2 sisters, my uncles, and my 5 grandchildren.
Okay. And if you were released, would you comply with any no contact orders or any other orders given by the court?
Y si usted queda en libertad, usted pudiese cumplir con cualquier orden de contacto que esté emitida.
No entendí porque se encortó la llamada.
I didn't understand because the sound went off. I'll repeat the question again for for the defendant. Si usted quedase en libertad bajo fianza, usted pudiese cumplir con cualquier orden de prohibición de contacto que le emitan.
¿Cómo así? No te entiendo la pregunta bien. Explícame.
What do you mean? I don't quite understand that question.
If the judge ordered you to do something while you're on bond, would you do that?
Si el juez le ordena que tiene que hacer algo mientras se encuentra en libertad bajo palabra, ¿usted lo haría?
Correcto, claro que sí. Yo no me
Of
quiero
course
meter
I
en
would.
problemas.
Of course I would. I don't want to get in trouble.
And would you appear at any future court dates?
¿Y usted comparecería ante todas las fechas de comparecencia al tribunal?
Todo el tiempo, cuando he necesitado anteriormente, yo he ido a la corte. Todo el tiempo, sí, claro que sí.
Every time that I've been summoned, I've showed up to court, yes.
Okay, no further questions right now, just argument.
Yeah, no tengo más preguntas.
All right, any cross-examination from the state attorney?
No, Your Honor.
All right,
Contrainterrogatorio de parte de la fiscalía, no, su señoría.
any additional witnesses, Mr. Johnson?
No additional witnesses, we just asked to take notice of the court file as well.
¿Algún testigo adicional? No hay más testigos adicionales, su señoría.
Mr. Johnson, I think the one thing that's missing from the record at this point is Mr. Perez actually was on bond in all 6 of these cases, correct?
Yes, Your Honor.
Señor Johnson, creo que lo que falta para que conste en actas es que el señor Pérez se ha encontrado en libertad bajo fianza en estos 6 casos, ¿correcto? Sí, su señoría.
So why is he sitting in the Osceola County Jail if he already has a bond on these 6 cases?
Entonces, ¿por qué él está ahora en la cárcel del condado de Osceola si él ya tenía fianza en estos casos?
In these 6 cases, he's currently at a 0 bond because there's a new case, 19 CF 3283, which we did not bring up for a bond hearing today because he currently has a bond on that case. But since that case came about, there was an order 0 bonding him on these 6 cases.
His bonds, go ahead, Mr. Figueroa.
Thank you. La razón por la que él no tiene ninguna fianza en estos 6 casos en estos momentos es porque surgió un nuevo caso, el 19 CF 3283, que no hemos mencionado porque ya él tiene una fianza fijada en ese caso, pero a raíz de ese caso se anularon las fianzas en los otros 6.
So in reviewing the 6 cases set for today, I see in each of the 6 cases, it appears that there was an order revoking bond based on the probable cause finding in 19 CF 3283.
Veo acá en la orden judicial que en estos 6 casos se habían anulado las fianzas debido a los problemas que surgieron a raíz del 19 CF 3283.
So don't I have to consider that in determining whether it's appropriate to set bond in these 6 cases now?
¿No tendría yo que tomar eso en cuenta también para determinar si sería posible fijar fianza en estos 6 casos también?
Yes, Your Honor. The only reason why we didn't have it in front of this court is because, like I said, he currently has $5,000 bond, and these cases are 0 bonded, so we were looking to try and get bond on these cases.
Well, I understand that.
Sí, señoría, la única razón por la que no habíamos mencionado este caso es porque tiene una fianza en este momento de $5,000 y en los otros casos no tiene ninguna. Estábamos tratando de fijar fianza en los otros casos.
Mr. Johnson, would you agree as a matter of law, when there's a probable cause finding that a new crime has been committed while someone is out on bond, that it's allowable to revoke the bond, and then whether the defendant bonds back out is within the discretion of the court?
Pero, licenciado, ¿no estaría usted de acuerdo que, de acuerdo con la ley, cuando surge un nuevo ilícito en el que hay indicios de criminalidad, mientras un acusado se encuentra en libertad bajo fianza en otros casos, que existe el derecho de revocar la fianza en esos otros casos y la determinación si se emite nueva fianza o no, dependería entonces del juzgado?
Yes, Your Honor.
Sí, su señoría.
So, what argument do you have that I should put the defendant back out on bond given the allegations in 19 CF 3283?
Bien, ¿qué argumento tiene usted entonces para que yo vuelva a fijar fianza para este acusado, dado los alegatos del 19 CF 3283?
The argument that we would have is that prior to picking up 19 CF 3283, Mr. Perez was going through competency proceedings in all these cases. A large part of the reason for these cases, defense would argue, is his ongoing competency. Since he's been in custody on this last case, he's been found competent to proceed now and appears to be significantly stable compared to how he was before. So defense is asking to set a, and I apologize to the interpreter for going on, but defense is asking to set a bond in these cases because given that he was picking up new charges, his mental health circumstances have changed, which I believe, as well as speaking with Mr. Perez, changes the outlook as to picking up any further charges upon his release if the court would be inclined to.
Mr. Figueroa, try to interpret all.
Don't worry, Your Honor. I've been taking notes. Thank you. Su señoría, la razón es que antes de que surgiera el caso 19-3 CF-3283, el señor estaba esperando determinación si era competente o no para enfrentar juicio en los otros 6 casos. Dada esa la razón por la cual él se encuentra en libertad bajo fianza. Se ha determinado recientemente bajo el caso 19 CF-3283 que él es competente para enfrentar juicio y que su salud mental se encuentra ahora en un estado estable comparado a como estaba antes. Quisiéramos indicar que esa es la razón por la cual surgió este nuevo cargo debido a el estatus de su salud mental en ese entonces, la cual quisiéramos indicar que ya ha cambiado y se encuentra estable, por lo que sería justo fijar una fianza en los nuevos casos ya que él está en un estado estable.
Right. State Attorney, what's your position on whether I should consider a bond?
Fiscalía, ¿cuál es su opinión con respecto a si se emite una fianza?
Yes, Your Honor. While I make an argument, could I?
Well, get closer to a microphone first.
Yes, Your Honor. While I make an argument, can I approach so we can present the score sheet?
You may.
Se me permite hablar, su señoría, mientras hago el argumento para presentar la hoja de cálculos. Adelante.
Yes, Your Honor. And at this time, the state would respectfully request the court to hold the zero bond on all the previous 6 cases. As stated, the defendant has had multiple issues with competency. However, every time this defendant has been given a chance to bond out of jail, he has committed a new law offense. The state also has a concern with the current case, the 19 CF 3283. Although the previous cases were of grand theft and resulted with victims of facilities, stores, the victim in this case now the state has a concern that now the victims are escalating from facilities to actual to people. So at this time, the state would request that the judge look at the totality of the circumstances surrounding this defendant's previous cases and the current 19 CF 3283 and issue a no bond.
Sí, su señoría. La Fiscalía quisiera pedir que, dados los hechos y dadas las circunstancias, se mantenga la determinación de cero fianza para los otros 6 casos. Este defendido ha tenido ya varios incidentes con respecto a su salud mental en los otros 6 casos, por ejemplo, y dada también el hecho de que se le han dado ya oportunidades para quedar en libertad bajo fianza, y lo que ha hecho es que ha incumplido con nuevas leyes, incurriendo nuevos casos, como es el caso del actual que tenemos ahora, el 19 CF 3283. Los otros 6 casos, que eran de hurto en mayor cuantía, habían sido afectados, eran las facilidades, los edificios y los locales, pero si nos fijamos en la totalidad de todos los casos, hemos visto que ahora hay víctimas. Ya ha bastado de solamente perjudicar a objetos como localidades y lugares en físico, ya ahora está perjudicando a personas en sí, que son las nuevas víctimas. Queremos pedir que se base en la totalidad de todas las circunstancias, no solamente de los casos previos, sino también del caso actual, para que se acate a la determinación de cero fianza en los otros 6 casos.
Mr. Johnson, have you seen the Criminal Punishment Code score sheet, and are you currently challenging any of the history?
Señor Johnson, ¿está usted de acuerdo o le ha echado usted un vistazo a los cálculos y desea usted disputar alguno de esos cambios?
I have seen the score sheet and I'm not currently challenging it.
He visto la hoja de cálculos y no la estoy disputando en este momento.
I'm going to deny the request to set bond in these 6 cases. I see that the defendant has a criminal history going all the way back to 1987. It appears to be a consistent, ongoing history. It's quite possible that that history in part is fueled by a mental health challenge that's difficult for him to manage. However, while it's mitigating in some aspects, it also causes the court concern about his ability to manage his mental health condition while he's on release, given the facts of 19 CF 3283, which suggested a very violent interaction with individuals. He's charged with burglary of a dwelling with an assault or battery therein. If that case goes to trial and he's convicted, then he's looking at a substantial period of time in the Department of Corrections. Under those circumstances, I find that he poses a risk to the community. I don't believe any conditions of release would ensure his future appearance and the safety of the community while his case is pending. For those reasons, I'm going to deny the request for bond in the 6 cases.
Voy a denegar el pedimento para que se fije fianza en los otros 6 casos. Me he fijado que el acusado tiene antecedentes bastante extensos que se remontan hasta el año 1987 y parece que es algo concurrente y que sigue ocurriendo. Entiendo que muchos de estos pueden ser arraigados a raíz del problema de salud mental, lo cual me parece que es difícil para él mantener bajo control, pero dado los hechos del caso I-19CF-3283, en el que no solamente estaba la entrada ilícita con fines delictivos, sino que también hubo violencia y hubo agresión física, si él fuese hallado culpable de este ilícito hoy en día en un juicio, estaría enfrentando bastante tiempo que tendría que pasar en prisión. Así que, dado todo esto y el hecho de que yo determino que él tiene una gran dificultad en mantener su salud mental bajo control, determino que él sería un riesgo para la comunidad y que también sería un riesgo para que pueda comparecer cuando sea convocado a comparecer al tribunal. Así que, dado el riesgo a la comunidad y el problema que él tiene desde hace años, yo determino que no sería lo más prudente en este momento emitir fianza para esos 6 casos.
Do we have court dates on the 6 cases that were set for bond hearing today?
¿Tenemos fecha fijada para los 6 casos por los que nos encontramos aquí hoy?
Set for September 2nd, pretrial.
All right, then there's set for September 2nd pretrial.
Están fijadas para la vista preparatoria el 2 de septiembre. Bien, entonces el 2 de septiembre será la vista preparatoria.
All right, that's the order of the court in regards to Mr. Perez.
Esa es la orden del juzgado con respecto al caso del señor Pérez.
All right, Mr. Figueroa, I think that is the end of our need for your services this morning.
Not a problem, Your Honor.
Have a good day.
You as well.
All right, do we have Cashton Kidd? He should be on my 11 a.m. docket. He's set for hearing at 11 a.m.
Yes, sir, and he is also an active COVID situation.
Okay, so Mr. Burnham, why don't you come up?
Morning.
Morning, Mr. Burnham.
We're here for initial appearances. So the folks you'll be interpreting for do not have the headset on. We'll first call up case 20MM1674, State versus Angel Padilla Colon.
Ángel Padilla Colón, acérquese.
All right, good afternoon, sir. Please tell us your name.
Buenas tardes, señor. Diga su nombre.
Ángel Padilla Colón.
Ángel Padilla Colón.
Ms. Padilla Colon, you are here because you've been arrested on a charge of battery.
Está aquí porque lo arrestaron por un cargo de agresión física.
The bond is presently set at 0.
No se le concede fianza actualmente.
Perdón, no lo entendí bien. ¿Me puedes repetir?
De momento no se le da fianza.
Okay.
I'm told that there is a person who wants to provide some testimony, so we'll hear that testimony before we proceed further.
Escucho testimonios. Hay una persona que tiene un testimonio.
And Mr. Leal, I'm told the witness also needs the interpreters, and she'll be at the lectern also without the headset. So, ma'am, if you'll please raise your right hand.
Levanta la mano derecha, señora.
You solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
Jura y afirma que el testimonio que dará será la verdad, toda la verdad y nada más que la verdad.
Sí.
¿Jura?
Sí.
Yes.
All right, you can put your hand down, ma'am.
Puede bajar la mano, señora.
Please tell us your name.
Díganos su nombre, señora.
Carmen Prieto Martínez.
Marlene Prieto Martínez.
Okay. Ms. Martinez, you are listed as a named victim in the case involving Mr. Padilla Colon.
Señor, aparece aquí en la anotación como la víctima en el caso del señor Padilla Colón.
The court is considering conditions of release.
La Corte está considerando alguna condición de liberación.
And I would be interested in your input in that matter.
Y usted tiene también algo que aportar.
No.
First, let me ask you this. Are you asking for Mr. Padilla Colon to be allowed to have contact with you while this case is pending?
Usted está pidiendo que se le permita al señor Padilla Colón tener contacto con usted mientras este caso está pendiente.
Sí.
Yes.
Are you afraid of Mr. Padilla Colon?
¿Usted le tiene temor al señor Padilla Colón?
No.
No.
Has any incident like this happened in the past between you?
¿En el pasado han habido incidentes de este tipo entre ustedes?
No.
No.
If something like this were to happen again, would you hesitate to call law enforcement?
Y si vuelve a pasar algo así, ¿usted estaría dispuesta a llamar a las autoridades para protegerse?
Sí.
Yes.
You would hesitate, or you call law enforcement?
Sorry, the interpreter's having a hard time hearing.
Okay, you would hesitate, or you would call law enforcement if something happened like this?
Si pasa así, ¿usted llamaría a las autoridades o dudaría en llamar a las autoridades?
En un futuro, si fuera una violencia, sí, lo haría.
Yes, if there is some violence, yes, I would go ahead and call.
Okay, thank you. State any
Nothing beyond the court's inquiry.
Thank you, ma'am.
No. Gracias, señora.
Does pretrial release have any prior history on Mr. Padilla Colon?
The defendant has no locals, has history out of New Jersey. Back in 2018, one arrest, aggravated assault, domestic, those charges were dropped, and unlawful possession of a weapon. That is all, Judge.
De la historia que tiene de antecedentes, usted es uno del 2018 que viene de Nueva Jersey. También hubo un ataque agravado, pero ese cargo se retiró, al igual que el de la tenencia de armas.
Yes.
Okay. All right, Mr. Padilla Colon, I'm going to set bond in your case in the amount of $100.
Señor Padilla Colón, en su caso voy a poner una fianza de $100.
It will be conditioned upon supervision by pretrial release.
Estará bajo la supervisión del Departamento de Libertad Provisional.
If you do postpone, you will not have any hostile contact with
Cut off.
Carmen Martinez.
Cut off.
Sí, no tengo la fianza ahora mismo, donde no tengo dinero. ¿Dónde la voy a prestar? ¿O dónde la puedo dar?
I'm sorry, there's conversation going on that's, Ms. Leal, are you still with us? Sorry. Yeah. All right.
Your Honor, yeah, the audio was totally lost.
Okay. You're back with us. Okay. Mr. Padilla-Colon, I'm setting bond in the amount of $100.
Así es, señor Guaya Colón, son $100 de fianza.
It is conditioned upon supervision by pretrial release.
Bajo la supervisión del Departamento de Libertad Provisional.
If you do post bond, you will not have any hostile contact with Carmen Martinez.
Si usted puede salir bajo fianza, no puede tener contacto con hostilidades con la señora Carmen Martínez.
Or with Juan Concepcion Prieto.
O señor Concepción Prieto.
That means no pushing, no shoving, no biting, no scratching, no fighting.
Nada de empujones, ni empellones, ni tropezones, ni golpes, ni maltrato, ni nada de eso.
You will also not possess any weapons or firearms.
Tampoco rasguños, tampoco posesión de armas de fuego.
The Public Defender's Office is appointed to represent you in this case.
Y en este caso, la Defensoría Pública quedará designada para representarlo.
Your next court date will be
Next court date, if still in jail, July 23rd. If out, August 14th in courtroom 4E at 2:30 p.m.
Si está todavía en la cárcel, entonces la próxima comparecencia será el 23 de julio. Pero si ya ha salido, será el 14 de agosto en la sala 4E a las 2:30 de la tarde.
Thank you, sir.
Gracias, señor. Okay.
Mr. Leal, we have an additional case, Jose Luis Marrero. And for your records, this is case 20 FW28. All right, good afternoon, Mr. Marrero. If you'll please raise your right hand.
Buenas tardes, señor Marrero. Por favor, levante la mano derecha.
You solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
Juro y afirma que el testimonio que dará será la verdad, toda la verdad y nada más que la verdad.
Sí, señor.
Yes, sir.
Please tell us your name.
Díganos su nombre, por favor.
José Luis Majero.
José Luis Marrero.
Mr. Marrero, what is your date of birth?
Señor Marrero, ¿cuál es su fecha de nacimiento?
6/8 del 48.
June 8 of 1948.
Mr. Marrero, as we discussed, I believe, last week, you've been arrested on a warrant out of the state of Pennsylvania for failure to appear on a charge of driving while under the influence.
Como le expliqué ya la semana anterior, señor Marrero, usted está aquí porque había un auto de detención emanado de la autoridad de Pensilvania por una incomparecencia ante una acusación de conducir bajo los efectos.
You have the right to contest your extradition back to Pennsylvania, or you can waive that right and agree to be voluntarily returned to that state.
Entonces usted tiene las dos opciones, o de disputa esa extradición y entra en litigio, o acepta que usted tiene ese caso pendiente y decide que acepte que lo transporten para Pensilvania.
No, yo no quiero que me transporte, yo me quiero ir yo mismo voluntariamente. Yo lo que quiero es que me pongan un bail bond aquí.
Yeah, I don't want to be transported there. I want to go willingly. All I want is to be able to post bond.
Well, this court has no control over the bond that was set in Pennsylvania, which is set, I believe it's the bond is set at 0 at this time, so it's you cannot post bond here in Florida. Mr. Leal, did you drop again?
Thanks. Your Honor, yes, interpreter. Again, the audio was lost. The interpreter is back. But you said Your Honor said that this court had no control over the bail from Pennsylvania, and that's where it stopped.
All right, and so you cannot post bond here in Florida.
Si este tribunal no tiene ningún control sobre la fianza que se dicte en Pensilvania, y por lo tanto no se puede postear aquí una fianza aquí en la Florida.
So So your choices at this time, unless something is worked out with the authorities in Pennsylvania, is to either contest extradition, which is fine, or agree to be returned to Pennsylvania.
Así que las alternativas que usted tiene de momento es o disputar la extradición o aceptar la extradición para que lo extraditen a Pensilvania.
No, yo no quiero aceptar la deportación, yo quiero yo irme yo voluntariamente, que mi hijo puso un abogado en Pensilvania y el abogado le dijo que yo podía poner un bail bond aquí.
No, I don't want to be extradited. What I want to do is I want to go willingly. I want to pay for my bond. My son already talked to an attorney, and the attorney said that I could pay bond here.
Mr. Romero, have you had a chance to look into this?
Judge Mendoza.
Mr.
It's okay.
Mendoza, I'm sorry.
Judge, actually, my office did. Unfortunately, we were having technical issues in the office. I couldn't do the video. I didn't have an interpreter. But prior to today, one of our PDs, I'm sorry.
Ya, desafortunadamente, su señoría, yo en mi oficina de la defensa no tuve oportunidad de ver el video ni tuve oportunidad de utilizar un intérprete previamente.
And that they explained waiver and extradition with him, and he understood, and that he would address the court next time he was in court, i.e. today.
Yo que le explicaría, él mismo iba a dar la explicación del tribunal una vez que ya había entendido en qué consistía la extradición, que ya había entendido.
All right, well, Mr. Marrero has appeared twice before the court, once before myself and once before Judge Karsten, and on neither occasion has he indicated a firm desire to waive his right to contest extradition.
Bien, señor Marrero, ya son 2 veces que usted ha comparecido ante el tribunal. La primera vez con mi persona, la otra vez con el juez Karsten. Y en ninguno de los casos se ha usted expresado a que está dispuesto a aceptar el derecho de exención de extradición.
So at this time, I'm going to set the case for an extradition hearing on,
Así que voy a fijar fecha para una audiencia de extradición
on August the 10th
para el 10 de agosto
at 8:30.
a las 8:30.
Mr. Mendoza, your office is appointed to represent him.
Yes, sir.
Y la defensoría lo va a representar.
And if you all reach a different resolution, whether he's able to have Pennsylvania release the hold based on the posting of a bond there, or in some other manner, we can cancel the hearing.
Of course.
Y estaríamos dispuestos a cancelar la audiencia si acaso la oficina de la Defensoría Pública llega a algún acuerdo o si se llega a algún acuerdo de que Pensilvania lo deje ir. Si hay un acuerdo, no se hará la audiencia del 10 de agosto.
So, Mr. Marrero, you are represented by the Office of the Public Defender in this case.
En este caso, señor Marrero, usted está bajo la representación de la Defensoría Pública.
A lawyer from that office will be in touch with you very shortly.
Y un abogado de esa oficina de la defensa se va a poner en contacto con usted en breve.
Your son can also contact that office.
Y su hijo también podría ponerse en contacto con la oficina de aquí de la Defensoría Pública.
We have a hearing set on August the 10th, unless the matter is resolved prior to that.
Así que queda señalada la fecha para la audiencia el 10 de agosto, a menos de que el caso se resuelva antes.
Thank you.
Gracias.
Judge, I did find information off of the York County website. Unfortunately, it did not say anything about a bond, but it did clarify what the charges were. It did not look like any of them were a felony.
Sí, ya se han aclarado los cargos, parece que no tiene ningún otro asunto pendiente.
Sorry, did you hear all of what he said, Mr. Leal?
Yes, Your Honor.
Okay. And did you interpret that for Mr. Marrero?
Yes, Your Honor.
That seemed pretty quick, okay. All right, well, your attorney will be in touch with you about the possibility of your release or conducting the hearing.
Así que su abogado, señor Barrero, va a estar en contacto en cuanto a la posibilidad de su liberación o de realizar la audiencia.
Thank you, sir.
Gracias, señor.
Yo no lo entendí, pero yo no lo entendí lo último que usted me dijo. Yo quiero que me hable poco a poco para yo poder entender.
I did not understand the last thing I was told. The interpreter could speak slower so I could understand.
Mr. Marrero, I have set your case for a hearing on August the 10th.
Así que para agosto 10, señor Marrero, se ha fijado fecha de audiencia
The Public Defender's Office is appointed to represent you in this case.
y la oficina de la Defensoría Pública ha sido designada para representarlo en su caso.
A lawyer from that office will be in touch with you shortly.
Un abogado de esa oficina estará en contacto con usted en breve.
That lawyer will explore whether there are options to release you from jail here before you are returned to Pennsylvania.
Y ese abogado explorará las posibilidades de que usted salga de la cárcel antes de que sea extraditado a Pensilvania.
It would be important for you to give that lawyer contact information for your son.
Va a ser muy importante que le dé a ese abogado la información para poderse poner en contacto con su hijo,
Because your son may have some very helpful information about what's going on in Pennsylvania.
porque su hijo puede que tenga información importante para ellos en relación a lo que está sucediendo en Pensilvania.
¿Y qué yo tengo que darle de mi hijo? ¿El nombre de él y la dirección o el número de teléfono?
And what should I give him about my son's contact information, his address and telephone number?
I will let you talk to your lawyer about that, but I would presume the telephone number would be the most helpful.
Bueno, voy a dejar que el abogado hable con usted de eso, pero supongo que sí, el teléfono de su hijo sería algo que sería muy valioso.
Thank you, sir.
Gracias, señor.
Thank you, Judge. May be excused.
Yes, thank you. Appreciate your assistance.
Oh, my pleasure.
All right. Does anyone else require the services of the Spanish language interpreter? If so, if you please come forward at this time.
Pase al frente a alguien que necesite los servicios del intérprete de español en este momento.
No, Your Honor.
All right. Thank you, Mr. Leal.
You're welcome, Your Honor.
Okay. Richard Dominic. State your name, please.
Richard Dominic.
Mr. Dominic, you were arrested on a warrant for battery. Your bond was set at 0. The court does note that you are presently out on release in case 20MM 819, but that that release occurred before the alleged date of this incident. Your bond is presently set at 0. Do we have any additional prior information, Mr. Dominic?
Judge, this defendant has criminal history going back to 1997, charged of burglary with assault, burglary of a dwelling, grand theft. We were not able to contact the victim today.
All right. Mr. Dominic, based on the charge in case 20MM 819, I'm not going to revoke your bond in that case. I'm going to set bond in case 20MM 1251, which is the new battery charge. That bond will be set at the amount of $500. That bond is conditioned upon you not having any contact, directly or indirectly, with Ashley Nicole Rodriguez, pending further order of the court. You will not go within 1,000 feet of Ms. Rodriguez's residential address or any place that you know her to be employed. You will not possess any weapons or firearms. The Public Defender's Office is appointed to represent you. If you feel that you should be allowed to have contact with Ms. Ms. Rodriguez, you can talk to your attorney, but even if she wants to have contact, you're not allowed to have contact unless the court modifies that order. And any contact, even with her consent, would be a violation of your bond, so it could result in you being back in jail with no bond. Your next court date will be,
Is still in jail July 23rd, if filed August 12th in courtroom 5B at 8:30 a.m.
August 12th?
I'm sorry?
Was that August 12th?
Yes, if you postpone, your next court date is August 12th. If you're unable to postpone, you'll be seen on July the 23rd.
Your Honor, may I postpone myself?
Yes, sir.
Okay, thank you.
Yes, sir. Thank you. Jesse Jennings. Good afternoon. State your name, sir.
Jesse Jennings?
Mr. Jennings, you've been arrested on a warrant for violation of probation in case 19 CF 4015 on a charge of felony battery. Your bond is set at 0. The public defender's office is appointed to represent you. Your next court date will be
On demand.
okay, but we do have a date for him. May 12th. I'm sorry. August 12th. So we don't have a date today.
We don't, I mean, I can reset him for the
15th of,
I can, 8:45 of this month.
so that's tomorrow?
Tomorrow, I can reset it for tomorrow.
Okay. So, Mr. Jennings, you'll be seen by Judge Karsten tomorrow at 8:30. Public Defender's Office has been appointed to represent you, a lawyer from that office. Maybe I'll get in touch with you this afternoon. If not, they'll speak to you in the morning. All right, thank you. John Morgan. State your name, sir.
John Morgan.
Your Honor, we'd like to waive reading in this one, please.
Excuse me?
Good name, sir. Mr. Morgan, you're arrested on warrant for violation of probation. Your attorney has waived the reading of the charges. Your bond is set at 0. Your next court date will be,
Next court date, July 22nd in courtroom 5A at 8:45 a.m.
you'll be seen July 22nd in courtroom 5A by Judge Wooten.
Judge who?
Wooten.
Okay, thank you.
All right, thank you. All right. Roberto Brigade. Good afternoon. State your name, sir.
Robert Brigade.
Oh, it's Robert? Okay. For some reason, they added an O on your name. Mr. Brigade, you arrested on several charges, possession of cocaine, possession of cocaine with intent to sell or deliver, trafficking in 28 grams or more of cocaine, keeping a structure for, or a vehicle for drug activity, and use or possession of paraphernalia to transport drugs. The court finds probable cause as to the possession of cocaine, possession with intent to deliver, and trafficking in cocaine. I don't find probable cause on the use or possession of drug paraphernalia for the purpose of transporting drugs or for keeping a vehicle for drug activity. Your bond on the possession of cocaine is set at $2,500. On the possession of cocaine with intent to sell or deliver, it's set at $7,500. The trafficking in cocaine is set at $50,000. Be released on your recognizance as the other two counts. The Office of the Public Defender is appointed to represent you. Your next court date will be on demand in circuit court, sir. Thank you.
Excuse me, Your Honor, what does that mean, my next court date will be on demand?
What that means is the arrest affidavit and other reports compiled by law enforcement will be forwarded to the state attorney's office. The state attorney will decide what formal charges, if any, to file against you. If they decide not to file charges, you'll be released. If they file charges, then your court date will be set, you'll be set for arraignment. If they don't file any charges within 30 days, you may be eligible for release on your recognizance. Your attorney will talk to you about that if that's appropriate.
Okay, and, do I still get to post bond?
Yes, you can post bond if you're able to.
And, what is the total amount?
Yeah, the total amount, clerk. It's 2,500, 10,000, 60,000. Total amount is $60,000.
60,000?
60, 60.
60,000.
60,000, correct.
So I'm paying 10% of that?
That's between you and the bondsman, but I'm told that's a typical arrangement.
All right, I swear I have one last question. When will I get to see a PD?
Someone from the Office of the Public Defender will be in touch with you shortly if you remain in jail. If you post bond, you'll need to make a contact with the Public Defender's office.
Understood. All right, and I have one more question. I don't know, I guess I'll just talk to my PD. I have a lot of questions. I don't want to take up
Right.
nobody's time.
Well, most of the questions you may have are ones I probably couldn't answer. Your attorney could help you with, but I can't give you any advice, so.
It was because I was looking at this paperwork, Your Honor, and the wording of the paperwork.
Right.
And a lot of the charges that they gave me, because they gave me a total of 7 of them. The improper change of lanes and failing to signal 100 feet prior. And I understand it's 50 feet and better, and I did do that, so I don't.
Well,
see why I got all these
those two charges are civil traffic infractions. You're not being held on those.
And what is the public nuisance, Your Honor?
I don't know what the public nuisance is.
Yeah, I have no idea what that is, so.
I didn't.
All right, thank you very much.
Thank you. Thank you, sir. Titus Tyrone Collier. Afternoon, state your name, sir.
Titus Tyrone Collier.
Mr. Collier, you're arrested on charges of battery, tampering with a witness in a third-degree felony proceeding, and false imprisonment. Excuse me, your bond is presently set at 0. Do we have any prior history on Mr.?
The defendant doesn't have any local history, but has history out of New Jersey, Nevada, and Arizona, charges of burglary, trespassing, aggravated assault, possession of weapon. He has 2 active warrants, one for Nevada, for a violation of probation, and one for New Jersey for a failure to appear, and there is a detainer in place for the aggravated assault out of Nevada.
I never had aggravated assault.
I'm sorry?
I never had aggravated assault in Nevada.
All right, well, that's a separate issue you'll have to address if and when you resolve the local charges. Apparently, they've lodged a detainer, and you may be able to resolve it earlier because it'll keep you in jail if you do post bond. I'm going to set bond in your case in the amount of $500 on the charge of battery, $1,000 on the tampering with a witness, and $2,500 on the false imprisonment.
All right.
If you do post bond, you will not have any contact directly or indirectly with Angeletta Marquetta Russell Williams, and you will not return to the area of 4984 Windermere Avenue in Kissimmee. You may do so on one occasion accompanied by a law enforcement officer to retrieve any clothing or personal possessions you have at that address.
Yeah, I do have all of my personal
All right.
items there.
You will not possess any weapons or firearms. Again, the Public Defender's Office is appointed to represent you. Your next court date will be on demand in circuit court.
Quick question, Your Honor.
Yes, sir.
Because I was charged with kidnapping and false imprisonment.
I'm
right?
sorry. Yes, okay.
Hello?
You're charged with kidnapping, false imprisonment, yes?
Yeah, how?
Okay, well, you can talk to your attorney about that. The court does find probable cause on the false imprisonment.
So you find probable cause?
I do, yes, sir.
What's the reason for that?
You'll have to talk to your attorney about that if there are issues, legal issues.
I got it. So how much would I have to pay on that bond?
Again, that's between you and the bondsman. All I can do is set the bond. You can pay that full amount in cash, or you can go through a bondsman. I don't know what a bondsman will charge you. Typically, it's 10%, but I don't know if that would be the situation in your case or not.
Okay, you said 1,500.
The total is $4,000.
Gotcha.
All right, thank you. Jaquez Malachi? State your name, please.
Jaquez Malachi.
Okay, Mr. Malachi, you're arrested on a charge of battery. Your bond is presently set at zero. The Public Defender's Office is appointed to represent you. I'm told there's a witness here, so we'll take some testimony before we decide what conditions of release to set in your case. All right, sir, if you want to come on up. Morning. Raise your right hand, please. You solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
What is your name, sir?
My name is Daniel Rosario.
Mr. Rosario, you are listed as the victim in the case involving Mr. Malachi, who was arrested on a charge of battery. The court is considering what conditions of release to set in this case. I'm interested in your input, so I have a couple of questions. First of all, are you afraid of Mr. Malachi?
I am.
Do you want to have contact with Mr. Malachi while this case is pending?
I don't mind this. Yeah.
I'm sorry?
Yeah.
You do want to have contact?
Yeah.
Okay. And do you have any objection to Mr. Malachi returning to the residence?
No. No objection.
All right. If something like this were to occur in the future, would you have any hesitation to call the police or law enforcement?
You mean like if something was to happen, if I'm going to call the police?
Right. If there were a situation in which you were a victim of a battery?
Yeah. I will call the cops. Yeah. Or if not, if it was to get like that, I'll just leave the situation. You know, as I was doing. You know, that's why I was driving my car to leave the situation.
There would be a contact, at least of no hostile contact between the two of you.
Yeah.
So if Mr. Malachi were to initiate a physical contact with you, would you contact the police if that were?
Yeah.
Any questions, Mr. Baird?
Nothing beyond what the court's inquired.
All right, do we have any prior history on Mr. Malachi?
No prior history, Judge.
All right, Mr. Malachi, I'm going to set bond in your case amount of $100. It will be conditioned upon you having no hostile contact with Daniel Rosario. And I'm also going to indicate no hostile contact to Amelia Berzwane. How do you pronounce that?
Berzano, I think.
Okay. I won't impose any, well, there'll be a condition, you not possessing any weapons or firearms. The Public Defender's Office is appointed to represent you in this case. Your next court date will be?
You're still in jail July 23rd, if out August 14th, in courtroom 4E at 11 a.m.
Judge, I don't know if
You want me to write that?
If I didn't, it will be conditioned upon supervision by pretrial release with the conditions as mentioned.
So, The $100, can I pay that on Friday? I only have like 70 right now.
You can pay it whenever you want, but until the bond is paid, he remains in jail, so.
Okay, so when I pay the bond, do I go to Osceola County Jail or do I come here?
The Osceola County Jail.
Osceola.
You can pay it in cash, or you may be able to, if you don't have the cash, you may be able to make arrangements with the bondsman.
All right, perfect.
Thank you. All right, thank you, sir.
All right, thank you.
Have a good day.
The next court date, is it okay if I could get like a letter or something? So I could...
You will receive information from pretrial release in writing with respect to the court dates. You're good to go. Thank you. All right, Juan Montserrat. State your name, sir.
Juan Montserrat.
Mr. Montserrat, you arrested on a charge of battery. Your bond was set at 0. Do we have any information regarding Mr. Montserrat?
The defendant has prior criminal history going back to 2005, failure to appears, aggravated battery on pregnant woman, battery, domestic battery by strangulation. Those charges were dropped. Most recently, in 2016, operating a motor vehicle license. We were not able to contact him.
And Your Honor, if I may, the 2016 CF 419, that was no information by the state. That was alleged to be the same victim as in the present case.
Okay. All right, Mr. Montserrat, I'm going to set bond in this case in the amount of $500. It is conditioned upon supervision by pretrial release. If you post bond, it will be a condition of your pretrial release and bond that you not have any contact until further order of the court with Ms. Jalice Ponciano. You will not return to the area of 2660 North Orange Blossom Trail, Lot 70. Again, until further order of the court, you may do so on one occasion accompanied by a law enforcement officer to retrieve any clothing or personal possessions you have at that address. You will not possess any weapons or firearms. You will not possess or consume any alcoholic beverages or a controlled substance without a valid prescription. The conditions can be modified by the court. The Public Defender's Office has been appointed to represent you. If you want to seek a modification, talk to your lawyer about that. But in the meantime, if you return or have contact without the court order being modified, that would violate your conditions of release and could result in you being held without bond pending resolution of your case. Your next court date will be?
Still in jail July 23rd, if filed August 14th in courtroom 4E at 2 p.m.
All right, thank you, sir.
Thank you.
David Sanders. State your name, please.
David Sanders.
Sanders, you arrested on a charge of domestic battery by strangulation. Your bond was set at 0. And I'm told there's or it's indicated there's an active warrant of some kind?
Yes, Judge. There's a detainer for Polk County, full extradition on battery by strangulation, no bond on that. It's a different victim also.
All right, Mr. Sanders, I'm going to set bond in this case, the amount of $2,500.
Your Honor, the state would like to be heard.
Yes, sir.
Your Honor, as the court just heard, there is a pending warrant for DV strangulation on a different victim out of Polk County. There was also a prior DV case out of, I believe it's this county, that was no billed against that same different DV victim. The defendant's criminal history includes case 5311 CF 9846, robbery with a firearm. The defendant has other smaller offenses, but I wanted the court to be aware of that.
Based on that information, I'm going to set bond the amount of $5,000. In this case, your bond will be conditioned upon you not having any contact directly or indirectly with Brenda contact with the victim in this case, and no return to the residence at 4547 Pleasant Hill Road in Kissimmee. Actually, I'd take that back. It'd be 1387 Burnley Court in Kissimmee. You may return on one occasion accompanied by a law enforcement officer to retrieve clothing or personal possessions. The Public Defender's Office is appointed to represent you. Your next court date is on demand in circuit court. Thank you, sir. Okay, it's to Marquise Williams. Are you waiving reading?
Marquise Williams? Yes, Your Honor.
Good afternoon. State your name, sir.
Keys Williams, Keys Williams, 0105-2001.
Okay. Mr. Williams, you were arrested, and do you know what the charge is against you, sir?
Yeah, yes, sir.
Okay. Your bond was set at $0. I'm going to set bond amount of $1,000. He does meet criteria for pretrial release supervision.
This charge is just,
I can't hear you, sir.
he doesn't have anything open.
I can't hear you.
Your bond is set at $1,000.
Okay.
It will be conditioned upon supervision by pretrial release.
Okay.
If you post bond, it's important that you get in full compliance with
Yes, sir.
registration requirements.
Absolutely.
The Public Defender's Office is appointed to represent you. Your next court date will be on demand in circuit court.
Hey, so I'm saying, so you said like a pretrial release, so I lead a late like that.
You need to do what? I'm sorry?
So
There's a bond and pretrial release.
so what that means? I don't know what.
So you have to post a bond, and you will be supervised by pretrial release if you do post bond.
So I talked to a deputy Kiefer, and she said that I should be on hard or something like that.
That's not the case right now. You can talk to your lawyer about that. That may be possible down the road, but right now, there's a bond with pretrial release. All right, thank you. All right, Andre Glenn. Good afternoon, Mr. Glenn. State your name, please.
Andre Glenn, sir.
Yeah, Mr. Glenn, you were seen, I believe yesterday by Judge Wooten, and he found probable cause as to 3 of the 4 charges against you, but not as to the corruption by threat by a public servant, corruption by threat of a public servant or family. Does the state have any additional information?
I forwarded it to the court this morning, forwarded to your JA.
Okay, I didn't see this. Take a moment. All right, well, based on the supplemental affidavit by Trooper Escobar, I do find there's probable cause as to count 1. He indicates what the nature of the alleged threat was. That's sufficient at this stage for finding a probable cause. So your bond is excuse me, is $2,000 for count 1, $2,500 for count 2, $1,000 for count 3, and $1,000 for count 4. So the total is $6,500. The Public Defender's Office is appointed to represent you. I realize they may represent the co-defendant. I don't know if you have a conflict at this time, do you know?
I'm not sure at this time, Your Honor.
Okay. Mr. Glenn, the Public Defender's Office will determine whether or not they have a conflict. If they do, I'll appoint another lawyer to represent you. Your next court date will be on demand in circuit court, sir.
So what is my total bond, sir?
Your total bond is $6,500.
Thank you.
Thank you. Okay. Let me read this for a moment before I proceed. This was the,
Your Honor, I do see that in the case we just heard with Mr. Glenn, that the co-defendant is set for initial appearance here in a few minutes.
okay. Thank you. All right, Orlando Rosario. Good afternoon, state your name, sir.
Orlando Rosario, sir.
Mr. Rosario, you are here again in case 20MM1657. You were seen yesterday by Judge Wooten, who found probable cause as to counts 2 and 3. The resisting without violence and allowing minor to consume alcohol at an open house party, but did not find probable cause as to receiving a person in the building for prostitution. The state has submitted some additional paperwork, and Mr. Baird, if you have any argument you wish to make.
Your Honor, it's not necessarily just prostitution under that statute. It's also lewdness. I believe under lewdness, the facts of the case are appropriate for a probable cause finding.
Well, it requires it to be obscene, I think. I'm not mis-
That's correct. Lewdness is defined by the statute as indecent or obscene.
Right. So what we have is allegedly dancers or strippers dancing, and the allegation is that, or at least as far as I could tell, they were allegedly wearing pasties and some other covering. Mr. Rosario, at this time, I'm going to continue the finding of no probable cause as to count 1.
Thank you, sir.
So be released on your recognizance as to that count. Your total bond is $1,000. Be aware, of course, that doesn't mean the state will not be charging you with that. You may still have that as a charge against you.
Yes, sir. Yeah, I asked to see
because they took my bond from my first charge I was at. I was gonna see if you can reinstate that.
I'm sorry, I'm having a hard time hearing you.
I was trying to see if you can reinstate the bond that they had took from me.
I'm not going to do that here today. You can talk to your attorney about that, all right? Your next court date will be,
You're still in jail July 23rd. If filed August 10th in courtroom 4A at 9:30 a.m.
thank you. This one, okay. Coratel Jones. All right, good afternoon, Mr. Jones. State your name, please. Ms. Jones, you're arrested on a warrant out of Orange County for a violation of probation on a charge of possession of a controlled substance. Your bond is set at 0. It's going to remain at 0 at this time. The Office of the Public Defender is appointed to represent you. Officer, did you have? Okay. I don't know if there'll be, I'm sorry?
They said I was supposed to get R&R because they ain't gonna transfer me to Orange County. My charges already got dropped.
Well, I don't have that information right now. If the charges in Orange County were dropped, you would be released on your cognizance.
No, the charges was in Osceola, but they dropped the charges in Osceola, so.
That doesn't necessarily mean the state will not go forward with the violation of probation based on those charges. The burden of proof is different. They can elect to proceed on the violation of probation even though the new criminal case was dropped. They very well may drop the violation of probation. I don't know. The Public Defender's Office is appointed to represent you. Excuse me, they have the ability to communicate with the Public Defender's Office in Orange County as well as the prosecutor to see if that will be the case. They can also file a bond motion down here or resolve your case.
She filed one on Sunday. I done been here for like 33 days already.
Right. Well, you can talk to your attorney about that. At this point, your bond is set at 0, sir. Thank you.
Your Honor, I'll have the other group up here as soon as possible.
Okay, that's fine. Thank you. I'm sorry? Well, I'll see what. Oh, yeah. All right, and Mr. Donnelly and Ms. Kohler, is Mr. McCullough going to be an admission this afternoon? Has that been worked out, or is that?
Yes, Your Honor, Melanie Kohler on behalf of Corey McCullough. He is prepared, Judge, to waive his right to a non-jury trial, and he will enact admission. We had further discussions with Mr. Donnelly yesterday, and what he had agreed upon was revoking his current supervision. He would be sentenced to 270 days jail with being awarded 210 days credit towards that jail
Okay,
sentence.
that's fine. Is that correct, Mr. Donnelly?
Yes, Judge. I don't know if the clerk has an updated credit time served.
Sorry? She's telling me 253.
Judge, the overall.
If you all want to stipulate to 210 days as what he's to get credit for, that's fine. He can waive credit to some or all of the days that he's entitled to. Or if you want to agree on, I know the intent was that he serve essentially an additional 60 days. Or what is the credit from the time he is arrested on the violation of probation? Do we know that? Okay, so he's got 30 days credit from the time he was arrested on the violation of probation, according to the clerk. So I don't know how you all want to proceed. He's not present yet.
I will defer to Mr. Donnelly Kelly on this one. I mean, if he wants to sentence him to 90 with 30 days credit from the time in and just waive the previous credit, that's fine.
That may be the simplest way.
I think that is the simplest way, Judge. If we could do it that way,
That's fine. All right, that's fine. We've still got some initial appearances to deal with, so unfortunately, you'll be waiting a little bit, but it shouldn't be too long. We're still waiting on the next group of IAs to be brought up, though, so.
That's fine, Judge.
In fact, we could probably do that one first, since we have a clerk who's here just for that case, right? Okay. So when we get the people in, as soon as we get Mr. McCullough, we'll go and do his case.
Thank you, Your Honor.
All right, do we have Mr. McCullough? Ja'Cory McCullough? Not yet.
We're
I
ready
can't-
with the females, Your Honor.
Okay. I guess we'll go ahead and start with them, and when we get the males brought up, we'll. Okay. Brittany Carroll? Come on up, please. Okay. Good afternoon, Ms. Carroll. If you'll state your name, please.
Brittany Carroll.
All right, Ms. Carroll, for you and as well as the other young ladies who are present, you're here for your initial appearance.
I don't know. What am I doing wrong? Okay.
I've reviewed the arrest affidavits, and unless I indicate otherwise, when your case is called, I do find there is probable cause to believe that you committed the offenses for which you've been arrested based on those affidavits. Unless you tell me that you are represented by a lawyer that you've privately retained, I will be appointing the Office of the Public Defender to represent each one of you here this afternoon. Now, you do have the right to remain silent. You don't have to say anything about the facts of your case. I'm not going to be asking you anything about the facts of your case today. If you do say anything about the facts of your case to any person other than your lawyer at any time, it could be used against you later at trial if your case does go to trial. So it's likely in your best interest not to discuss the facts of your case with anyone other than your lawyer. You also have the right to make a phone call to someone outside the jail. If you've not yet been allowed that opportunity, let me know. I'll ask the jail staff to assist you. Ms. Carroll, you arrested on charges of petty theft and resisting merchandise recovery. I do find probable cause as to each of those offenses. Your bond was set at $250 on the petty theft. I'm going to increase that to $1,000. It is set at $500 on the resisting merchandise recovery. It appears that you are presently out on bond in Orange County case. Is that Orange County? Yes.
That's correct, Judge.
20 CF 8168 for 3 counts of petty theft with prior theft conviction. Based on this arrest, I'm going to revoke and discharge your bond in that case and order that you be held without bond pending further order of the court in that case. Your next court date in this case will be,
Still in jail, July 23rd. If out, August 12th in courtroom 5B at 8:30 a.m.
thank you. Okay. Erica Ortiz Colon. State your name, please.
Erica Ortiz Colon.
Ms. Colon, you were arrested for driving while license revoked as an habitual offender, or as a second or subsequent offender. Resisting arrest without violence and violation of probation on a charge of driving while license suspended as a subsequent offender in case 19 MM 1866. Your bond is presently set at $2,500 for the driving while license suspended as a second or subsequent offender. The court does not find probable cause as to that count at this time. There's an indication that she was sitting in the driver's seat, but not that she had the ability to operate the vehicle.
I believe, Your Honor, she made an admission that she was in actual control of the vehicle.
She said she was in control, but that's a legal term that means different things to different folks. If she had the keys in the ignition or if the car was running, I would have no problem finding probable cause, but at this point,
Your Honor, I'll ask for 24 hours.
yes, I'll give you 24 hours to submit a supplemental affidavit if you wish to do so. The bond will remain at $2,500 pending. That will reset your case for tomorrow. We're finding a probable cause as to that. I do find probable cause as to resisting arrest without violence. Your bond is set at $500 on that charge. Your bond on the violation of probation is set at $0. It'll remain at $0 at this time. And I'm not going to take action today in case the Orange County traffic case that you are out on bond for, but that can be revisited tomorrow by Judge Wooten when he addresses probable cause on the driving license suspended here. The Public Defender's Office, again, is appointed to represent you. At this time, your next court date we'll be seeing you tomorrow, but following that, your next court date on the driving license suspended, on all the charges would be what?
Next court date for 2020, MM 1673 is still in jail, July 23rd. It's out August 14th in court 4E at 2:30 p.m. And for 2019, MM 1866, next court date, July 23rd, 4E at 8:05 a.m.
Thank you.
Thank you.
Angela Reed? State your name, please.
Angela Michelle Reed.
Ms. Reed, you're arrested on a charge of aggravated assault and battery. Your bond is presently set at $0. We have prior history on Ms.
She
Reed.
has no prior criminal history, and the victim is requesting non-hostile contact.
Indicate the victim
Which
moved
victim?
out of the residence.
I'm
It's indicated here the victim has moved out of the residence.
We have a residence of 1007 11th Street.
No, I'm saying on your information sheet, you say the victim
Oh,
has
that's
moved out of the
correct, yes.
residence.
That's the information that the victim gives.
Your Honor, if the state may inquire of corrections, which victim is corrections referring to? There's two separate victims here.
Right, I assume it's the domestic.
Spoke with Daniel B.
Right. All right, Ms. Reed, I'm going to set bond on the aggravated assault in the amount of $2,500. Bond on the battery charge will be set at $100. The bond will be conditioned upon supervision by pretrial release. If you do postpone, it'll be a condition you not have any contact directly or indirectly with Leanna Howe or Ho. It will be a condition that you not have any hostile contact with Mr. Daniel Beam. You will not possess any weapons or firearms of any kind. You will not possess or consume any controlled substance without a valid prescription or any alcoholic beverages at all. Public Defender's Office is appointed to represent you. Your next court, yes.
Your Honor, the arrest affidavit indicates that alcohol is not a factor. Doesn't mention alcohol.
I'll delete the no alcohol. Your next court date will be on demand in circuit court. Thank you. Clarissa Washington? Okay. Good afternoon. Please tell us your name.
Clarissa Washington.
All right, Ms. Washington, you're arrested on a charge of battery. Your bond was set at $0. There's apparently a witness here who wants to provide some testimony, so we'll take that and then we'll consider conditions of release. So we'll be at ease for just a moment. While that's happening, do we have any? No prior history? Okay, excellent. If you'll come on up, please. Raise your right hand, sir. Do you solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? State your name, sir. All right, Mr. Keller, you are listed as the victim in the case involving Ms. Washington. I'm at this time considering conditions of release to impose in this case, so I have a couple of questions to ask you. First of all, do you wish to have contact with Ms. Washington while this case is pending?
Yeah.
Are you afraid of her at all? Okay. If anything like this were to occur in the future, would you hesitate to contact law enforcement? Sorry?
Sir.
Okay. Thank you. Any questions, Mr. Baird?
Nothing beyond the court's inquiry.
All right. Well, Ms. Washington, the charge against you is not one for which the court can release you directly on pretrial release. So I'm going to set bond in the amount of $100. That bond will be conditioned upon you not having any hostile contact with Mr. Antonio Keller. There's no pushing, no shoving, no fighting, no biting, no striking with brooms or fishing poles or anything of that nature. There won't be any other restrictions imposed. The Office of the Public Defender is appointed to represent you. Your next court date will be,
You're still in jail July 23rd, and file August 10th in courtroom 4A at 10 a.m.
so pretrial release will have those dates, and they'll give you that in writing before you are released from jail if the bond is posted. All right? Thank you. Thank you, Mr. Keller. Okay. You say Ms. Sanchez Santana requires the interpreter? Okay. Glennie Sanchez Santana. Excuse me.
Good afternoon, Your Honor. This is Carlos Morales, State Certified Spanish Court Interpreter. Interpreter has been sworn in already today.
All right, good afternoon, Ms. Morales. We are here for initial appearance in case 20MM1675, State versus Glennie Sanchez Santana. And Ms. Sanchez Santana does not have the headset on, of course. If you'll please tell us your name, ma'am.
Señora, su nombre, por favor.
Glenny Sanchez Santana.
Ms. Sanchez Santana, you were arrested on a charge of battery.
Señora Sánchez Santana, usted fue arrestada por una acusación de agresión.
Your bond is presently set at $0.
Actualmente, o hasta el momento, no se le ha asignado ninguna fianza.
The Public Defender's Office is appointed to represent you in this case.
Y se han nombrado los defensores públicos para que la representen en este caso.
The court is going to be considering conditions of release.
El juez va a pasar a contemplar si se pueden imponer algunas condiciones sobre su libertad.
And we have here, is this Mr. Colon?
Yes, sir.
Do you need the interpreter, sir?
Well, some words sometimes, but I'll let you know.
Well, we have the interpreter online, so if you'd be more comfortable with the interpreter.
Okay, just in case, okay.
All right, Mr. Colon, please raise your right hand. You solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
And Mr. Morales, if you could go ahead and interpret for us, please.
Yes, sir.
Mr. Colon, if you'll state your name.
Say what?
Señor Colón, díganos su nombre, por favor.
Oh, Anthony. Colon.
I'm sorry, Your Honor, is the witness in front of a microphone? Because the interpreter
And
can't
if you'll
hear.
try to speak up as best you can.
Anthony Colon.
Anthony Colón.
Mr. Colon, you are named as the victim in the case involving Ms. Sanchez Santana.
Señor Colón, usted ha sido nombrado como la víctima en el caso en contra de la señora Sánchez Santana.
Before I set conditions of release, I'm interested in some information from you.
Yes, sir.
Y antes de que yo pase a imponer algunas condiciones sobre la libertad de ella, me gustaría recibir alguna información de usted.
And I know you seem to speak English fairly well, but even if you understand what I'm saying, I would ask that you wait for the interpreter to interpret before you answer. I would ask you to go ahead and answer in Spanish, just so it's more clear on the record.
Y señor Colón, aunque usted Bueno, por lo que puedo ver, usted entiende, parece que entiende bien el inglés, pero aún así le pediría que por favor usted espere a que se le dé la interpretación del inglés al español, espera a escuchar la pregunta, luego conteste en español y el intérprete lo interpretará del español al inglés.
Está muy bien.
Very well.
My first question, Mr. Colon, is do you wish to have contact with Ms. Sanchez Santana while this case is pending?
Mi primera pregunta para usted, señor Colón, es, ¿desea usted tener contacto con la señora Sánchez Santana mientras este caso esté pendiente?
Sí.
Yes.
Are you afraid of Ms. Sanchez Santana?
¿Usted le tiene miedo a la señora Sánchez Santana?
No.
No.
If something like this were to occur in the future, would you hesitate to contact law enforcement?
Si algo como esto volviese a suceder en el futuro, ¿dudaría usted en llamar a la policía?
Sí.
¿Perdón?
Sí.
Yes.
So you would not contact law enforcement or you would contact law enforcement?
Entonces, ¿usted no llamaría a la policía o sí llamaría a la policía?
Sí, llamaría.
I would call.
Okay, very good. Any prior history?
No prior criminal history.
All right, Ms. Sanchez Santana, your charge does not qualify for a direct release on pretrial release.
Señora Santana, por la acusación que hay en contra de usted, no reúne los requisitos para poder salir únicamente bajo el Departamento de Libertad Provisional.
So I will be setting bond in the amount of $100.
Así que vamos a pasar a imponerle o asignarle una fianza de $100.
That will be conditioned upon supervision by pretrial release if you do post bond.
Sin embargo, si es que usted logra salir depositando, pagando esa fianza, la condición es de que el Departamento de Libertad Provisional la supervisen a usted.
It will be further conditioned upon you not having any hostile contact with Anthony Colon.
Además de eso, también habrá otra condición, que le estará prohibido cualquier trato hostil o de naturaleza o de manera hostil por parte suya hacia Anthony Colón.
So if the two of you are not getting along, it would probably be in your best interest to leave the area before any dispute escalates.
Así que si surge el caso o en algún dado caso de que ustedes no se están llevando bien, pues entonces lo que más le convendría a usted es irse o alejarse del lugar antes de que cualquier discusión o disputa se llegue a empeorar o agravar.
It will also be a condition of your pretrial release and bond that you not possess or consume any alcoholic beverages.
Además, como una condición tanto de su fianza como de su supervisión por el Departamento de Libertad Provisional, es que le está prohibido el poseer o consumir alcohol.
Again, the Public Defender's Office is appointed to represent you.
Además, se le está nombrando a los defensores públicos para que la representen.
I would suggest that you contact that office as soon as possible if you are released from jail.
I'm so sorry, Andrew, your voice trailed off at
I
the
would
end.
suggest that you contact that office as soon as possible if you are released from jail.
Y mi sugerencia para usted es que tan pronto usted salga de la cárcel, que usted se comunique con la oficina de ellos.
Your next court date will be
They're still in jail July 23rd, if filed August 10th in courtroom 4A at 10 a.m.
Si la próxima vista que usted tiene, si todavía está en la cárcel, sería el 23 de julio. Ahora, si ha salido, entonces la próxima vista sería el 10 de agosto en la sala 4A a las 10 de la mañana.
Yes, sir, Mr. Colon.
Sorry, sir.
Señor Colón.
I thought, I mean, by releasing her, can it be sooner than that, or can we just close the case? Because I'm not interested in like
All right. Well, whether or not the case is formally charged and proceeded on will be a decision for the Office of the State Attorney to make. Mr. Morales.
Bueno, quienes toman la decisión de radicar cargos formales le corresponde a la Fiscalía.
in making that decision, they will be interested in, but not bound by your wishes in the matter.
Al llegar a tomar una decisión, ellos van a tomar interés en lo que usted opina, pero no están obligados a tener que seguir sus deseos.
So if you do not want to proceed with formal charges, I would suggest you contact the Office of the State Attorney.
Así que si usted no quiere continuar con la denuncia o que se radiquen cargos, debe comunicarse con la fiscalía.
If you ask to speak to a victim advocate, they can take that information from you.
Y usted pide hablar con uno de los ayudantes o asistentes a las víctimas y ellos pueden tomar su información
And advise you of your options.
e informarle sobre cuáles son sus opciones.
You also have the right to speak to the defense attorney, although you're not required to do so.
Además, usted tiene el derecho de consultar con un abogado defensor, aunque no está obligado a hacerlo.
Ms. Sanchez Santana will have information about how to contact the Office of the Public Defender.
I'm sorry, what was that last part?
Ms. Sanchez Santana will have information on how to contact the Office of the Public Defender.
A la señora Sánchez Santana se le va a dar la información para que ella se pueda comunicar con la Oficina de los Defensores Públicos.
And she can put you in touch with her attorney or relay to her attorney what your desires are.
Y ella puede ponerlo en comunicación a usted con el abogado de ella o comunicarle al abogado de ella cuáles son sus deseos.
Thank you, sir.
Muy bien, gracias, señor.
Thank you, Ms. Sanchez.
Gracias, señora Sánchez.
Does anyone else require the interpreter? If so, please come on up. No one? All right, thank you, Mr. Morales.
You're welcome.
Okay, do we have Mr. McCullough yet?
Your Honor, we do have one that needs an interpreter. It's Mr. Bosch.
Okay. All right.
Good afternoon, Your Honor. This is Carlos Morales, State Certified Spanish Court Interpreter.
All right, welcome back, Mr. Morales. Apparently, I missed one. So this will be case 20 CF 1968, State versus Giovanni Bosch Ojeda.
Yes, sir.
Okay.
Your Honor, defense would like to waive reading here.
Sorry?
We'd like to waive reading on this case.
Please tell us your name, sir.
¿Cómo se llama usted?
Giovanni Bosch Ojeda.
Giovanni Bosch Ojeda.
Mr. Bosch Ojeda, your lawyer has waived the reading of the charges against you in this case.
Señor Bosch Ojeda, su abogado ha pedido que no se lean los cargos que se han radicado en su contra.
Your bond is presently set at $0.
Actualmente o en este momento no se le ha asignado ninguna fianza.
Does pretrial release have any information on Mr. Bosch Ojeda?
Defendant has prior arrest in 2019, petty theft, trespassing, brand handling, violation of a municipal ordinance, and out of Georgia in 2018, possession of marijuana. That's all.
All right, based on the facts in this case, the court is going to set bond in the amount of $2,000.
Muy bien, basado en los detalles de este caso, la fianza que el juez le va a asignar es de $2,000.
It will be conditioned upon you not returning to the property of the Kissimmee Civic Center.
Y una de las condiciones es que le estará prohibido regresar al centro cívico de Kissimmee.
It will be conditioned upon you not having any contact directly or indirectly with Jennison Ribeiro.
Además, otra condición es que le está prohibido el contacto directo o indirecto con Jennison Rivero
or Lillian Stuckey.
o tampoco con Lillian Stuckey.
The Public Defender's Office is appointed to represent you.
Se han nombrado los defensores públicos para que lo representen.
The next court date will be on demand in circuit court.
La próxima vista todavía no se ha determinado y se anunciará cuando se sepa.
Thank you, sir.
Gracias.
Thank you, sir.
All right, I believe that's all, Mr. Morales. We have anyone else? All right, thank you again.
Okay, you're welcome. Thank you.
All right, do we have Crystal Soto? Not yet. All right, good afternoon. Please tell us your name. I'm sorry? All right, Ms. Soto, you're arrested on charges of possession of cocaine, possession of cocaine with intent to sell or deliver, trafficking cocaine, possessing a vehicle for use. This says to sell obscene material, but I think it was, yeah, it is. And possession of drug paraphernalia for the purpose of transporting drugs. Yesterday, you were seen by Judge Wooten, who found no probable cause at that time, gave the state 24 hours to provide some additional information. The state has provided additional reports. Let me view those quickly here. All right. Ms. Soto, based on the report from Trooper Wademan, which has been provided by the state, the court does find probable cause as to counts 1, 2, and 3, the possession of cocaine with intent to sell or deliver, and trafficking in cocaine. And I believe there's a Scrivener's error, but in any event, your bond is set at $2,500 for possession of cocaine, $7,500 for the possession with intent to sell or deliver, and $50,000 for the trafficking. For some reason, that was listed as $5,000 yesterday, but it says stayed. I know originally it was $50,000, and of course, saying it $50,000. As to counts 3 and 4, you'll be released on your recognizance. The court finds no probable cause as to those 2 counts.
I believe the court said 3 and 4, just now the court mean 4 and 5.
You are absolutely correct. Counts 4 and 5. The Office of the Public Defender is appointed to represent you. Are you in a position to announce a conflict or?
Yes, Your Honor. This case is the same as the we talked about earlier.
Ms. Soto, the Office of the Public Defender represents your co-defendant, so they have a conflict in representing you. We'll find that to be the case and grant what I guess is the oral motion to withdraw.
Yes, Your Honor.
And I will appoint the Office of Regional Conflict Counsel to represent you in this case. A lawyer from that office should be in touch with you very shortly. Your next court date will be on demand in circuit court. Thank you. All right, do we have either Mr. Miller or Mr. McCullough?
Ms. Miller, Your Honor.
Or Ms., I'm sorry. Good afternoon, Ms. Miller. State your name.
Makoya Miller.
All right, Ms. Miller, you arrested for disorderly conduct and refusal to obey the lawful command of a law enforcement officer. I don't find unless I'm reading the wrong report. Are you also known as McCoya Deshay?
Yes.
Okay. And which is it Miss Deshay or Miss Miller?
It's Makoya Deshay Miller.
Okay, I got you. Fair enough. Ms. Deshay Miller, I don't find probable cause on the charge of disorderly conduct. I don't know if the state wants 24 hours to file an amended or a supplemental affidavit or whether.
I believe that we had all the supplements that we're going to get as to the co-defendant, so I don't believe there's going to be any additional evidence beyond that, Your Honor.
So, Ms. Deshay Miller,
Yes.
you'll be released on your recognizance on the charge of brawling or fighting or disorderly conduct. You do have a bond of $500 on refusal to obey the lawful command of a law enforcement officer.
Yes, she qualifies for direct PTR. I don't know if you will release her on direct PTR on count 2.
She lives in North Carolina, is that?
That is okay.
All right. Yeah, based on these charges, I'll release you on pretrial release. To be let out of jail, you are, again, released on pretrial release. The Public Defender's Office is appointed to represent you.
Yes, Your Honor. We also represent the co-defendant in this case from earlier we just talked about.
Are you moving to withdraw?
Yes, sir. Your Honor, motion.
Grant the motion to withdraw and appoint, the Public Defender's Office represents the co-defendant, Mr. Shard or Mr. Glenn. So I'll appoint the Office of Regional Conflict Counsel to represent you. Your next court date will be
Next court date for 2020, CT 1713, August 14th in courtroom 4E at 2 p.m. And for 2020, MM 1671, next court date, August 14th in courtroom 4E at 2 p.m.
Your next court date is August 14th.
Okay, thank you, Your Honor.
The pretrial release folks will have that information for you. You can talk to your lawyer. Your lawyer may be able to waive your physical presence at that next court date. Are you living in North Carolina right now?
Yes.
Okay. So you can return home and come back for your court dates as required.
Okay, I will.
All right. Thank you.
Your Honor, your afternoon court doc will be up in just a minute.
All right. Thank you.
Thank you.
I grant the oral motion to withdraw from the public defender and appointed regional conflict counsel. All right, so they're bringing up Mr. McCullough, so appreciate your patience.
Judge, what case number are we waiting for?
Sorry?
What case number is being brought up?
Mr. Donnelly's on the line. It's-
Oh, okay.
I think
or he
IAs
was.
are finished though, correct, Your Honor?
Sorry, yeah, we're through with the PD. Mr. Donnelly was with us. He's dropped off, it looks like. It's case 17 CF 435, State versus Ja'Cory McCullough. This is agreed upon downward departure with a revoke and terminate sentence of 90 days, agreed upon credit for 30 days. Based on the BOP, all prior to be waived. Oh, yeah, he's back. Okay, thank you. So Mr. Donnelly is back. Mr. Baird. You are?
I think with that,
May we be
I'd be excused.
Absolutely.
Likewise, Your Honor.
Have a good
Thank
day.
you.
All right, sorry, folks, for the wait. They've gone to get Mr. McCullough. He's our last customer, so. There he is. All right, good afternoon, Mr. McCullough. If you'll please raise your right hand. Do you solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, nothing but the truth? The microphone seems to be off.
Sorry, Your Honor.
That's
Yes,
right.
sir.
Okay. Please state your name.
Ja'Cory McCullough.
Okay, Mr. McCullough, you are here again today in case 17 CF 435. And as yesterday or the day before, which I can't recall, I guess it was yesterday, because that was Monday. As with yesterday, your attorney, Ms. Kohler, is on the line with me. I can see her. She can hear you, but you can't see her. And the state is on the line as well. Ms. McCullough, you were placed on probation in this case for burglary of a dwelling in count 1, grand theft of a firearm in count 2, and grand theft of a firearm in count 3. Do you understand?
Yes, sir.
The burglary charge is a second-degree felony, which is punishable by up to 15 years state prison, up to 15 years probation, and/or a fine of up to $10,000. Each of the grand theft charges are third-degree felonies, which are punishable by up to 5 years state prison, up to 5 years probation, and/or fines of up to $5,000. Do you understand?
Yes, sir.
All right, and again, you were accused of violating your probation. It is alleged that you violated Condition 5 by committing the offense of driving without a valid driver's license on or about April 17th of 2020 in Marion County, Florida. Do you understand?
Yes, sir.
If you admit that you willfully violated your probation can be revoked and terminated. You could be sentenced to anything up to the legal maximum, which would be up to 25 years state prison. Do you understand?
Yes, sir.
And do you wish to admit that you violated your probation as alleged?
Yes, sir.
Very well. And yesterday, we discussed that you had discussed your rights in this case with Ms. Kohler. Is that correct?
Yes, sir.
And do you fully understand your rights?
Yes, sir.
Are you currently under the influence of any medication or other drugs or alcohol?
No, sir.
Are you thinking clearly at this time?
Yes, sir.
Has any person coerced or forced you to enter the admission?
No, sir.
Okay. I had some discussion with your attorney and the prosecutor while we were waiting for you to be brought up. And there's been as you will recall, there's been some question as to how much credit you actually have for time served. And the attorneys have agreed that if you enter the admission, they will recommend that the court sentence you to 90 days in the county jail with credit for the 30 days that you've already served since your arrest on the violation of probation All other credit for time served would be waived, and this would be a downward departure sentence agreed to by the state. Do you understand that?
Yes, sir.
And do you wish to proceed with the admission with that understanding?
Yes, sir.
You have the right to have a hearing to determine whether the state can prove that you did willfully violate your probation in this case. And if you chose to go to hearing, you could not be found guilty of any violation unless the state proved by the greater weight of the evidence that you did in fact violate your probation as charged. Do you understand?
Yes, sir.
You would have the right to be represented throughout your hearing by Ms. Kohler, and you would have the right to confront and cross-examine any witnesses who testified against you at the hearing. Do you understand?
Yes, sir.
Excuse me. You also would have the right to present witnesses and evidence in your defense at your hearing. And you have the right to have the court order any witnesses you have to be present at the hearing so you can present their testimony. Do you understand?
Yes, sir.
You further would have the right to testify yourself at the hearing. Since the only allegation is that you committed a new crime while on probation, you could also choose not to testify. If you chose not to testify, the court would not hold your decision not to testify against you or consider that as proof of guilt. Do you understand?
Yes, sir.
By entering an admission here this afternoon, you're giving up all the rights we've discussed, and there will not be any further hearing in your case other than a sentencing hearing, which we will conduct this afternoon. Do you understand?
Yes, sir.
You also, by entering the admission, are waiving your right to appeal any matters relating to your case other than this court's jurisdiction to hear the case and the legality of the sentence imposed. Do you understand?
Yes, sir.
All right, do you have any questions about your rights or about this plea?
No, sir.
Very well, Mr. McCullough, I find that you are alert and intelligent, that you understand the nature of the allegations against you, you understand the penalties that you're facing, as well as the rights that you're giving up by entering the admission. And I find that your decision to enter the admission has been freely and voluntarily made, and that you've had the advice of a competent lawyer with whom you've told me you're satisfied. So I'll accept the admission in violation of probation. Ms. Kohler, is there any objection to the score sheet with 99.4 total sentence points?
No, Your Honor.
And Mr. Donnelly, you are recommending a downward departure sentence, is that correct?
Yes, Judge.
All right. Is there anything further then with respect to sentence?
Nothing.
Okay. All right, Mr. McCullough, I will follow the recommended disposition. I'm going to revoke and terminate your probation in this case. As to each count, counts 1, 2, and 3, you'll be sentenced to 90 days in the Osceola County Jail with credit for 30 days that you have already served from the date of your arrest on the violation of probation. Those sentences will run concurrent with each other. You are ordered to pay the outstanding financial obligations of $1,065.89. Now, when you get out, do you know how you're going to be supporting yourself?
Yes, sir.
Do you have a job? Are you going to have to find a job, or?
I have a job. I've been working at FedEx for almost a year.
Okay, excellent. I'm going to order that you pay the money that's owed through the clerk's collection program at the rate of no less than $50 every month. I'll go ahead and give you until February 1st of 2021 to make your first payment. So that'll give you plenty of time to get out and get back on your feet. You can pay ahead of time if you wish, but at least by February 1st, you need to pay $50.
Can I pay it all at one time?
Absolutely. As soon as you pay all the money off, the case is closed. If you do decide to make the monthly payments, it's important that you make those payments on time. If you do not make the payments on time, the clerk will do two things. They will direct that your driving privileges be suspended, and they'll also refer the matter to a collection agency, and they start charging interest, and the amount balloons really quickly once that starts happening.
Okay.
So if you're having financial difficulty, it's important that you get in touch with the clerk. They can work with you on that, but don't just disregard it, or it'll cause you a lot more headaches. Payments need to be made to the clerk on the second floor of the Osceola County Courthouse. You can make those payments in person, you can pay online, or you can pay by mail. And again, if you wish to pay the money all off at once, that's fine. Once you've paid the money, your case is absolutely closed. You do have 30 days within which you can appeal the judgment and sentence which just entered in your case. If you wish to appeal and you are unable to afford to hire a lawyer, I will appoint one to represent you. If you do not file an appeal in writing within 30 days of today's date, you waive your right to appeal. Do you understand, sir?
Yes, sir.
All right. Thank you, sir. Good luck to you.
Thank you.
Thank you. Thank you, Counselor. Again, appreciate your patience. Didn't think you'd be holding on this long, but have a good afternoon.